Smoking tires.
Okay, we're hot.
Yeah, I have.
We're hot, she said?
We're live, hot.
I know, I heard. She said hot.
But this is,
Good morning, this is the New York City Board of Standards and Appeals public hearing for April 23rd, 2019. We'll begin with the appeals calendar. Item number 1, continued hearing, 2017-310A, 1002 Farragut Road, Brooklyn.
This is DOB show? DOB 1, 2. Come up.
I mean, normally in the appeal, the
You want
opponent
to
speaks.
state, you want to, oh,
Oh, we called the DOB's case.
this is DOB.
The CO revocation, so I think we're in the same place that we were last time, which is
Okay.
where...
Introduce your same for the name.
Sure, sorry. Tim McKernan for the Department of Buildings. With respect to the CO revocation application, I think we're in the same place that we were, which is we're willing to essentially defer it, which I think just means adjourn it in sequence with the appeal that owner has filed. And I think that's okay with the owner's attorney.
Okay, so we won't set a date until we're after the next
Okay.
one, right? Okay.
Okay, item number 2, new cases, 2019-45A, 1002 Farragut Road, Brooklyn. Please state your name for the record.
Good morning, Chair Perlmutter, Commissioners. My name is Ken Fisher. I'm a member of the law firm of Cozen O'Connor on behalf of the owner of the premises. And just for the record, we agree with the Chair's suggestion, DOB's suggestion. The other case, I think, really follows this one, and we're not pursuing the notion that this should be treated as an accessory use. We're dealing with the primary use. The core question on this appeal is whether the use of 1,274 square feet of the premises on Farragut Road are properly categorized as use group 18, industrial facilities which either involve considerable danger of fire, explosion, or other hazards to the public health or safety, or cannot be designed without appreciable expense to conform to high-performance standards with respect to emissions of objectionable influences. That's reading from the zoning resolution. And normally generate a great deal of traffic, both pedestrian and freight, or use group 16, basically automotive and other necessary semi-industrial uses that are required widely throughout the city and have some objectionable influences incompatible with residential and commercial zones. So regulated medical waste transfer station or some other use group 16D category that it involves regulated medical waste is not described in the zoning resolution, as we already discussed yesterday, neither are solid waste transfer stations. So the question is it more like one or the other? And in this context, I want to join with the Department of Buildings, and maybe the only thing we agree on, in referencing Board Case 74-93A, which they cite on page 9 of their April 9th, 2019 submission, that, and I quote, "The zoning resolution should allow the locations of all legitimate uses in a way that best reflects the reality of the marketplace and affords the appropriate protection to the surrounding area." So I'm going to first turn to a couple of the DOB points that I don't think require a tremendous amount of discussion, beginning with the question of whether or not the product that's moved in on smaller trucks, loaded onto bigger trucks, and taken out again constitutes freight. And the DOB relies on dictionary definitions, including the fact that the Blackstone definition, which they cite in their brief, basically says it's moving something from one place to another. There is some case law on this point, which I apologize, I thought I had at the top of the pile, but basically, I can provide the citations in a second, but basically the case law from the Second Circuit, 1911, and I believe there are some New York City court cases both point out, and I didn't know this before, freight, the noun, originally meant the charge for moving someplace from one place to another, as pay the freight, that phrase. And then what it's said, what the cases say is from the time that we were moving goods by covered wagon, freight has always been understood to be something you move from one place to another for compensation. And as the chair pointed out yesterday, we're no longer in an era where one person's trash is never one person's treasure, and that waste materials of various kinds are transported around the country for various reasons, and I don't think there's need for much more definition. Just to provide the cases for you that I was referencing, Triway Co. versus Tepper, 88 New York State 2nd 50 at page 52 to 53, says the word freight has been used from earliest times to mean the property or commodity which is carried, whether it was that which was carried in times past in Conestoga wagons drawn by ox teams across the plains, or whether it was carried upon canal boats or is carried today by airplane or truck, as well as rail. And that's in accord with the Second Circuit case, the Nassau 188 F 46 at 48, Second Circuit 1911. By the way,
Sorry,
Read that
you're going so
citation one
fast,
more
yeah.
time.
okay, I'll do it more slowly, thank you. The Nassau is the name of the case. It's 188 F 188 F 46 at page 48. It's the Second Circuit, 1911. Both of those were interpreting what the word freight meant in the context of charge or goods, but both of them are pretty
You do the
clear.
same with your 88 New York State 2nd,
Sure.
whatever that
Yep.
was.
It's 88 NYS 2nd 50 at pages 52, 53. That's a city court case from 1949. But I think if you look even at the dictionary definitions, particularly the Blackstone dictionary definition that the DOB cited. Ironically, by the way, if you were to accept the DOB's definition of the word freight, and that the goods that are transshipped through this facility are not freight, then it would, of course, fail the test under Use Group 18 that there needs to be both pedestrian traffic, a great deal of pedestrian traffic, and a great deal of freight traffic. So if there's no freight, there's no freight traffic. And by the way, Commissioners, there's virtually no pedestrian traffic, and the zoning resolution requires both. I'm advised that approximately 5 people work at this facility, and if each and every one of them walked to the building, I don't think anyone could rationally argue that it was 5 people.
I'm sorry, there's more than 5 people that work it.
Yes, but not in the medical waste motor freight station. And by the way, I'm going to show you some photos in a minute of what that actually constitutes, but just to clear up a couple of things that came up yesterday in the review session. The building is about 6,000 square feet. There's approximately 1,000-foot mezzanine, which is used for accessory offices. We use about 1,275 square feet for the motor freight station. The balance of it is used by an ambulette company for the repairs of their own vehicles. So the use group, it's categorized, most of the building is categorized under as minor repairs. And if you went to the facility, you would see the bays and trucks up and getting oiled and whatever. Those are all from the ambulette facility. So
So
that's
it's still consistent with what it says on the C of O?
correct. Correct, in terms of what the actual operation is. So there's no pedestrian traffic to speak of, and we would respectfully submit that the Department of Buildings is incorrect in categorizing the 17 deliveries and 2 departures in a 12-hour period as, quote, a great deal of traffic, which is the use group 18 definition. I wanted to note that we referenced the city's Environmental Quality Review Act, CEQA, technical manual, which indicates that in most circumstances, 50 vehicular trips an hour is a significant impact. I would respectfully submit that even if all 17 panel trucks and 2 trailers came in and left at the same time, that would not constitute a great deal of traffic. Certainly not in comparison to other use group 16 uses, such as car washes and laundries, just by way of an example.
I just have a question about that. So 17 deliveries, but it's more than 17 trips then, or I don't know, how's that work? It's 2 trips, but arriving and departing?
Yes,
Right.
that's correct.
Okay.
That's correct. So I want to turn now to what I don't think this facility is, and that is it's certainly not analogous to the kinds of facilities that Use Group 18 contemplates, where sulfuric acid is manufactured or asphalt. And of course, the Department of Buildings initially relied on a TPPN that was intended to define solid waste transfer stations. As the chair pointed out yesterday, solid waste transfer stations tend to be large operations where you have putrescible waste picked up from restaurants and any other commercial establishment that get dropped off, commingled, packed up using heavy equipment, and then transshipped out. It can also be recycling materials. It can be construction debris. These are all types of materials, but it's not just the type of material that underlies the TPPN. It's the use of the facility. This is a land use decision that we are asking you to make, and the very nature of the operation there poses risks to the people involved of heavy equipment. There's been at least one reported case that I remember from the 90s where somebody died in one of these facilities. And it also goes on to talk about the fact that they can't be designed to meet high-performance standards without considerable expense. As you'll see in a moment, that's certainly not the case with our facility. And it also leads me to another point that I wanted to make, Commissioner, and I want to clarify something that you pointed out yesterday, and I think you're right in the way we phrased it. And that's the reference to the Department of Sanitation, whether the Commissioner has inspection rights over the type of facility that we suggest is the appropriate categorization. The answer is, of course, yes. The Commissioner of Sanitation can enter for the purpose of examining what's going on in the facility. I'm told that in the years that it's been open, they've never been there, but it's possible. But I want to draw a contrast with the provisions in the TPPN, which basically require the Department of Sanitation to participate in the design process and to come out and observe what's actually occurring there in terms of how the machinery and so forth all fits in before a permanent C of O can be issued. So the safety sort of on the upfront side, because of the inherently dangerous nature of a solid waste transfer station as opposed to an inspection right with respect to a facility such as ours, which handles regulated medical waste. In addition to that, I think it's helpful to talk about the regulatory scheme that applies to this type of product. And I want to start with the public health law because the beginning of the analysis, I believe, and I think there was some allusion to this yesterday, is with the generator of the site. And as the chair observed, there are thousands of sites all over the city, doctors' offices, dentists, you mentioned hotels, colleges and universities, pretty much anywhere where anybody's getting any type of medical treatment can be a generator of these materials. And those generators of materials are under an obligation, an affirmative obligation under the public health law to package the materials carefully and to make sure that they are transferred to an organization that will track them. So under the public health law, the materials are divided basically into two categories. One category are sharps, and those have to be in a rigid container. When you see the photographs in a second, you'll see some red barrels, waste baskets that are plastic, and those are what the sharps are disposed of. And the rest of the materials have to be put into bags that are basically puncture-proof, and they go into a cardboard box, and they're basically handled in the same way. They're separated for obvious reasons. When the goods get to the facility,
Sorry, just one thing. So the things that aren't sharps are put into these bags, and
Plastic.
the bags by the generator are put into the cardboard boxes?
correct,
Okay.
correct. And then they're loaded onto the panel trucks or box trucks, as the case may be, and brought to our facility. Commissioner Schmetter, you asked, and I think Commissioner Ishida asked yesterday about radioactive materials, which are excluded from this under the public health law, have to be dealt with separately by the generator of the waste, the doctor's office, the hospital, for example, for radioactive isotopes and the like. Those are not within the definition of materials that we're discussing today. And as I'll show you in the photos in just a second, there are radiation detectors at the entrance to the bay where the transfer takes place, and if anything goes off, it's not accepted into the facility. It must be returned and then properly disposed of. The Department of Environmental Conservation, and again, it might be easier, I'd be happy to submit a letter afterwards with the various citations.
That would
but-
be very helpful,
of course.
thank you.
The Department of Environmental Conservation regulations, which to some extent also regulate the generators of these waste, require that the waste be weighed, and it's part of a tracking system. So it's sort of generator to disposal site tracking system. So you want to know that you put as much on the truck as was actually delivered. I'm also told that the waste generated at this facility is separated by the generator, by the doctor's office, by the hospital into two categories. One category are items that are autoclaved and basically heated to a temperature that would kill any infectious materials. I see that in my dentist office with some of their tools, and also to facilities where they're incinerated. They're not, it's basically, those are the two ways you dispose of it. Some of the ultimate destinations have both, some have only one. So depending on what type of material it is, as designated by the generator.
So I
that
missed
sorting-
something. The generator separates the autoclaved items from the what?
From the items to be incinerated.
Oh, okay.
But this is in addition to the sharps versus the not
Correct,
sharps? Okay.
correct.
So then there are four categories. There are sharps that are incinerated and sharps that...
Counsel, I don't know whether the sharps are the ones that get autoclaved. Logic would suggest that that's what happens to them,
Okay.
and that the metals don't get burned, but any type of biological material or paper and so forth would be incinerated.
Okay.
And you're saying this for the purpose of that all this sorting happens at the side of the generator,
Correct.
not by your client?
Correct. In fact, let me actually, if you don't mind, I will submit these electronically for the record, but if it might be helpful, we had some photographs done just this past Friday, because I thought this might come up, but unfortunately, because of the holidays, we didn't have a chance to put them on boards, but if I could hand up the photographs, and I have a copy for counsel to the Buildings Department.
Just hand them to Commissioner Shabeta.
Oops.
Yeah.
Mind passing those down? And we'll submit these both electronically and by paper for your record,
With a cover letter?
with a cover letter, as well as the citations to the various statutes and regulations that I referenced. Yeah. So if you start with photo number 1, this is an entrance into the yard, which is acknowledged on the C of O, where vehicles can be stored while they're being serviced by the ambulette company, or when the operator's vehicles come in. So you can see it's within this gated area, and you're looking at it. That bay that you can look down, that's what we're talking about. That's the 1,274 square feet of regulated medical waste motor freight station that the Department of Buildings tells you is as hazardous as a solid waste transfer station. If you look at page 6, the second photograph, one more time. Photo 6, which is the second one in the series, shows one of the box trucks being backed up to the facility. If you turn next to photo number 3, you'll see inside the facility is a trailer, semi-trailer truck. And as you can see, there's barely enough room on either side to walk past it. It goes...
That's a semi or not just the box truck that's
That's a semi.
open?
That's it. That's a semi.
A semi fits
Yep,
in that space?
and nothing else. I mean, there's some washing equipment and there's some other minor equipment. There's no heavy equipment. There's virtually no mechanical equipment. They use hand trucks. But that's a semi, fits in. If you turn to page 7, I'm sorry, photo 7. I keep making that mistake. Photo 7, what you'll see is the workers lifting the materials out of the box truck and putting them into the semi by hand.
The box truck is outside.
The box truck is outside, the semi is
Semi's inside, and they're loading directly into the semi.
Correct,
Semi.
with weighing. There are scales.
On
Yep.
on the truck.
There are scales on the truck, and I'll show you in a second, there's also a scale there.
I don't know.
No, because the boxes are big.
Yeah.
Doesn't
Is
fit
that
no
the limit of
safety
safety equipment that person needs to have, just gloves?
Oh, it is,
There's no
there's a
safety
different thing. There's a thing on the floor.
Yes, I believe that that's the case. I believe that it's gloves, and I think they have some.
Okay, so no face masks or anything?
No,
like
because
that?
all of the biological material is basically double sealed. It's sealed inside of a plastic bag, and then it's inside a cardboard box, or it's inside a sealed plastic container. They are never opened. They are never opened. They're not processed. They pick up the box and they put it inside.
What I'm currently seeing on page 7, you're stating that these workers are in perfect compliance with what ECL requires them to be wearing while handling this freight.
I don't represent the operator of the facility, so I would hesitate to say that they are
Who
in
do you
perfect...
represent?
The owner of the property.
Oh,
So I hesitate to say that they're in perfect compliance,
Could you,
but it's my understanding that the operation is in compliance, doesn't have any violations, and that they follow proper procedures.
can you follow up on that? Because a lot of what Department of Buildings is saying is that there's pathogens and this is very dangerous. So
Right. There are pathogens. By the way, Commissioner, you also asked if there's, and you did as well, is there a operating manual? My understanding that there is an operating manual If you want us to introduce a copy for the
Yes.
record.
If it's not 500 pages.
Well, it's at least the one that I saw, which may have been from a prior operator, was a large notebook. I suspect that the current operator has a similar operating manual, will inquire, and if we can provide it,
Maybe you could
we
get
will.
some just choice
Sure,
morsels from it.
understood.
I do have a question, though, about that. So the trailer truck is inside the building. The panel truck pulls up against it, and they're showing them loading directly. But I know you haven't turned the page, but
Right.
photo 8 shows the scale,
Right.
right? But the scale is in the building itself.
Right.
So how do you get it from the panel truck
Right.
onto the scale if you're loading directly into the trailer?
There's a scale in the truck as well. It's not shown in these photographs.
But
and there's
no,
a-
but there may be a scale also in the truck,
Right.
but there is notably a scale that's being used
Yeah.
in the building, so that can't be the only method of transfer, right? It must be that sometimes goods go into the building.
Right. On occasion, they'll take it off the panel truck, the box truck. They may have to weigh it there. Maybe the truck that's doing the pickup that day doesn't have its scale, or it's not functioning. It's basically a backup. But I'm told that there are scales on the truck. And then if you just look at the last photograph, this just gives you some sense of the materials. They get stacked up, and off they go. And I think Commissioner Shabeta, you flagged the point that I'm sure that the Department of Buildings will be quite emphatic about. And yes, there are materials that are inside the rigid plastic container and never opened, or inside the sealed plastic bag, inside the cardboard box that are never opened, that are potentially hazardous. I don't think there's any question about that. Doesn't mean all of it is, but it is potentially hazardous. But the critical point, I believe, is not what the nature of the material is, but whether or not, but what happens to it there, and what is the risk posed by the facility itself. And you'll forgive the macabre reference, but perhaps nothing illustrates it more than the fact that autopsy material is organs that are removed from a body are considered regulated medical waste. Therefore, under the Department of Buildings theory, when they leave the medical examiner's office, the organs have to make a left turn and go to use group 18, whereas the body can make a right turn and go to use group 16 because human crematoriums are permitted in use group 16. So are animal hospitals. So are poultry and rabbit killing facilities. These are all considered safe enough to be within a use group 16, and certainly pose similar potential hazards to the biological material that is otherwise categorized as regulated medical waste. So, the chair pointed out yesterday at some length that the generators of these facilities are all over the city. There are thousands of them, and they travel through residential and commercial neighborhoods on a regular basis. And while not strictly speaking regulated medical waste, because it's used for another purpose, Council and I, when we left this building yesterday, noted that there was a Quest Diagnostics lab truck picking up blood samples, and I assume other bodily fluids, from parked in front of this building. And I don't think any of you walking past it considered it to be a particular hazard. And in fact, Commissioner Shabeta, and only because you asked some good questions yesterday, I keep referring to you, but I think you used the word hysterical to reference some people's reactions to the possibility that something like this might be passing by their doorway. I believe the legal term for that would be irrational, which is what I think the Department of Buildings' reaction has been to this situation. And the fact that they referenced the threat of Ebola as being posed by this facility, I think perhaps supports both adjectives.
But, and to pick up on that, I think I read in your papers that, just to use that as the more hysterical example, that's not something that's permitted to be transferred here.
I don't recall the specific reference, but even if it were, I don't believe, I'm not sure about the reference, but even if it were, I would submit that it poses, that the operation, the use of the premises does not pose any greater risk of exposure of taking the box off one truck and putting it on the other truck than that same sample of material driving down the street in a vehicle where it could be subject to, as DLB pointed out, maybe there's an accident. So the long and the short of it is that these, in modern days, I think we all should consider ourselves fortunate that we have the technology to be able to take advantage of it, to take a sample of blood or a piece of thing, or to bandage somebody up in an office or a dentist office, have it disposed of properly, have it tested properly, have it tracked, all of which happens every single day all over New York City. And lastly, I wanted to just speak to a couple of other things that the chair brought up yesterday. And most particularly, to remind all of you that there are companies that deposit these wastes with the post office, that deposit these wastes with FedEx or UPS, and that I don't think that the Department of Buildings would suggest that the transport of regulated medical waste is merely an accessory use because it's a small volume, although how they would know that. One of the facilities I think we referenced in our papers actually has a drop-off place there. So this is, throughout the city.
Sorry, has a drop-off place where?
There's a specific medical waste drop-off, I believe at the UPS facility.
Oh, wow.
It's mentioned in my papers. But as you pointed out, there's a facility called Medical Waste by Mail. I think
Right,
that says it all. I also want to talk a little bit about other certificates of occupancy and how they're categorized. So the Department of Buildings said that they only found one reference to medical waste in their records. And it's actually an interesting situation. Because it's located in an M1 zone, and we were kind of surprised by that. Usually you wouldn't see use group 16. So we researched a little bit and found that the original certificate of occupancy for that particular building was for storage. They apparently received a violation and came here in 1987, and apparently the board at that time legalized the use in this M1 zone. We requested yesterday the record of that case. It's in the archive someplace and not within our ability to produce.
Do you know the calendar number for that case?
I do, I'll have to send it to you. I don't have it handy. I also, we looked to see where some of these other facilities were. We looked at a bunch of C of Os. And what we found was that there's a kind of a range of answers that perhaps the buildings department might categorize differently if they were looking at them de novo. So these types of facilities tend to be categorized as warehouses or trucking depots, sometimes as storage, I believe. They're not specifically called out as facilities handling regulated medical waste, except through their DEC permits, and of course, how they advertise themselves. Some of them predate, I think, a lot of the regulatory schemes. I would speculate, but it would be speculation, that some of them don't want to call attention to the specific operations because of the hysteria that it might engender. And I know that council called out the fact that we categorize this in different ways, but every category that we've referenced is within use group 16D. So I didn't want to, I recommended to the client we not call it a warehouse because the goods aren't really stored there. They're allowed to be there for a couple of days under the DEC regulations, but they're not. Maybe overnight, but that would be it. But it's not really a warehouse. Trucking depot, to me, conjured up images of a whole field, acres of semis that are being washed and serviced and things. I couldn't find a definition of it in the zoning resolution or any of the interpretations that you had made. And as the chair pointed out, there's not a lot on what a motor freight station is either, but that seemed to me to be the most accurate description. Because we have rail freight stations, and there could be shipping, marine freight stations. Motor freight stations seem to make the most sense since it comes in on a motor vehicle and goes out on a motor vehicle. But any use group 16 category that the board feels is more appropriate would be acceptable to us, and of course, we would conform the CFO accordingly when we remove the accessory reference. I'd be happy to answer any other questions.
Yeah, I did have a question about, and I'm just curious, is the operator of the facility here?
No.
No.
And let me speak to that briefly, Chair. When the facility was originally opened, it was operated by a company that was under common ownership with both the Ambulette company and the real estate holding company. And that entity, CMW, was sold to another operator. So that other operator is the tenant, and my client is not directly involved with the operation anymore, to the best of my knowledge. I believe we included some information from the website of the other operator. They have multiple facilities, and they perform a variety of services. So they don't distinguish on their website one from the other, and in fact, I don't think that they even reference this location on their website because it's not someplace where they would interact with customers. They have other places for that. So that's why the operator is not here. My client, through another
Sorry,
entity.
I didn't understand what one thing has to do with the operator not being here.
No, I'm just saying, my client ultimately, or affiliate, was the operator, and they no longer operate it. They sold the business to a competitor some time back. The competitor operates this facility as well as several other facilities.
Okay.
That's not an explanation as to why they're there.
Yeah,
That's
yeah.
just more information about
Yeah.
them.
Right,
and-
but so what I'm trying to get at is if there's specific questions that we might have for the actual operator as opposed to, because this is a little bit third-hand information,
Sure.
right? You're gathering.
I'd be happy to do that, but I also think that the legal issue, I mean, there's the application of the zoning resolution to the facility as it's designed and operated, but I would also suggest to you that the regulatory scheme that they're under speaks to the inherent nature of what's going on there, where the material comes from, how it gets there, why it's weighed, where it goes, without regard to who the particular operator is.
The
Yes,
operator-
but just to pick up on that, the photograph, I do have to say, in terms of the operation that you described, the thing that was inconsistent is me seeing a scale that's inside the building. So not that, taking a box and putting it inside the building and putting it on a scale and then putting it in a truck changes my feeling about whether the public is more exposed or anything, but there's a missing link in the analysis, and it's not really clear what actually happens, and I want to make sure that we have all the facts. And then the other part of it is, I'm aware that this company that's doing this has other locations, and since this becomes a discussion about how all of those other locations are categorized, to talk to the operator who actually does this kind of work to make sure that when we when we describe what these groups are, we want to be very precise, and we want to make sure that we're encompassing the correct group and not expanding it into ones that actually dispose of or in some way transfer, in some way manage, like take it out of the boxes, process. Because as I mentioned yesterday, I found one on Staten Island where the text on their website implies that they may be taking it out of the boxes and doing something with it, but because I don't know, this was a group called Stericycle, and they say we specialize in proper pickup, treatment, and biohazard waste disposal. So what I couldn't understand is whether, because they are actually use group 18, if I remember correctly. Yeah, they are use group 18. And the only one that I found that had anything on the C of O indicating anything to
Medical
do with
waste, yeah.
use.
Yeah, that's the one I referenced, Commissioner, where I believe that they're in an M1 zone and operating pursuant to some grant of authority from here. But let me speak more directly to your point. To the extent that I can get the cooperation of the current operator and provide additional information, we're happy to do so. In the alternative, because it was an affiliated company for the owner of the premises, I can provide some additional information from him. At some point, he may get back into the business when the lease is up and his non-compete is over,
I
but
see.
we're not there
Okay.
yet. But he's very familiar with what happens there because he's there frequently, because he also owns the building and he owns...
The Amulet.
Yeah, the family owns the building and the Amulet company.
Okay, so, and then the other question I had was, the floor plan shows this sort of demarcation area as if there are demising walls, but there aren't, it just sort of bleeds into the other. How does that work to isolate one use from the other?
It actually, there are walls, and in fact, that's what the building permit was for. The building permit that the Department of Buildings sought to revoke after the work was done and after the C of O was issued, it's a box, and they put up a wall.
Right,
That's it.
but the wall isn't, when you look at the area described as the 1,200 square feet or whatever it is, it goes past the wall, about, I don't know, 3 feet past the wall, and it extends to a kind of arbitrary point at the rear, which must be where the semi-truck doesn't need any more space, right? But then there is nothing that demises it, that distinguishes this part from that part. I'm trying to understand, not to say that you can't operate and share with your
Right.
neighbor, but we're talking about, I think one of the aspects of hysteria, say, which was raised in one of the papers, was like, what if the box breaks, et cetera, et cetera. So if you've got another activity going on where you're repairing the ambulettes and there's no clear isolation between one function and the other, what if an ambulette falls during its lifting or something like that, and, right?
So, Commissioner, we'll provide additional documentation to clarify that. I can also tell you from my own observation, when I was out there a week or so ago, the two are physically separated. This is contained within the four corners of the bay. There is no direct access from one operation to another, except through a door. It's not, there are
We need to look
walls.
at the floor plan, because that's not what the floor plan shows.
Okay, we'll take a look at that. I think if you mentioned it was A101-01, was that?
Sounds right.
was-
I mean, there's not a lot of drawings that were
Yeah.
submitted to us. Right,
Right.
but what it does is it hatches the area that's not
Right.
of concern, and then it leaves clear the area that is, and the hatching is outside of the wall line.
Right, I understand. We can provide documentation and clear that up pretty easily.
I want to second the chair's request for the operator to come in. I believe that it's very relevant to what the Department of Building is saying. Further, I want to hear your response to Department of Building's assertion that, or insinuation that there was dishonesty in the May 14, 2015 Alt Type 1, where the design professional did not indicate that there was a related job that was denied.
Sorry, there was a related job.
There was a related job that,
Oh, you mean when the C of O
yeah,
was
the
issued?
C of O was issued. So on May 14th, 2015, the owner's design professional did not indicate on the PW1 that there was a related job in the department, the related job that was denied. Is there a reason why that wasn't Or is that, what's your response to?
I don't know. I think that may be a, look, let me speak with what I think is your question, and
Maybe I'll clarify. In 2009, the application was not approved and was withdrawn. Then 6 years later, or around 6 years later, an alt one was filed, and they did not mention the original application that was withdrawn. I'd like to understand your reason as to why.
my understanding is that, and based on what we were told by the architect or expediter at the time, was that the original job had expired, that it was, and the job number basically no longer existed because it had been withdrawn, and it was resubmitted. I will tell you candidly, Commissioner, that some of the passage of time was in the hopes that the Buildings Department would give a more clear-headed analysis of this, since their original decision and apparently their subsequent decisions were influenced heavily by politics. I spoke at the time of the original application with the Buildings Commissioner himself, who told me, and I believe I'm quoting accurately, that when politicians, he may have said elected officials, and having been one myself, I use them interchangeably, complain about something, that they tend to err on the side of caution. And I would draw that as a contrast to the plan examiner who looked at the most recent application, approved it, and then was ready to resolve the audit objections based on the merits when once again there was an intervention the next day and all of a sudden it was reversed. My recollection is further correct, and with all due respect to Commissioner Farriello, who I have a great deal of regard for, he was the borough commissioner, I believe, when this was first denied, and he was the commissioner when it came back around again most recently, and I believe it was a political decision. And I would point to the Department of Buildings' own April submission, where they talk about the newspaper stories and the controversy over it, that was an improper motivating factor in their analysis and not a legal or technical one. So yes, the owner filed it, withdrew it, waited until there was a new administration, tried it again, and wound up with the same type of unusual intervention that we had seen the first time.
Any other questions? No? Thank you very much.
Thank you.
DOB?
Good morning, Chair and Commissioners. Tim McKernan for the Department of Buildings. In my presentation today, I will discuss the following topics. First, I will briefly discuss the premises and its history with DOB with respect to regulated medical waste. Second, I will explain why DOB determined that this facility is properly classified only as a use group 18 use. Finally, I will address some specific issues raised by the board yesterday and answer any additional questions that the board might have. I was prepared to review the history in detail, but as Commissioner Sciabetta just indicated, it seems like the board is familiar with the history at this premises. And I'm happy to answer any questions that the board has about the history. Otherwise, I can skip straight ahead to the substantive.
Yeah, we've reviewed all the papers.
Sure. So I think I'm going to break this into three categories. First, I'm going to discuss why the department determined that this is a danger to public health. Second, I'm going to discuss whether this generates a great deal of traffic or whether it even has to generate a great deal of traffic. And third, I'm going to talk a little bit about the department's determination that why this is not a motor freight station. The question in the instant appeal is identical to the underlying issue since the department disapproved owner's 2009 application to construct such a facility. And the issue is whether a regulated medical waste transfer is properly classified only as a use group 18 use. The basis for DOB's classification of this facility as a use group 18 use is the department's determination that it, quote, involves considerable danger of hazards to public health or safety, end quote, as that phrase is used in ZR 4215. The facility is governed by Title 15 of the Environmental Conservation Law, the ECL, Title 13 of the New York State Public Health Law, the PHL, and the rules pursuant to those titles. ECL 27-15091 states that no person shall transport regulated medical waste unless permitted as a regulated medical waste transporter by the department. And pursuant to PHL 1389EE, regulated medical waste, a defined term, and therefore the material transferred at the subject facility may contain the following: cultures and stocks of infectious agents from research and industrial laboratories, tissues, organs, and body parts that are removed during surgery, autopsy, or other medical procedures, various sharps, including broken or unbroken glass in contact with infectious agents, body parts, body fluids, blood or bedding original from animals known to be contaminated with infectious agents. So due to the danger to the general population if exposed to those specific types of regulated medical waste, including, as we've highlighted, infectious disease agents such as Ebola, the department believes that such a facility presents a risk appropriately permitted only in M3 districts, which accommodate the city's most disturbing nuisances and are generally the most buffered from residential districts.
Do we have any basis for your statement of them carrying Ebola?
So my understanding, and I know the board discussed this, and this is why I think it would be very helpful to have the owner of the facility present at a hearing to explain. My understanding based, and I submitted a piece of paper that said only regulated medical waste from the, a piece of paper from the ECL's, from the DEC's website stating that only regulated medical waste licensed transporters can handle Ebola. So my understanding, whether they can right now, they are the type of facility that is eligible, and from the department's perspective, they would not need a new C of O to become eligible to handle infectious disease agents like Ebola. So I submitted, I think, an exhibit with my statement showing the DEC statement that only certain facilities can handle material suspected of being contaminated with the Ebola virus. And I believe that this is, if it's not such a facility already, it is a facility that's eligible to handle those.
So I have a question though.
Sure.
Aren't the source sites, like the hospitals, such, required to handle those types of very volatile kind of germs in a certain way to protect the public? And that's where the burden of enforcing that the standards are kept lies, and not with the regulated medical waste transfer station? Because it doesn't seem to me that they could just toss an Ebola infected rag into a garbage bag and then just throw it into a box.
Of course, but I guess I find this at the least a double-edged sword, which is the reason why these materials are so heavily regulated is they're dangerous. So the idea that they're in boxes and containers, I've heard discussed as if it's evidence that they're not dangerous, but from the department's perspective, it's at least a double-edged sword because it indicates how potentially dangerous these materials are. And as we've seen, this was a medium-sized truck with boxes filling almost the entire back, which means they're in a volume and they're in a volume and intensity that the department believes is potentially hazardous, meaning if there are a risk. If something goes wrong at this facility, it is potentially a major risk to the public nearby.
But in the same way that if something goes wrong in the hospital,
Sure.
where the Ebola-infected patient is, that hospital is right in a residential.
Of course. I think the major difference is there's a reason why hospitals are community facilities, and that's because the zoning resolution wanted hospitals close to residents.
That waste would leave the hospital at one point or another.
Of course, it has to. But I see a parallel here to solid waste facilities. All solid waste, well, the vast majority of solid waste comes from households. Households are all over the city. Just because the generators are spread widely throughout the city, the department does not believe there's a need for facilities that handle the waste of those generators to be distributed widely throughout. And one more thing, which is in the intensity, which meaning collecting all these materials in one place, we believe adds an extra level of danger.
But, wait a second. So this is a tiny facility, and if we were to just say that it handled materials, well, actually, we can see from their contracts, if you go on their website, you can see that they service all kinds of facilities all over the city, right? But it's a tiny facility, it's one panel truck's worth of transfer, or maybe it's two, not panel truck, sorry, semi-trailer worth of transport per day, right? That's what you can just see by the size of the site, that it couldn't handle many more boxes than what it's handling, as opposed to, for example, a hospital or lots of other generators that are probably using, I don't know how many, it'd be interesting to know, a dozen, 24 of these medical waste transferers in order to just handle what they produce on a given day. So the generators are actually of enormous, if we talk about risk to public health, the generators are the ones that are, first of all, they're handling it, they're packaging it, they're putting it into the boxes, they're storing it, and in some cases, they're even disposing of it. We've learned that some of the hospitals actually dispose on site. So in the interest, so on the one hand, the zoning resolution says, great, put a hospital within a residential district because that's more convenient. The zoning resolution has also said the same about doctor's offices, that there's one in every neighborhood. There's a doctor's office on a leafy residential street, right? Which is a generator of potentially dangerous medical waste. So, and if there's any opportunity to mishandle it, it would be at the generator site, which, by the way, I used to work on doctor's offices, and the staff would eat lunch in the laboratory. So if we just talk, so in terms of things like that, it's hard for me to really imagine why this creates a greater danger to the public when you can see it comes in these containers. And is there a risk that there's a traffic accident on the street and the whole thing spills out onto the street? Sure, but then that's a traffic accident on the street.
I understand what you're saying. I don't know that our position is the risk is higher here in hospitals. I would say two things. My understanding is that the hospitals are doubly regulated. They're regulated to some extent by the ECL, and then also extensively regulated by the New York State Department of Health. So they're subject to two sets of regulations to ensure that those are safe. And second, I think I would categorize it as a necessary evil, which is the state made the determination that all things considered, it's actually safer for many of these facilities to treat these waste on site. And third, I would say this only cements or emphasizes our position that I think it would be appropriate for the operator of the facility, and what the department really wants to see is the actual permit for this facility. Because in general, we deal with categories. So you just noted that the facility is quite small, but that doesn't mean these facilities are always quite small. And I think you mentioned that you'd like to make this determination with precision, and the department agrees, because what certain things we're afraid of is we're operating at an information disadvantage here. We don't know, we're not experts in regulated medical waste. We don't know exactly what this facility can do. We haven't seen the permit, and as Chair noted yesterday, the one CO that DOB was able to find lists as, I think I have it here, transfer station dash medical waste, and I looked up the DEC open data site, and it is unclear whether it's truly a transfer station or a treating station. So I think what the department at the very least wants more information to be able to, if the board decides that this is a use group 16 use, to differentiate the different types of operators. And I don't think right now the Department of Buildings is in a position to do that. So
That makes sense to me, actually, right? If it's beyond, the zoning resolution limits to size, for example, 10,000 square feet sounds like an
Variety stores.
enormous transfer station, right? So, but it limits as to size. Maybe in talking to an operator, we could find out what kind of variety you see. Are they all these little tiny things? Or are they, sometimes the one in Staten Island is clearly very large because it shows on their website a picture of this gigantic warehouse. Right.
Okay, so I think, and that goes to another point that I was going to get into a little later, but it seems appropriate to make it now, which is
Move the mic a little bit, move the mic a little bit.
move away.
Yeah, for some reason it's just, yeah.
Is that better? Oh, that's still pitchy.
Maybe it's worse now. Want to lift it up, perhaps?
Sorry, someday we'll have a new one.
No, I'm not even doing anything.
Maybe one of us. Oh, but often it's because the plug isn't right.
Sorry, guys.
Try that.
Let's try it. Ooh, let's not do that again.
Yeah, please, somebody else volunteer to do
Yeah.
that.
Sorry.
It's
I
on,
believe it is.
I think.
It's working.
Let's hear.
No.
No, not
Is there a
on.
button?
Yeah, it's not picking up, so it's not.
Tony, don't.
How about someone else do that?
Sorry.
Just put it back in the other place.
But sometimes it's just not sitting well.
Yeah, push it in. It's in.
There we go. Do that again? Yeah. Same problem.
So
Oh, okay.
just to continue, I was discussing sort of what I'm calling the asymmetrical information situation, which is the owner submitted some materials and pictures indicating, and I'm not suggesting it's not accurate, that these materials can be shipped via the United States Postal Service. What the department's research indicates is that such shipments are both regulated by the Federal Department of Transportation and by the United States Postal Service regulations. And one thing that the department would like the opportunity to research, but I believe it would be appropriate for the owner to brief this, is what are those regulations and are they different from what's happening on this facility? Because again, just, I keep coming back to Ebola, not to spark hysteria, but to use what I believe is an accurate and the most extreme example of the dangers here. And as far as I know, or perhaps I'm wrong, but I don't believe the USPS can handle those types of infectious disease agents, and I think it would be appropriate for the owner to explain the difference between the facilities that it's saying have drop boxes on the corner and its facility, which is a licensed facility by the state DEC.
Okay, that's fair. Yeah, I should imagine that hospitals don't do most of this stuff by mail. It would be actually doctors' offices because they're the ones who have smaller quantities, if it's a small doctor's office, and smaller, they're dealing with kind of smaller parts, to say, right? They're not doing major surgery in a doctor's office, they're, things like that.
Right. One of the regulations I saw some kind of 50-pound threshold, but again, the department's not an expert in regulated medical waste, so we ask that the owner does brief this issue.
Let me comment on this. I believe, and you said it twice. You said the department is not an expert in looking into facilities like that. This is the first point I got from your explanation. The second thing is I believe you didn't get enough explanations for the operations that are taking place on the facility. That's why the department elected to go like the conservative route and classify this as use group 18 rather than use group 16? Is that a fair statement?
I understand your position. They've had not 10 years now to present as much information. If they want to distinguish between what can be mailed and what can operate at this facilities, they had literally 10 years to come in and give that information. As far as I know, they've submitted these pictures of the Dropbox facilities, but have never explained the difference to either the department or BSA, what the difference is between those regulations. So I don't think you can fault the department here for not being an expert when they've had 10 years and
I think
Yeah, no, that's
saying
not
that
what
you're
he said.
operating under an abundance of caution at this point.
Right.
Because of lack of
In abundance?
information, you didn't get probably what helps you to look into this in more details. Is this a fair statement?
An abundance of caution, I mean, we applied the meaning of the zoning resolution, which is if it's a significant public hazard, we believe it's appropriate only in a use group 18 use, and that's the department's position. Is it an abundance of caution? I don't think the department would categorize it as such.
Okay, that's fair.
And I just want to mention the great deal of traffic. I think the owner called it a requirement. However, I just want to note that ZR 4215 states that normally use group 18 uses generate a great deal of traffic. And there's also, and I can go into it, the Applebaum case. But the upshot is we don't believe that the amount of traffic is a determinative factor. We believe even if certain use group 18 uses have less traffic than a motor freight station, if they are inherently dangerous, they would be appropriate for a use group 18 classification. And I think that's consistent with the zoning resolution, which treats radioactive storage as use group 18. And I don't think anyone would suggest that a normal radioactive storage facility generates more traffic than a 20,000 square foot, which is the maximum motor freight station. I don't think the zoning resolution implied all use group 18 uses generate more traffic than use group 16. So I think the main point for us is the main issue here is the danger. The department determined that this is a danger sufficient to a use group 18 use, and I think that's really the question here for the board.
Okay, but just in the defense of both the board's conversations and the owner's response materials, that was a position that the DOB was taking, which was it was a great generator of traffic, and it really wasn't until we had this conversation yesterday about it being across the street from a Jetro that has like 30 semi-trailers parked out front, that we said, well, that was like a great...
Understood. I think I could have expressed that point in my papers with more nuance, but I think the point I was trying to convey was it's consistent with other use group 18 uses.
And what would satisfy the department into thinking that this type of, it seems like you're stating that there is a certain level of regulated medical waste that the department would say is appropriate for use group 16.
I think that's possible. I'm not ready to say that here, but I think with more information, that's a possibility. But I think this goes to my earlier point, which is I think we need to see the permit, and if it turns out that everything they're shipping at this facility is the same thing that can be shipped through USPS, that would certainly, I think, make us take another look. But without that information, I think I can't.
I think that's a fair statement.
Thank you.
So it just seems to me that when you make a statement about use group 18 handling radioactive material and that you're concerned about this site, it seems like you're equating what happens at this site with use group 18 uses, and they've already stated that they don't do that here. So at what point does the department give up this preconceived notion about what goes on at this site and starts to listen to what the appellant is trying to say?
I mean, I disagree with your characterization. I think that this facility handles, or at least potentially handles, the most dangerous infectious pathogens that such facilities can handle. And I believe radioactive waste is a different type of danger, and this is a different one. I believe we've listened, and again, I think we're operating in the dark as terms to what exactly this facility can handle.
Question. So you're talking about handling, right? And so I think this also speaks to Commissioner
Sure.
Brown's question. How is a radioactive treatment, use group 18, how is it operated versus what we've heard the tenant at the subject premises handles or deals with? So.
Sure. I mean, to the extent I'm not an expert in regulated medical waste, I'm less in radioactive. But I will say that radioactive is listed as storage alone is a use group 18 use, if I'm reading that correctly, meaning that like here, I believe certain types of materials, I think ammo or something like that is all, ammo storage is also listed in use. Ammo.
Ammunition.
Ammunition,
Okay.
sorry.
Ammo. We're so personal with ammo.
And the point being that certain materials, and the department's position is that regulated medical waste, specifically certain types, rise to the level of a use group 18 use because of their danger, even if they're not being treated or handled, even if they're being stored. And that's the department's position, and if the board finds that regulated medical waste storage, what's happening at this facility, does not rise to that level, that's the board's prerogative. But again, the department asked that we see the specific permit so that, and possibly make that a condition of the CO or the statement that this CO mentions the specific permit so that they cannot apply to for instance, expand or treat because regulated medical waste transfer is already listed on the CO.
Right, understood. I just want to clarify, though, use group 18 says radioactive waste disposal services involving the handling or storage of radioactive waste. Now, the word disposal, which we've learned when we're talking about the regulated medical waste, is actually something where either you incinerate it or whatever the other thing is that happens to the stuff that can't be incinerated that we don't actually know. We know it arrives autoclaved, but we don't know what happens then, right? So disposal says they're actually doing something to that radioactive waste. Maybe maybe they move it from whatever its kind of raw material is that's delivered to them, and then, you know, my idea of how do we deal with radioactive waste, we bury it, we send it to Salt Lake City in those underground tunnels, right? But first it has to go into one of those containers, and then the container is sealed, and then it gets put on a truck, and then it gets driven to an underground place, and then we pretend it's not there anymore. So obviously, the handling of radioactive waste and moving it around, so not that I know of a single one of these in all of New York City, but it does bring up the idea that a lot goes on at that site.
Okay, I
Right.
think it's ambiguous. It's not before, so I don't think it's not before us right
No,
now,
but
so I don't think.
using it-
Can I,
Yeah.
if I finish, I think it says radioactive waste disposal services involving the handling or storage of radioactive waste. So I think the department would likely find that a transfer facility such as this is in the disposal services, it's in the process of disposing, and therefore storage would be okay. So I don't think we need to belabor that example, because there are other examples. I think I said ammo, I meant explosive storages, but there's certainly a list of in use group 18B that are storage, and it's the storage alone of those certain facilities. I think some it's because they're danger, and some it's because they're a nuisance in terms of smell or other or visually. But I think use group 18 does set a precedent that storage alone for certain types of materials is appropriately dangerous to be classified as a use group 18 use.
Storage?
I'm sorry?
How do you determine storage? Storage for an extended, temporary?
Well, I know when the owner referenced this in his argument earlier, is that some of these regulated, I looked in I believe some types of materials that spoil may only be stored at the facility for 3 days, and some, I think, that don't spoil may be stored at the facility for 30 days. And I note that the owner previously categorized this facility as a storage facility. So from the department's position, their permit does allow them storage at this facility, and that's why I'm comfortable using that term. And again, I think if you want the details of that, we need to see the permit and possibly talk to the...
Have they presented to the department any document that indicates some sort of storage?
Yeah, so my understanding, as the owner just mentioned, by their current permit, they're allowed to store regulated medical waste at this facility for a certain amount of time, and a previous CO application did use the word storage on the list.
I think, though, that this is where the DEC regulations then come into play, because I seem to remember that this idea of holding it at the site is, the maximum is like 7 days? It's not, yeah.
Okay, I thought it was something like that for spoilable waste and significantly longer, but I think I can brief that in our next submission, and obviously the owner who runs a business in regulated medical waste is best
Yes,
qualified to answer
right.
that.
Yeah, I completely
But
agree with
aren't
that.
use group 18 storage uses that are volatile and possibly vulnerable to explosion or to dissipation of chemicals into the atmosphere that could be dangerous? It seems like it's not a very
I'm sorry, were you quoting?
No, I'm looking at all of them, like manure, peat, topsoil storage, explosive storage, electric power, steam generator, dumps, coal or gas. These are all things that could either explode, which is a danger to the public, or they give off chemicals as they degrade.
I understand that this specific use was not imagined by the drafters of the zoning resolution in 1961, and the department's determination is that this facility presents a comparable danger to those facilities. Because the chemical reaction by which it creates a danger is different, I don't think is a reason.
The possible, depending on what it is that this medical waste consists of, you're saying the possible.
And I think it's, if the board disagrees with the department as that classification as to the danger, then the board can overrule the department. But the department's position is the danger is comparable to those listed uses.
So I just want to clarify again, I'm sorry to belabor this, but I just want to make sure the record's clear. Radioactive waste disposal services is actually listed under manufacturing establishments, not under storage. So I don't think it should be ambiguous.
That's storage alone?
Use group 18B, all by itself, is storage or miscellaneous uses open or enclosed, so it's storage of coal or gas. I don't know why they say miscellaneous uses, I guess, is where the dumps come in.
Can you clarify that?
Yeah.
What you just made?
So the use group 18A.
Yes.
Is entitled manufacturing establishments, and radioactive, whatever it says, I don't know.
Waste disposal.
Waste
Yeah.
disposal services.
Is listed
Yeah.
under 18A.
Is under 18A.
Versus
So
18B.
it implies therefore that there is manipulation of the product, right? Whereas the use group 18B is specifically storage or things left out from the above, right? So it would be storage of coal or gas, storage of explosives, storage of grain, junk or salvage yards, so that would be arguably storage, lumber yards, manure storage, petroleum product storage. I don't know why refrigerating plants are in a different place, because that's really manufacturer, but never mind. Yeah.
So I think we acknowledge your point that there's potentially a difference between treatment and storage. The department's position here, though, is that storage alone of these materials rises to the hazard as described in use group 18. So the department is not relying on the description in either use group A or use group B for its classification.
Okay. Are there any speakers, members of the public who'd like to speak on this, fire department?
Good morning, John Daly, Fire Department. I attended yesterday's hearings, and I understood all the commissioners' concerns regarding the site. That I have informed various units in the fire department, in particularly hazmat unit. We will be scheduling inspections at this site, especially since the adjacent tenancy is a motor vehicle repair shop. As Commissioner Brown had mentioned, different materials do, as they degrade, give off gases. I mean, dust is a combustible waste material, and so as I stated, we will be conducting inspections at this site. Once I complete these report, I will submit same to the board.
Great.
Thank you.
Thank you very much. Okay.
I just wanted to add, I think the Chair, you asked yesterday about 10401 Foster Avenue. So I think that was listed on the Stericycle website. Is that how you located that address? Anyway, I just want to know.
Papers, actually.
Okay.
Yeah.
So I just want to clarify, that CO does not list regulated medical waste, so I don't think the department knows, it knows even less of what's going on at that facility. And then to the extent the board upholds DOB's determination here that this is a use group 18 use, we would inspect, and then it would be a matter of enforcement at that facility.
Okay, right, understood. Okay. All right, thank you.
Question
Yeah, go
about use group 18. It also lists junk storage, so is there a particular use that you're looking at?
I mean, we've stated in our papers that this specific use is not listed. I think, and this has happened before, that specific uses are not listed, and the department classifies it in the most appropriate use group. So we thought there were enough differences between this use and junk that it was warranted a sui generis classification.
Okay, great. Okay then, so I would then like to set a briefing schedule for this, right? So I guess it would be Mr. Fisher first.
Or it could be simultaneous.
It could be,
No,
no, you have to be a response.
I mean, I think in general, we're fine with the, I think what you've been calling the SIR reply, so meaning they allowing them the last word prior to, so owner submission, DOB reply, owner SIR reply, that's fine with DOB.
Okay. Mr. Fisher, then how much time will you need?
To be on the safe side, I had about a month.
Great. And then, Mr. McKiernan, would you like a month as well to respond?
That'd be great.
Okay.
Oh, no, sorry, wrong year.
It's just been 2019 for 5 months.
It's 2020.
Okay, so a month would be May 22nd for Mr. Fisher, then, sorry, 1, 2, 3, 4, May 22nd for Mr. Fisher, 1, 2, 3, 4, June 19th for Mr. McKiernan, and then 2 weeks, Mr. Fisher, for his reply? Is that sufficient?
Sorry.
And then 2 weeks, that's July 3rd, which, 1, 2, 3, puts you on July 23rd. Yeah.
Happy summer.
That's fine. That's fine with us, and I think the facility is operating, so that does not prejudice the owner.
Okay, so this is the schedule for the second case, so are we following that one
Yeah,
too?
it would just be her.
It's for
on the
both.
second.
Okay, now for the hearing on July 23rd?
Yes.
Do we want the operator of the facility
Yes, of
to
course.
appear?
Yes.
So it would be best if it was the operator of the actual facility, because that can answer specific questions as to this facility, and I'm aware that they own other ones, so it would actually, in the end, be very helpful to that operator for their other facilities to kind of understand what fits within the parameters of what it is that we're going to determine.
Understood.
Right.
If I can produce them, I will.
Okay, and if, trying to think of, because it's not useful for us not to have some real definitive answers from an operator. So, yeah, I don't want to encourage not an operator, so I would just have to say, it's the tenant, right? It's the tenant of your client.
Correct.
Isn't it in the tenant's interest to preserve its use here?
It may be in the tenant's interest, it may not be in the tenant's lease as an obligation to do it, so.
That was a fair question. Yeah.
Right, but it is in its interest not to get shut down, for example, right? So,
I'm
yeah.
certain it's in its lease that
It has to be
Cooperation.
I don't know if there's a cooperation clause. There may be a lawful use clause.
Certainly a lawful
Yeah,
use clause.
The permit, of course, the permit requires that as well. I'm going to address in our papers conforming the certificate of occupancy to reflect the existence of the permit. I'll address that in my papers. But
We
quite frankly,
really do need the operator.
as I stand here now, I don't even know what the term of the lease is. So I can't tell you whether they'll be the tenant by the time we get to July. So that's one of the things I have
Oh,
to
you mean they
find.
might have moved out, in which case this whole thing is moot?
I don't think it's moot.
I believe
No,
that's
they'll
correct.
be taking,
Client may
I
Because
know.
my client
I
might
know
come back
that,
into the business. By the way, if I could just add one small note, just because the chair raised it a second ago, I happen to know, I believe there's only one depository for low-level radioactive waste in the city.
Oh.
It's in Williamsburg. It's located across the street from a public school and surrounded by new apartment buildings that are as a result of city planning and the council's determination to upzone the area. It's a facility known as Radiac. I know that the fire department is quite familiar with it because half the building has storage for radioactive waste and the other half of the building has storage for volatile and hazardous chemicals, something that was of concern to me.
You happen to know what district it's in, zoning
I
district?
believe it's the 33rd Council District.
No, I mean, I know you think like a councilman, but
Yes.
still, it's been enough time.
It's use group 18.
It appears to be 261 Kent Avenue,
Yeah, it's use group 18.
But 18 therefore in an M3.
but not
yes.
anymore.
Or it's grandfathered.
Or
I don't-
grandfathered.
Yeah.
What is it? To what?
261 Kent Avenue.
And I'm sure the fire department is familiar with that facility.
They are now.
I had one, I know
That doesn't put me at ease much. but-
the chair mentioned yesterday possibly contacting DEC. Is that something the board plans to do, or?
It would help us, I think, if we, to see if we can find, we often have conversations with them about other things. Sounds like a whole different department, but we'll see if we can get more information from them.
Okay,
That's an M3.
Thank you.
What? Sorry?
I'm going to ask her, repeat.
It's
Yeah.
M31,
Yeah,
yeah.
M31. So it's 261 Kent is in an M31 currently.
Yes, but it is adjacent to a, what is this? An M12 R6B.
Oh, so they turned it into a mixed-use district, right?
Ms. Monroe,
That's the
could you
other-
repeat the date, the briefing dates when you
Oh,
have a chance?
of course, yeah. Sorry, Mr. Fisher is May 22nd. You, Mr. McKiernan, are June 19th. And then Mr. Fisher is July 3rd. And the hearing is July 23rd.
Thank you.
Thank you.
Thank you.
Thank you. Ready to move on?
Yes. Everybody okay? 30 minutes till we're right here. Okay.
Continued hearing items, special order calendar, item number 3, 21858 BZ, 7740 Hewlett Street, Queens. Hi, good morning. It's good morning still, right? Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? Sign it.
No, I don't.
No, this one. Yeah, that's for Apple. That's for our neighbors. Thank you.
Good morning. I just here to
Your name
just
for
go.
the record.
Oh, sorry. Nancy Lee Paul, and with Nasir J. Kanzada, LLC. Here to respond to some comments for 7740 Hewlett. It seems to me that most of the issues were over the parking, maneuverability, whatever. We will make a different maneuverability diagram to make it clearer how the cars will go in and out. The planter issue, we kept, oh, sorry. All right, sorry.
So we had a discussion amongst ourselves about whether we needed this maneuverability diagram and whether or not another planter would be necessary along that curb, right? And concluded that there's a hydrant.
Correct.
Kind of in the way anyway, so those planters wouldn't be necessary other than for pretty, which is your option, right? And maybe they would be in the way of cars, so not that pretty after they get hit by a car. So I don't think there was actually any other needs for amending the drawings. It was actually what we wanted you to do, since this is legalization, is to go forth now
make the changes on the site,
Oh, okay,
and
yeah.
then, and come back to us, having been given enough time to make those changes.
The main, all right, so the paint, all right, so the light has already been shielded, the owner sent us photographs, and, okay, yeah, we can, that's pretty simple. The planting will be happening this month, because now this is the right season,
Great,
and,
all right, and I don't know if there was anything.
And then there was a request for the FEMA map.
Yeah, the request for the FEMA map, just
So-
to indicate on the panels.
so this is what we could come, this is sufficient, we can just submit it, or?
Yeah,
Yes.
Okay.
And then, was the planting the only thing? Photo show cards on file, no? I think it was, I don't know, oh, maybe I don't know if we need to stripe that parking in the back? Yeah, maybe striping the parking in the back, is that necessary?
It's valet parking, so I'm not sure that would really be,
Wouldn't matter. I mean, you're
Yeah.
showing a particular number of spaces. I frankly don't think it matters how many spaces they have back there. The idea is to not have them be on the sidewalk.
Right.
You're showing 4, but if you look in the satellite view, there are like somehow or other 8.
The only other thing is
Oh, it's
the
the dumpster.
dumpster is being relocated, so
Yeah.
Yes.
that is under construction.
that is all, yeah. The owner's doing a couple different sites, so he's kind of contracting everything, kind of.
Okay, so the dumpster has to be installed,
Enclosure, right?
in dumpster enclosure, and then the planting done, and again, you've done the lighting already. So, and then you just come to us with photographs
Okay.
of the site, and it should be a good set of photographs that really walk around the site and show its condition.
All right.
So, and then key them to the plan so we can see where you are. So
Okay.
not just photographs simply of the planters. there.
Right, no, I understand.
Really the whole thing. So we get a good sense that we're leaving the site in good shape for
Mm-hmm.
your next however many years.
All right,
Okay, great.
no problem.
So how long,
Is this, I'm sorry,
Sorry.
is this a planning map, that map you just showed?
Well, because it's right on the Nassau-New York border, it kind of is hard, so this is, I mean, it is FEMA, but it's like right on the border, and there is no actual panel, it's not in a flood zone, so it's kind of not,
Yeah, I understand, and I didn't ask for a FEMA map. What I said yesterday is just locate the site
No, but-
on the map that you submitted. My understanding is there is no flood map for that.
Right.
yes, but so she's able to get,
The
FEMA
closest panel.
changes its database constantly.
Okay.
So you
okay.
start off with getting just a diagram that says, sorry, we don't have it. And then eventually they start to use satellite images that say, sorry, we don't have it. Then there's that Find My BFE site where you can put in an address and then all of a sudden you realize there's actually a map for you now.
Okay.
That kind of thing. So it's kind of day to day.
yeah.
So it looks like you found the most recent.
It's the best we could do, yeah.
Yeah.
If this is the case, that's fine.
Yeah.
Yeah, as long as it says from FEMA.
Yeah, no, yes, it's printed that way, so, yeah.
Or from, yeah, exactly. Okay, great. So, planting this month is perfect. Dumpster, we could put you on for like, what is this, April? Maybe middle June or something like that? End June, how about that? End June. That's all of May, most.
No, I'm more concerned, there's someone else will be appearing at that point, because I'm on vacation at the end of June.
If that's okay with you, otherwise we can put it in July. That's-
No, I mean, the owner is anxious to get going, so,
Okay, then we can do June 25th,
Okay.
submission date of June 5th.
yeah, that should.
Anything? All of
Pardon?
May. All of
Oh, no,
May.
that's plenty of time, it's just,
Okay, great.
Great. Get that, Ms. Matias?
June 25th, submission date June 5th.
Yep.
all right, thank you.
Thank you. Item number 4, 15900BZ, 383 3rd Avenue, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board to respond to the board member questions?
Good morning, Elise Fullader from Eric Palatnik PC on behalf of the applicant.
I just want to, before you go, we just received a letter from fire department about this.
Okay.
Dated 4/19, so it's not even, it says, please be advised that the submitted plans for altered fire extinguishing equipment protecting the commercial cooking equipment and exhaust system at the premises has been reviewed by the department and was approved on March 29th. An authorized contractor may submit the request to the department for the acceptance test to be witnessed by a representative from what's known as the range hood unit. Okay.
That's positive.
Go ahead, go forth.
I also wanted to let you know that it's a little hard to see, but on A002, I can go up and show you.
Please.
With the submitted plans, they wrote a little note that says existing masonry wall to be open for access, and that's what the architect did to show what's going to be, so the room doesn't have no doors.
Oh.
So it's a tiny little note. This was what was submitted. See that?
No, over here, mason wall to be open for access.
Where is it?
did in this one.
On which side is it opened?
It's the strangest way of an architect drawing anything, because normally open for access is called a door.
Yeah, but I'm just letting you know
Yeah.
because you said you didn't see it, so I.
Yeah. Right, it's called a door, and there's an indicator that you use to indicate that the wall is actually physically opened, as in not having a wall. It's just been a struggle with this architect, I have to say.
Understood, I just wanted to keep his name, you know.
Okay.
So they're demolishing the wall, so it's one large room?
No, it
No, I think
sounds like.
they're opening, making an
Opening for
opening.
access, I don't know what that means, squeezing your body between the bricks, you know.
They're
I don't
opening the
know.
wall to put some sort of door there, that's,
Or-
but that's how he indicated it on
Yeah.
the plans that we submitted in our last submission.
So again, DOB won't allow for it to be described like that, so when it's filed to correct the C of O, they'll expect you to actually show a door.
I think the confusion was when you look at this plan as opposed to the bubble diagram.
Yeah.
The bubble diagram does not have this note.
Have it, okay.
And we were
sorry.
looking, I know I looked at the bubble diagram first.
Okay.
Yes.
I'm
Well, that's
sorry.
true also, but it says door to be sealed, and then the note points to a wall.
Yeah,
That's not the same thing
Yeah.
as removing the wall.
I know, yeah.
These are conventions in the business, right? So anyway, I don't want to belabor this.
I'm not an architect, I just wanted to show you what he did.
I don't want to belabor it, it's his seal.
And then my
his
other
license.
question is, would you consider, because this is a non-for-profit, so it's very expensive for them to keep coming back here, would you consider a compliance hearing to get rid of the term? In the
I don't know
future?
how we set that up.
Because
I was talking about a 5-year term because they have a very bad
Yeah,
track
I-
record.
Is there any way, I'm just asking, is there anything we could do to get rid of this term?
We don't have any kind of.
Well, yeah, it's comply with the terms for the first 5 years, and then you show.
Well, that's coming back, it's just, I'm saying it's very onerous on this owner, because it's a non-for-profit school to keep coming back.
Very suggestive.
Part of
Keeping
that
the
is
keys.
because they weren't in compliance, and it
Yes,
took several
understood.
hearings to get them in compliance. If they're in compliance in 5 years, it should be an in and out.
Right, right.
Okay, understood,
Yeah.
I'm just asking, if you can't, you
I don't think
can't.
we keep a case open for 5 years either.
No, that's not what she's suggesting.
And,
She's suggesting having a very long term, and then in 5 years, they come back for something called a compliance hearing, which we don't have any way
Or
of
just
scheduling.
something, I'm just.
that's what I'm
Right.
trying to say.
So do
Yeah.
a 5-year term.
When-
So a 5-year term is a lot easier.
And then at that point, maybe the board would be.
Right, exactly.
for determining.
And we
getting
would
rid of the
write
term.
that in the resolution, that
Okay.
at the end of the 5 years, if the owner has demonstrated full compliance with the terms of the
Okay.
grant, then it will consider a longer term or eliminating.
Okay.
A longer term is actually
Understood,
what
just
we'll talk about. Okay, so then, are there any speakers on this? So I'd like to make a motion to close.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye?
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabbat.
All right.
And I'd like to make a motion to grant on condition, right? That the Department of Buildings and the Fire Department inspect and review the building and the drawings compliance with fire and building code, which they do anyway, but I want to draw attention to it because we've had so much trouble with this application. And then the condition is that, as we explained, it's a 5-year term, and that we can have in our resolution, the 5-year term was set so as to ensure compliance with the terms of the grant, and if in 5 years it turns out that they are in full compliance, and by the way, that means coming back here before the term is up, right? Not coming back in 10 years, because that's called not in compliance. Then the board will consider a longer term, okay? So I hope your client takes this very much to heart, and then I'd like to make a motion to grant on that condition, those conditions.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Thank you very much.
Thank you.
Item number 5, 13204BZ, 310 East Houston Street, Manhattan.
Elise Fullader from Eric Palatnik PC. We would like to request 8 weeks, if possible, for submission, not for hearing.
1, 2, 3, 4, 5, 6, 7, 8. That's the week of June 19th. That would put you on the calendar for July 16th.
Okay, thank you.
And your actual submission date would be June 26th, so you get an extra
June
week.
26th,
Yeah.
okay. June 26th, July 16th.
Yes.
Thank you.
Thanks.
Item number 6, 12207BZ, 1630 East 15th Street, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to board member questions?
Good morning, Madam Chair and Commissioners. Frederick Becker. We supplied the revised maps as requested at the last hearing. I believe that was the only outstanding issue.
So I just want council to make a note, though, because the statement of facts is incorrect.
Okay.
That the entire building sits within the C44, I think, 44A. So it's not a split lot, and that, because that was making it difficult.
Okay.
And then we mentioned the hours of operation yesterday. Okay, so then, are there any speakers on this? I'd like to make a motion to close.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
And motion to grant.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Thank you.
Application is granted.
Thank you very much.
Item number 7, 23114DZ, 124 West 23rd Street, Manhattan.
Should we take 5 minutes first?
No,
No, it's
no,
not
this- I don't think it's going to take too long.
Raise your right hand, please. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to board member questions? Okay, sign.
Good morning, Jordan Most from Bryan Cave on behalf of the applicant. We heard yesterday's comments at the review session, and just want to point out that the sound consultant, Cerami, it did say in the report, among other things, that the treadmill testing resulted in no audible impacts, sort of in terms of a human-based criteria, in addition to lease and noise code criteria compliance. We know you heard also from Mr. Lee, the fourth floor resident in the building, by letter yesterday regarding the testing conditions. And if you want to hear more about that, Mr. Lee, Mr. Krell, and the sound consultants were all present. Mr. Krell is the gym operator, and Mr. Krell could speak a little bit more about that if you want to hear regarding the construction conditions. I think you'll find that they tested at least several times, I think specifically trying to avoid and successfully avoiding testing while construction activity was in fact taking place. But Mr. Krell is here, he can speak a little bit more to that. I wasn't present in the testing.
Right, but apparently, according to the neighbor who was here to testify, there was construction going on. It just ended later. They must have had an after-hours permit, and they...
Right, but I think they were able to catch times in between when there wasn't specific construction noise activity. Again,
Right.
I can't really reply to that. Also, just want to point out that in general, I know there was some discussion whether there was a certain decibel level criteria. A +1 or -1 is basically within the realm of imperceptibility from the sound criteria testing. In terms of the sound science community, they call it within the tolerance of repeatability, that you could test one moment and the next moment, and sometimes it's +1, sometimes it's -1. And we generally don't hear that difference. And that's where all the testing showed within that range. +2, from +2 to +3 is regarded as sort of the baseline of perceptibility, and there were no increases to that magnitude. I'm sure you'll want to hear from Mr. Lee and/or Mr. Krell. I'd like to propose, if I could, and then I can step down, that we'd ask the board to consider a longer term than we've received in the past. Really, with my understanding is that the primary concern at this point among the residents of the building, and they will hopefully confirm that with you, is that there's just concern that over time, there may be the degradation of some of the mitigation materials, the rubber or the rubber mats or the new treadmills that were installed, and that perhaps a condition could be included in the board's resolution that would require the timely replacement of those materials if they wore out, and give I guess the residents would have an opportunity to call and, I guess, indicate to the board that there's a violation of the conditions, if that were the case. Not that we have any intention of violating any of those conditions. But it would be a way for the board to grant longer than a 2-year term, hopefully as long as a 10-year term on something like this. We think those materials will last much longer than 2 years. That's all I have at this moment. Any questions?
Not so far. Let's hear from Mr. Lee, because what really matters is it working?
Please state your name for the record.
Andrew Lee, I reside at 124 West 23rd Street. I'm president of the condo board at that location. So there was testing, and we had been told that the construction would end at 4:30, and it continued on until about 5:20. During the actual treadmill testing, there was ongoing construction, and I think that the engineer did attempt to, make recordings basically in between hammer strikes going on next door. I don't know how successful he was at doing that. I know that we did ambient noise level testing before, and then after the construction finally concluded. And I can't say much more about, the testing conditions, other than that, during parts of the testing, they were less than ideal.
Okay.
I have, not had any verified noise complaints since the new treadmills were installed. It's not clear whether or not the improvement, at least as far as what I'm able to perceive, results from the installation of the new treadmills, which I believe occurred before the new flooring was installed, or whether it's attributable to the new flooring, or both. As I noted in my email, the old treadmills were replaced after a period of 4 years, so we assume that the new treadmills will also be replaced after 4 years. So it's unknown whether in, let's say, 4 years, when this set of treadmills is replaced, whether the replacement treadmills will, change the noise conditions, in the building. As Mr. Most correctly noted, our main concern, it seems that we or hopefully have, finally achieved some measure of peace and quiet, and we'd like to keep it that way. I know that 3 years ago when we were here, the mechanism for, ensuring that things, stayed quiet, was a shorter permit term. Prior to, this hearing, we were outside discussing, whether or not there was some, alternative mechanism. Unfortunately, the residents and the condo board are not today represented by council, so, or at least not represented by outside counsel. So we don't know, whether or not there are alternative oversight mechanisms by which this board may retain some kind of jurisdiction to ensure that there aren't, future developments or deteriorations in the condition of the soundproofing that, might require some kind of intervention at some point.
The two options that exist really are either a short term where the applicant, or let's say the business owner, is just required to come back automatically and demonstrate compliance. And then the other way is a longer term where it's put on the residents to pay attention to when something becomes a disturbance, and then they complain to us, and then we hold what's known as a compliance hearing, because the terms of the grant are that that noise levels are kept to a point where they don't disturb neighbors, and that would be the condition. And a violation of the condition forces a compliance hearing where the business owner is required to come back and then demonstrate that either they're not causing a disturbance or making changes again to the site to eliminate the disturbance. When we have short terms, the same applies. So whenever if it were, for example, a 2-year term, as you suggested in your letter, the same compliance hearing rule would apply, right? But the difference would be that in the 2-year term, if there were noise, then there could be a phone call to us to say, we need a compliance hearing. But at the end of the 2 years, even though we'd already had a compliance hearing, they would have to come back because the term is up. You see? So, yeah, that's how it works. So I just need someone to remind me on the last time this was granted was 2015, I guess? And it was granted on a
I thought it was 16.
16.
2016.
And it came back immediately, so it was only for a 2-year term, which expired in 18. It was only a 2-year term the first time because it was a problematic site. So it continued to be a problematic site, right? We didn't have, so the ideal is when it's a problematic site, they sort of learn their lesson, everything's fixed so that by the time they come back, there are no complaints, and then we're kind of go with our blessing, right? But in this situation, it didn't turn out like that. They came back after 2 years, they were not in compliance with noise requirements, and so we had to go through this kind of lengthy process, right? This is the 4th hearing, to bring it into compliance. So my preference is a short term. I don't know if 2 years is right, it could be 3, but it could be 2.
They did seem to make a great deal of expenditure to
They did.
resolve the issue.
Yes.
I think that should have some value.
Sure.
But I should note that they only made most of the expenditures after this board instructed them to do so.
That's noted. That's
Yeah.
fair.
Because, so that's the thing is, what we could say is one of the requirements would be to set up some sort of a protocol, which we're not going to manage, right? But there needs to, we did this with another gym, where there's a protocol where, since you're, whoever the president of the board is at any given time, you are in direct contact with them, and that any time, and and the people in the building understand that all the complaints should go to you, because this idea of random complaints down to the gym isn't actually scientific enough, right? So complaints about the gym should go to the president of the board, and then the president of the board relays the information to the gym, and that way, for one, there's a good record that's kept over the years, and it's also, it's a way of requiring, therefore, the gym to make the changes, because otherwise, they're not in compliance, right? What we've heard on some other gyms is, no one ever told us there was a problem, and it didn't come up until the hearings, right? And so, because there wasn't any kind of formal mechanism for making the complaints. So maybe that could be one of the conditions, that between the board of the building and the gym, they set up a protocol for informing each other, or let's say the board informs the gym of noise complaints, and the gym informs the board of mitigative measures that are being taken in response to the noise complaints going forward.
And if the board isn't satisfied with it, they reach out to us and
Yeah.
say that they're out of compliance.
Right, for example. So maybe we could do something like a 5-year term that way. Because then you see that you've got and you could easily call the board and say, it's not working out.
Okay, well, I'm a tax attorney, not a land use attorney, so I'm not in a position to assess.
But tax attorneys make deals, right?
Yeah.
So, constantly.
That's true.
So if you were making a deal with the IRS, what kind of, similar, it's just, that's all it is, right?
Yeah, well, I would be looking for something, I would be looking for a shorter term as well as some kind of interim mechanism, procedure by way that the board may regain or retain jurisdiction.
What's the benefit of a shorter term for you? If you have the opportunity to always, if they step out of compliance, you can call the board, set a complaint, and then they will be brought back in for a compliance hearing. What is the benefit of a shorter term at that point? I'm asking sincerely.
Well, again, I'm not a land use attorney, so I don't know other than, I would imagine, and I don't know, I would imagine that it is easier to withhold a permit than to revoke a permit. That's a guess. All I really know is that, when we were here 3 years ago, our council at the time, didn't identify any other alternative that we could use. So unfortunately, I'm not in a position to, to know for sure whether or not what's being proposed is going to be adequate.
Mr. Lee?
Yeah.
Would you, as current president of the condo board, would you be amenable to setting up a protocol with the gym? If it's not directly you, maybe it's someone else on the board who would be able to operate in the way that the commissioners were discussing?
I personally would be, happy to have that kind of arrangement, provided that it, gave us an opportunity to come before this board, and that the board was actually in the position to, I've been told that the word enforce is a dirty word, but we need some kind of, mechanism which actually has some teeth.
So I'll maybe explain a little better. The compliance hearing works like this. If there are complaints where you or the representative of the building calls the board and says they are not in compliance with the terms of the grant, right, which would be clear, right, then we investigate and we contact the owner of the gym and we say to them, there's been a complaint filed against you, and we're going to hold a compliance hearing, and this is the date of the hearing, right? And so we actually schedule a hearing, and it looks exactly like what we've been doing. There isn't any difference, right? And the purpose of the hearing is for the property owner to come and say the complaints were unfounded, because here I can prove it, kind of thing. But meanwhile, you have testimony from the neighbors saying, not unfounded, I woke up at 5:30 this morning and I could hear, whatever, I could hear the workout or something, right? So it's exactly the same as what we do if it was a renewal, only it's initiated by a complaint.
And what happens if the board directs the gym to, take remedial measures, and those remedial measures are not in fact taken in a timely fashion? As I said, I suspect there's a difference between withholding a permit and revoking a permit.
So we actually, on one particular gym, we revoked their permit and they had to shut down. So it was a particularly difficult operator, but we've experienced not long ago shutting down a gym, not of this type, but another kind of.
Was that the gym on 17th Street?
Yeah. Okay, so you can see that the board takes it very seriously when the owner is not taking us seriously. Okay.
You know, I should note before I'm done that my fellow unit owner, Mrs. Sadi, is here, and she made a trip into the city, so she'd also like to speak.
Okay, oh, absolutely. Yeah. Thank you very much.
All right, thank you very much.
Coming every time, yes.
Please state your name for the record. You have 3 minutes.
Arlene Asadi, I'm in 2A, I'm directly above the gym. I just want to be brief when you were mentioning who can report to you in terms of the noise, and could it be the residents that are affected rather than the board presidents? Because things change, people move, there's different presidents that might not be affected by the sound and not.
So the idea was to set up a protocol,
Okay.
right? So that, because we've seen in some other gyms, maybe even this one at some point, where the gym is unaware that there are problems, because whoever complained to the gym might have spoken to someone who never told the owner. You know, it could be a staff person receives a call, oh yeah, her again, and then puts it down and doesn't tell the boss that anything happened. So in the end, the owner doesn't even know that there have been complaints. So the idea of setting up a protocol is so that the complaints go to one location, so there's a good record of the complaints. Because if it's just one complaint, that's not enough reason to set up these compliance hearings. It needs to be a steady, poor behavior on the part of the operator, right? So
Right,
that,
yeah.
and that's why we're trying to kind of clarify some methodology where the property owner, the business owner is aware that there's a problem, so that they can make an effort to mitigate the problem, instead of it all waiting until they have to come here and mitigate it in front of us, which is
Right.
very expensive. It's much more expensive if they do it that way. They have to hire a lawyer and sound consultants and all of that, whereas maybe just replacing the treadmills is the answer, right? Or replacing that flooring is the answer, and they kind of know it already.
Yeah, I was really just referring to the wording of who is allowed to report and to contact you. So it's not
Yeah, no,
just.
so that, I wasn't saying only the
Okay.
board president
Okay,
can
good.
contact us. It's about how to set up a protocol,
Okay.
right?
Okay.
And I would think that protocol should be discussed between
Yeah,
you
I
and
don't,
the.
I don't
you
want to
who
get involved.
in
Yeah,
that.
yeah, yeah.
Okay. Okay.
Right.
All right.
Okay.
Happy with that. Thank you.
Thank you. Thank you. Okay. And are there any other speakers on this? Okay.
Could both of you sign in, please?
Jordan Most again.
Have it for record.
So it sounds like that the compliance hearing would seem to satisfy the residents in, first of all, as you point out, the threat of having, the precise threat of having a compliance hearing would presumably result in responsive action from the operator of the gym, because they don't want to come in for a hearing because it costs a lot of money and it takes time, just as an extension of term on a short term does.
Right.
So I don't see much of a difference between a 2-year term and a longer term, because in any event, everyone has now been apprised of the compliance hearing option. We'll, of course, speak with the neighbors and arrange for a protocol whereby, and I think this is maybe not one of the gyms, I think there's always been a direct line of communication to the operator here, not to the front desk of the gym, but to the operator. Mr. Lee and Ms. Asadi know Mr. Krell, and they've been the primary people, and I guess Miss, forgot her name, Katie?
Harley, right?
No, the third floor, but that those lines of communication have been open. At any rate, some sort of method, we'll develop some sort of protocol or methodology, maybe with communication with council, that seems appropriate and acceptable.
Right.
So we would respectfully request the longest term possible, with the awareness of the compliance hearing sort of hanging over the operation of the gym. And again, as was pointed out, I think there has been money spent and conditions have been improved, and to the point where everyone seems happy at the moment.
Right. My personal opinion, but I'd love to hear everybody else's, sort of like to split the difference, that it'd be like a 5-year term with the threat of a compliance hearing. And because we have actually experienced, and, maybe in 5 years, you never know who's actually running the gym. But, it doesn't mean that there's a change in operator officially where they'd have to come back, right? But you never know who the manager is, who might be less responsive, et cetera. And in the case of that gym that ultimately we shut down, it was quite a bizarre set of circumstances where they just chose to ignore everything. So there were no threats. No, no threats were successful in preventing them from behaving the way they behaved. So unfortunately, the bad actors create the status quo. Anyway, okay. So I would like to make, therefore, a motion to close.
Chair Paramoto?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Okay, and I'd like to make a motion to grant on condition. The first condition being that the gym operator and the board of the condominium set up a protocol to keep track of noise complaints and to keep track of mitigation methods that are taken to deal with those complaints, to mitigate the complaints. Okay, that's the first. And then a condition that noise and vibration levels are to be kept so as not to disturb neighbors, and that any disturbances that are created will be corrective measures will immediately be taken to mitigate the nuisance. Or words to that effect. You can make it prettier.
And term of 5 years.
In a term of 5 years. So on that motion, is that okay? On that motion, a motion to grant.
Chair Paramoto?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
And just for the benefit of the property owners who are here, there isn't any need for there to be a condition about a compliance hearing. That's a standard sort of BSA operational methodology. Compliance hearings are conducted on all kinds of properties all the time when a complaint is filed. Okay?
Thank you.
Thank you.
5-minute break.
Yes.
5-minute break? Okay, we're gonna take 5-minute break.
Yes. 12:15, basically. 13 is too hard to find on your clock. Yeah, very. They're much bigger than I.
Thank you.
She's up there.
Okay. Back on the record. New cases on the SOC calendar, item number 8-22290BZ, 8002 Kew Gardens Road, Queens.
This is postponed for failure to give notice.
Is anyone appearing?
No.
No? Did they request a particular date?
No.
Or no, it's just postponed?
No, I
sorry.
didn't request a particular date. We need,
It's a BCE.
What do we want to put it on?
We need to give them the 20 days, so at least a
Right.
month from
Oh,
now.
right.
Month and a half, say.
How about June 11th for May 22nd submission?
6/11? Okay. So new notice goes out.
Yes.
And it's a light one, we have Post Road then.
Yeah.
Okay. Item number 9, 24601BZ, 3511 Prince Street, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond on city board member questions?
I didn't get it.
Gotta get that door.
It was adjourned. It was postponed, so I didn't get it. Thank you. Thank you.
Thanks. Thank you.
Thank you. No, it's good.
For what?
Elise Fullader from Eric Palatnik PC on behalf of the applicant. Firstly, I notified the owner about the graffiti, and they're going to take care of it. They're going to paint. Secondly, thank you for pointing out the hours of operation. I sent a statement of facts revision this morning. And we'd like to maintain the hours that were in the original application, or the original resolution, which was 24 hours Monday to Friday, and then 7 a.m. to midnight, Saturday and Sunday. And then lastly is the parking. You asked for photographs of the parking. That's photographs taken yesterday. You can see it's wet, so it was raining. But the owner understood, similar to the way you understood it, that he'd have a Bodie Fitness sign with parking here, and that's the sign he has. He doesn't have individual signs for each parking space. However, I would like to note that there used to be many uses in this building, and now it's just the billiards and the gym, and that's it. And he added space. He took away a storage space and added a few parking spaces. So there's actually more spaces now.
You don't know how many, though?
There's 52 spaces.
And before there were...
I think 50. But 16 were supposed to be for Bodie.
Okay, good. Any other comments, questions?
Can you just repeat the hours of operation?
Okay, it's on the original resolution, so I want to make sure I'm saying it right. I wrote it on my statement. Sorry, I'll clean that up. Monday through Friday, 24 hours per day, Saturday and Sunday, 7 a.m. to 12 a.m.
And Ms. Holder, can you confirm the total amount of floor area of the PCE, including the proposed enlargement area?
On Saturday, Sunday, 12.
I didn't bring my statement of facts with me. But I did bring this.
12 a.m. to 12 a.m. is 24 hours. I don't understand.
Saturday and Sunday, 7 a.m. to midnight.
Oh, 7 a.m.
Yes.
Yeah, 7 a.m.
Okay, because on their internet presence does say they have a 24-hour facility.
Yeah, I confirmed with the owner that those are the hours, and that was what was on the original resolution.
And both Saturday and Sunday is 7 to midnight.
Yes. It says it's till 10 a.m., but I want to just keep 10 p.m., not a.m. Total PCE floor area.
3 in the morning.
So the total PCE floor area, as it says, existing. I'm looking at the plans to get you there. Just making sure these are the most up to date.
Can't stand this thing.
Says existing PC floor area, proposed enlargement. Total 17,317.55 square feet.
Great.
Okay, everybody got what they need?
Yeah, and it's 42 parking spaces outside, 42 spaces inside, 10 outside.
Great.
And oh, but I thought it went up to...
52.
It's 52.
It was 52, okay.
It was
It was 50.
Was 50, okay. All right, okay then. Are there any speakers on this? So I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on all the same conditions as existed before, plus that the site needs to be maintained graffiti-free. And you noted the hours. Okay, and that seems to, yeah, okay.
Thank you.
Motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, item number 10, 20803BZ, 2555 Shell Road, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
Elise Fullader from Eric Palatnik, PC. I have a handout, but I got a fire department letter of objection yesterday, so
Okay.
I'll just resubmit this, but I'll hand it to you now to discuss.
Thank you.
Yeah, thank you. Violation issued by the SAIU unit and LPPA related to Maharashtra.
Was that submitted by FDNY?
That's just a violation, that's not a letter of objection.
But it does say objection.
Oh, okay. Okay.
Well, before that objection, I got the affidavit addressing parking revised, so it would say that 2569 Shell Road is not for sale, and it does not intend, and they do not intend on selling the property, and that valet parking is provided. I added those two things to an affidavit.
Okay, so just to be clear, the owner of the subject site and the owner of the parking lot are the same?
Yes.
Okay.
And there's what's it called? A certificate of conversion in here showing Jamal Joseph as the owner. They did, instead of a deed, they did a certificate of conversion. I can, and then the other one has a deed showing them as the managing member with the
So
deed.
Shell Road LLC is the owner of both sites? No, one is called 2569 Shell Road LLC?
Yeah, and the other is Shell Road LLC.
So that's two different ownerships?
Yes.
So what is there, a letter of conversion?
Certificate of conversion.
I have no idea what that is. That was in property 201. Certificate of conversion.
It's basically because they're both corporations, one's given to the other in such effect.
The name of the
Just to be a little
LLC?
more clear, if you go into the certificate of conversion, you turn 2 pages, you'll see a bargain sale deed with covenant against grantors acts.
Say that again?
If you look, it's a fancy way corporations give themselves to one another. If you turn in the certificate of conversion to the second or third page, you'll see a bargain sale and deed.
But this is between D&L Realty Associates to Shell Road LLC.
Yeah, because DNL, if you look on Acris, they have the deed, and instead of getting a deed, they did
Deed to where?
for Shell Road LF, so for the subject site, and they did, instead of a deed, they did a certificate of conversion
No,
to
but-
become the owner.
Wait a second.
Chase, can I see that?
I'm sorry.
I can clarify
Yeah.
how that works in a,
Yeah, no, but it's more like, we're talking about two separate sites.
Yes.
Right? And so conveying the subject site to another corporation is very nice, but not necessarily relevant if the parking site is owned by a different LLC.
yeah.
Unless
Of which
they-
he's the managing
They're
member.
both the
He's
same
the ma-
managing member.
Right, but even if he's the managing member, it's not a property interest in common. It's just it's sort of a nice coincidence, right?
So do you want a
Other-
lease from one,
Yeah,
from
so
him
it
to
would be a
himself?
lease between the two, because they are separate. You wouldn't, just for argument's sake, if somebody fell on the property over here, it wouldn't make liable
Wait, but
the
it's-
owner of the
but-
property over there.
But this conversion is converting from DNL Realty Associates to Shell Road, which
Right.
is what
Yeah,
we're getting
he's-
this affidavit from. So they are under the same ownership, the same
There's both-
LLC.
No,
They're
but
both-
DNL is
yeah.
not the owner of the subject site according to what her.
Yeah,
cover
Shell Road
letter says.
LLC.
Not any longer.
I'm
Yeah.
sorry, wait. So Shell Road LLC is the owner of the subject site.
Yes, and 2569 Shell Road LLC is the owner of the parking site.
Sorry,
And the
I didn't
managing,
see the 2569.
and the managing member of both sites is the same. And that's why he doesn't have a lease from one to the other. But I can ask him about getting a lease from himself to himself.
From one corporation.
Yeah, from one corporation to the other.
But the member is a person.
Yes.
Like, it's not, it might be different if the member were the same corporation, which you sometimes see,
Yeah.
right? But in this case, it's a person, and
Yeah.
that person is probably the member of lots of other properties. It doesn't mean those properties have a common ownership.
Yeah, they do not.
Except in the form of the person, so if you pierce the corporate veil, you would go to attack that person, but
This is Law
right?
101. I feel like I'm in law school.
So, so we need a lease.
Okay,
Which shouldn't be hard, given it's the same person.
okay.
Okay.
How long would you like the lease for?
It should be in for the length of the use, right?
Okay. Okay.
Okay.
And then in terms of public assembly,
Thank you.
I submitted with the notice of comments an amended PA drawing that was approved, and they don't have a final right now, because I was told that a final cannot be obtained until they get BSA approved.
Okay. Sorry, okay. I think that that was, the only thing that was open was this issue of the lease, right? That was just to show compliance with the terms of the prior grant. So really, I would have to say, since the owner is the owner, that might even be something you could do as much later in the day second call, right? To create just a standard lease form, like whatever the equivalent these days is of a Blumberg.
This is where the
Between the parking lot
it gets
and-
tricky. He's on vacation. I can ask him. I can call. I have his cell phone number, and I can see if he can get people to do it. But he is somewhere beyond with his family and children
Spring break.
because it's spring break.
Okay, anyway, that's his choice. If he wants to wrap this up today, he answers the phone, he signs a piece of paper, and,
So Lisa,
you know, depends on
Are we
how-
second calling this now?
Yeah, we could try second calling.
I'll try.
Yeah, okay.
Okay. Good.
Interesting,
Thank you very much.
thanks.
Item number 11, 18309BZ, 1400 Fifth Avenue, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony for this board and respond honestly to board member questions? Good, go.
Good afternoon, Madam Chair, Commissioners, Frederick A. Becker. We attended your review session. In terms of notifying the neighbors, we can notify them as we have properly in the past with the form that you provided to us, have it posted in a appropriate place, and provide you with photographic proof of that posting. So as we did on the Borum Place, which you found acceptable, and on Third Avenue as well. I do not have an answer for you regarding the ADA access. I will get that for you. We can provide you with photographs of the conditions, i.e., the plans do show for example, the studio in the cellar, but the padding on the floor, et cetera. So whatever is a condition, we will show you the conditions. And I think the other thing was something about the fire. No, community board never spoke to us.
What do you mean
They never contacted us of a hearing. I mean, this has been pending, this was filed, months and months and months ago, so this was filed in January. They never contacted us about a community board hearing.
Who's handling Veronica's case?
This is Segovia's.
Oh, this was, oh, sorry, I meant, this is Henry.
We can reach out to community board.
Yeah,
and
let's
find out
reach
what
out to
happened.
the community board. I just don't want to, I want to make sure, for one, that they actually did see the application, and if they actually would have comments.
So we have proof of service.
We have proof of, I know, I just,
We have
it's
double proof.
courtesy to the community board, because there was no circling back, right? And,
I mean, we said we have two proofs of service. I mean, we notified them of the hearing.
understood, but at the same time, it's just, that's what the board does. We make sure the community board has an opportunity to say what happened, and if it has an opinion. So,
Okay, no problem.
okay.
There's space next to it.
Next week, but they need to provide photographic evidence,
You want,
how
Oh,
the, of the
sorry,
compliance.
they have to have the next hearing anyway.
right. we
Yeah, they have to have a
another-
hearing for the,
Yeah, yeah. Okay.
So we need.
No, that's
enough-
fine. I have no problem with pushing it out and not too long, but yeah, that's fine.
Okay, well, we need enough time to notify, so at least a month of notification.
3 weeks, all right. I can, sometime in June.
Yeah. Are there any speakers on this, by the way? No, okay.
Fire department?
Fire department has a letter of objection and asks that we hold off until a fire alarm system application has been filed, so you need to tell your client to go do that. And if fire department, do you want to
There's
give any
no-
other additional testimony?
There's no fire alarm filed on
I
that?
will read what fire department says. A review of fire department shows that the space has no fire alarm system installed. The sprinkler fire alarm is installed and was tested satisfactory by the fire department. The applicant is directed to file an alteration type 2 application for the fire alarm system covering the cellar and first floors. In addition, an operating permit was never obtained from DOB, and that the PA application was disapproved in 2014. The Bureau's licensed place of public assembly has been notified of this application and will be conducting an inspection and will issue violation orders for failure to obtain an operating permit. These premises are protected by a fire suppression system, combination standpipe and sprinkler, that was inspected and tested satisfactory. Respectfully request that the board not render a decision on this application until after an application for the fire alarm system has been filed.
Okay, for some reason, I never got that letter, which is unusual since Chief Daley is exceptional in getting me documents. Can you send?
we'll email it to you.
Please just send me that. Yeah, I wasn't aware.
So Tony's making a note, right? To do
Great.
that? Okay. All right, so no speakers on this, and, okay, so you can, so there, because fire department is asking us to hold off until the application has been filed, and I don't actually know what it entails to file an alarm application, maybe not more than a month. I just don't
I
know
understand,
what
I'm not.
drawings
I-
are needed.
No, no,
I
I,
actually know how that's done.
fine. It's end of June hearing, potentially?
Yeah.
We can do mid-June. May 22nd would give you a month, no, more than a month?
Let's have fire department name it. Mr. Chief Daley, do you know how long, what's involved in filing a fire alarm application? Do you need to file drawings
send it to
with
you,
it?
John Daly, Fire Department. The timeframe for filing, I really cannot answer that question. It varies, but I believe once they file the application, we would be satisfied. Then I can form our LPPA unit to follow up on that.
But do you know what an application besides the forms looks like? Do you have to file drawings?
Yes, you
Oh, so you need
do.
drawings.
You have floor plans and riser diagram showing all the various components of the fire alarm system.
Okay.
Yeah.
So that means they have to hire somebody, that somebody has to come to the site and measure, they have to do all that
Correct,
stuff.
yes.
So I think early May is too
Early
early.
June. Let's do end of June, for end of June hearing before, like, whatever, last week, and then week in June is, and then we have till middle of, beginning of June to submit or something.
That hearing is June 25th, the submission date is June 5th.
Great.
Fine.
Thank you.
Works for me. Thank you very much. Thank you.
Appeals calendar, item number 12, 238-15A through 243-15A. This is 102-04, 8/12, 16, 20, 24, Dunton Court, Queens. Come sign. You don't have to be sworn in, just sign. Right there. Sorry. Yep.
Good afternoon.
Hi. Okay. So.
Your name for the record.
Oh,
Jeff Geary.
sorry about that.
Thank you. All right, so I assume you heard our review session?
I was able to listen to the review session. Yes.
Okay, so, as I mentioned, it's been kind of a frustrating application because to get responses to our direction has been like really painful. And so we're left with not having a draft of the HOA that was amended to respond both to council's comments and to the need to include in it reference to the restrictive declaration. It does actually show the parking restriction in it as the one that was submitted way back last year, okay? So what we're going to do is have that be sort of a conditional approval, where until it's submitted, the resolution is not released, okay?
That's
Because
fine.
it's the only way that I can think of finally get this thing submitted. And not have to be here for another 10 hearings. Okay, so are there any speakers on this? I would then like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And make a motion to grant on the following condition. So the first is that prior to the issuance of the resolution, an acceptable draft, acceptable to our council's office draft of the HOA, which includes that the no parking restriction that's already stated in their section 9.14, and includes reference to the restrictive declaration for roadway maintenance, must be submitted and approved by our council, and then the roadway maintenance restrictive deck must be recorded prior to the issuance of the resolution. And that the general, and then the general conditions are that, that no parking is permitted on Dunton Court, that the roadway will be maintained in, you know, let's say, in good condition, or something to that, words to that effect, which may include utilities and so on, and then it makes reference to the restrictive declaration, and by that point, you'll know where it was recorded, so recorded at CRFN, whatever, right? Okay. I think that's it. Any other conditions that anyone wants to mention? Because the street trees and so on are part of actually sitting on their own property, so that's not a condition. Okay. All right then, so a motion to grant on those conditions.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you for your time and your accommodation. Enjoy the day.
Item number 13, zoning calendar decisions, 2016-4265BZ, 25 Bleecker Street, Manhattan.
Good afternoon, Frederick A. Becker.
Okay, I think we got all of the submissions on this, right?
You got the submission, right, today?
Yes, right? Oh, and those notes were added, yes, thank you, Jella. The notes were added to the drawings themselves. I was concerned that there was this one page with all the notes that DOB won't see, but if it's on the drawings themselves, the floor plan. Okay, so then, are there any speakers on this? I'd like to make a motion.
Decision.
Sorry?
It's already on for decision.
Yeah.
Oh, it's already closed.
Oh, it's already closed,
Yes.
sorry. Sorry. I'd like to make a motion to grant on condition. And the condition is that, for one, there's an E-designation for hazardous materials on the site, which would get picked up in the seeker aspect. And that the Landmarks Preservation Commission restrictive declaration be required prior to the board's issuance of the resolution. And I think that was those were the only conditions, right? Everybody else? Yeah, all right, so on that, a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you very much.
Item number 14, continued hearings, 4311BZ, 1926 East 21st Street, Brooklyn. Sign in. Okay, raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and you respond honestly to board member questions? Please proceed.
Good afternoon, Lara Altman from the Law Office of Lara Altman. We'd had somebody attend your executive session yesterday, heard your comments. I'm going to go through a few of the smaller items, and we have a gentleman from the engineer's office here with us today as well. With respect to the DOB-approved plans, we'll be glad to provide a set to your board with the stamp from the Department of Buildings. We'll also provide you photos showing as-built conditions, which I should point out do match the drawings that say they are built. What you saw on Google is outdated. They did build it straight up inadvertently. When they realized their mistake, they've already moved that wall back on the second floor. So that's already been fixed. I know you were looking at Google to see it built straight up. It's not like that anymore. And we'll show you photos to support that statement. In addition, we will provide you the demolition plans that your board has requested. We'll also provide you a zoning calculation sheet and a FEMA map that your board has requested. Now, there was a discussion yesterday of the rear yard. I would point
So
out,
just to,
yes,
this is the engineer.
Yes, it is.
Are you the engineer of record?
No, I'm not.
But you're working.
he's a representative.
I'm a representative, yes.
Can we speak to him?
Please, if I may just show you one other thing, and then I will...
I just want to ask him about the existing conditions.
Absolutely.
Please state your name for the record.
Good afternoon, my name is Hamdan Al-Zindani, and I'm a representative of Balbaki and Associates Engineering.
Okay, and so that firm is the firm of record on the application?
Yes, ma'am.
Right? Okay.
Yes.
So the as-built drawings and what is currently built on site, have you gone to the site yourself?
Yes.
So what you see at the site versus your as-built drawings?
What is as-built drawings is what we see on the site, yes.
Okay, okay. So you'll then provide us with photographs of the as-built condition, photographs, and then the as-built drawings, have those been filed with DOB?
I'm sorry?
The as-bills, have they been
Yes.
filed?
Yes, just to clarify, what they changed now is not what, when I went to the site in the beginning. When we went to the site, we have pictures of when we first went to the site, when we were retained. We have pictures of those.
You're superseding?
Yes.
Yes.
It was a supersede. It was a takeover application, and we went to DOB. We have approved DOB as-built approvals,
Okay,
and that's when they moved the wall back.
okay, so you directed them, move this back.
Correct, comply.
So can we get a copy of the stamped DOB
Approved
approved
drawings.
as-bills?
Yes, ma'am.
Okay, and then also, so when you superseded, did you, is this the project that you're working on? Is this your project?
There is a couple people working on this project.
Okay, in addition to you, or?
Yes.
Okay,
Yeah.
so when you were you superseded, did you review the drawings for compliance with code zoning that so-and-so? Because you took over somebody else's drawings?
Yes, of course, we reviewed everything, yes.
Okay,
There was a non-existent front yard that we were aware about. The second floor was built in error, and that's why they moved it back, because in the front yard is requires 15 feet.
right, okay.
But the front yard is existing non-compliant.
Front yard had been an existing,
Yes, on the first floor.
Yeah.
For the first floor is existing non-compliant of 10.44 feet.
and so when you were, so this is a little tricky when you're superseding, right?
Mm-hmm.
It's a new construction, right? The house burned down.
Correct.
Right? So they would have had to persuade DOB that it was being rebuilt within whatever DOB's timeframe is for reconstruction, right?
Yes, for
So-
the existing conditions the way it was, yes.
To be able to take advantage of that existing non-compliant
Correct.
condition, right?
Correct.
So did you review that kind of information?
Yes, we did.
You did, and you concluded that the prior drawings, let's say the prior approval was
The-
consistent?
The pre-existing?
Yeah,
Yes.
and that DOB reasonably concluded that it was a pre-existing condition?
Yes.
Okay, okay. Okay, I appreciate that, thank you. Okay, I don't know, what other, I have other questions. Oops, I just lost it. What's the interest on this in 21st? Sorry. Okay. Yeah, so, okay, so the other thing that I'd like is a copy of the DOB-approved plans that were originally approved, as
Okay.
opposed to the as-bills, right? So, and to show that they were approved by DOB, because we only have like a copy of what was approved.
Okay.
We have, no, we have a drawing that says it's an approved drawing,
But it's not stamped from the DOB?
but it's not a
Okay.
DOB approved, right? It seems like it's a copy of what was approved, because
Yes.
I understand when you're superseding, you're not adopting necessarily somebody else's drawings. You drew them again from scratch, is
course,
that it?
yes.
Yeah, okay. Okay. So, but you drew them, you copied the ones that had been approved, so if we could get a copy of the ones that were approved, that way we can compare them to your as-built.
Okay.
And to the extent that there's a difference between the as-built approved and the DOB approved,
could you circle that, just highlight it with a yellow marker, that kind of thing?
Sure.
Okay. All right. And this job is not self-certified, right?
No, it was not.
Okay.
It went through plan examination.
Okay, good. And, oh, okay, so, and then in terms of, you know, what the, so we haven't seen you here before, but so the rule about these kinds of enlargements under this special permit is that we try to retain as much of the existing building, and when I say existing, the thing that's built right now,
Okay.
as possible, right? And on one of the drawings, the second floor, it shows the front wall of the house being replaced. Is that simply that you were correcting the error in the as-built? Or
Correct.
so that's a different thing? You're
Yes.
correcting it
We were
back? to what-
correcting, we were moving them back, yes.
Okay, so on your drawing, you should treat that as the existing condition because it's already been moved back, right?
Okay, so treat it as existing condition.
Yes, because you've already directed the contractor to move that back. It
Yes.
doesn't comply.
Approved by DOB.
Okay, so you should give us a photograph to show that it's actually existing in that place.
Okay.
And on your drawings, show that front wall as an existing wall, okay?
Okay.
And just make sure that that's the case in all the sections, that they're all agreeing with each other.
Yes, ma'am.
And then, this is more like a DOB interpretive question, and we're going to ask for a note to be added to the drawing. So when you're measuring the floor area in the attic, you're measuring it from basically the drop, so rather than just from the rafters, you're measuring also from the joist that goes across.
Correct.
And then you're saying, that's my structural headroom.
Yes.
We're just not sure what it is that DOB considers the cutoff in terms of height. Structural headroom being the rafters, or
Yes.
structural headroom being that cross joint, right,
As-
joist.
As per New York City zoning resolution, definitions of floor area, what's not included in floor area is any level that is below 5 feet.
Below
Any-
5
any-
feet?
Yes, any area that is below 5 feet is not included in floor area.
Right, but you're showing structural headroom of
4 feet
Oh,
11.
that's 4 feet 11, right. But you're measuring it to the underside of the cross, what is that called? Cross brace? And as opposed to the rafters. And my question is, I actually don't know what DOB does because you don't have that many cross braces, so there are a lot of places where the ceiling is high.
Correct.
So and it's true that there's constant ducking the way you're doing it, but I'm just not sure I'm just not sure how DOB would do it. So the reason that we wanted therefore a note on the drawings.
Okay.
And the note on the drawings is that the BSA is only approving the amount of floor area currently shown on your plans. And to the extent that they consider any more of it floor area, your attic will need to be reduced in size, okay? So the maximum that we're considering is 1 FAR total, which would include however it is you measure that attic. So you cannot have any more, and so there needs to be a note to that effect on the drawings, okay? The DOB will review the drawings to confirm that there's only 1 FAR in the building, and in particular, only whatever many square feet you show in the attic of floor area, okay?
Yes, ma'am.
Let's see. All right, then the next part, I think, might be in the Weir department. The other thing that we need is just sort of a standard thing that we do, is even though I think you have plenty of existing exterior walls being retained, you need to calculate how much of the existing exterior walls are being retained and how many are being demolished to allow for this enlargement, and then do the calculation. You're doing it in percentages, the percentage of exterior walls to be retained to allow this enlargement, okay? And when we say exterior walls, it's the exterior walls that are being retained on the exterior. So to the extent you might, not that you are on this, but you might be keeping some exterior walls in your addition,
Okay.
that doesn't count. It's only what's kept on the exterior of the building on which it rains, right? Okay, and then that goes also for the joists. So you should indicate on the drawings which joists are remaining in place. You can do that with like a hatching. This hatched area joist will remain. And what we're trying to do is maintain a minimum of 50% per floor on each of the joists, which I think you're doing anyway because this is a straight line extension, right?
Yes.
And then the other thing that's missing, which might be a LIRA thing, but really you fill this out, is the BSA calculation sheet. There's just a form that we always use, which is a little...
He's already seen it.
You've seen it, okay, so that needs to be filled out. And then, yeah, I think there might be an FAR calculation error. There was a comparison chart that you prepared, or your office prepared, that indicates that the building as approved by DOB and as built has an FAR of 0.8, which would exceed the allowable maximum FAR, so I think that's a typo.
That could be a typo, yes.
But just correct that. And let me see. You said something about the rear yard. What did you say, 49-foot rear yard?
Per plan submitted, DOB approved plan maintained a 49-foot rear yard, which is, doesn't correspond with what's stated in the statement of fact.
Oh, so that's a earlier question. Okay, I just want to stick with what the architect should be doing.
I'm sorry.
Okay.
If architecture, my question was along the way the attic wall, the roof is sloping.
Yes.
The existing slope of the attic, and that, I guess, ties into the whole FAR calculation.
Okay, so it's just, you mean, at what point does the structural headroom exceed the 4'11"? Is that what?
Yeah, because the slope of it, of the existing and what is being added is the same, as I understand. It's just it's a straight line extension.
It's a straight line, yes.
So when I look at the attic plan, the extended section, that's being not counted towards floor area.
Correct.
However, there's a portion in the existing section that's being counted towards floor area because that's where the bedroom is.
Yes.
Yes. So
That's
that's maybe part of it, since the roof line is the same all the way back. I see what you're saying. The roof line is the same everywhere, right? But in
Yes.
certain places, you've got your cross bracing. It's not even cross bracing, because you have higher cross bracing at 7 feet, and then you have, which I don't
Another
even
one at
understand, like,
4'11".
why would you have that bracing? It's not doing anything. Why would you have that bracing at 4'11"? Right? It's not doing anything. The only thing you need is the one that's holding the roof from going like that, right? That's the one that's up at 7 feet. So what do you need the one at 4'11", except to be artificially reducing the apparent amount of floor area up there? That we don't allow.
Okay.
So I would say you need to look at that again, because it's looking to us like you're creating much more floor area, and it's easy enough to just tell the contractor, you know what, forget those two pieces so that we can have a full head height, and then that's slipping in more floor area, which we're the ones with the authority to grant that. So you actually need to redesign that roof so you're not getting as much obvious floor area as apparently you have. Now I understand. I didn't understand what you said yesterday, but now looking while you talk, I understand. Yeah. Okay, do you understand what I'm saying?
Yes, yes.
Otherwise, so that means your roof needs to do something different in the extension if you're going to keep the amount of floor area, whatever it is. Did you make a note of what the attic floor area is? I didn't.
No, I
Okay.
can look it up.
Yeah. But, right, so the maximum allowable floor area, oh, there you go. The maximum floor area that you can have on the roof is what, at the attic is what you show, and you're kind of arbitrarily picking areas that aren't floor area in exactly the same roof line. So you need to, say, at the rear, which actually would be really good because the building is too tall at the back. So if at the rear that's no longer floor area, drop that roof line down to be a legitimate 4'11" without kind of these artificial cross braces. And then you do it, right? Except for, what is that?
Those are two bedrooms.
No, the grade area, that's not floor area.
No, that's not, those are closets and bathrooms.
Closets and bathrooms are floor areas, so why don't they show a structural headroom? See, that's what I mean. If this is a bedroom and that's the same roof line, yeah, you need to
That's
look
really-
honestly at, when your roof is doing this, it's true that at this point, for sure, that's under 4'11". But at this point, it's 7, and you're showing that it's creating enough area of bedroom all the way to something like 4 feet off the edge of off the building wall, right?
Correct.
So it means
This would
that.
almost continue.
Yeah, it
all
would
the way to the
continue
back.
all the way back and all the way front, because you're not doing any, because I don't see those dormers on the.
No, it's not there in the roof.
And you don't have, you have dormers? And there's dormers, so you're
It's
even
in the
getting.
front. That's in the front, that's counted.
That's counted, yes.
That is counted, that's the family room.
Okay, but what about in that corner?
It's not.
No, these corners, the front corners.
Oh, let me look at the elevation.
So, because some of it is we don't have sections through everything, so we can't really
I have,
see.
is it possible if I could show you a
Yeah, yeah.
section through that space, through the bedroom?
Yeah,
Where there's,
we have the set of drawings right here, if it's,
I'm not sure if this was included in it, but if you can see here.
yeah, that's what I'm talking
This is
about.
the 7 feet, that's counted as floor area.
Yes.
And now, like you said, the slope of the roof, this point right here is
Mhm.
4 feet 11.
Right,
And
that
that's-
we
and that's-
understood.
And that's controlled by the slope of the roof.
Right.
Now, to continue to have this deduction, there's a structural number that we put over
Right,
there.
but that's what I'm saying, that's the artificial structural member, because the only thing the only thing you need structurally is this one up top that prevents your roof from splaying out, right? These are artificial to create, I don't know what, but if you look at your floor plan, it shows that you've got bedrooms right underneath that area where elsewhere, yeah, you've got bedrooms
Right
here.
And then this is. what
But this
we do
is the
best.
area where you're artificially creating not floor area. So in order for you to reduce the floor area here, yeah. In order
Are
for
we
you.
talking, I'm sorry.
Yeah, that's what
Are
we're
we
talking
talking
about.
about these two members?
Yes, exactly.
Okay.
Yes. So you need to take this area, which is obviously going to be floor area, because it looks like your whole roof is the same, right? You need to drop the roof height down here, so you'll have a drop in the pitch. Yeah, it'll do something else there, so that this is actually below 411
Yeah, this needs to
everywhere.
come down.
Right, exactly. And that'll be great, because then it'll lower the apparent height of the building in the rear, because what's unfortunate about this is it's too tall going all the way back, right? Okay.
Yeah, I don't see a structural function
No,
for
this
what you
is-
described as a structural
Yes, exactly.
member. If you were analyzing this, are you a structural engineer?
No, I'm not, sir.
Okay, if you're looking at this as a truss member, this is something we call it zero member. It means that it doesn't have force in it because of the configuration that is shown on the drawings.
Okay.
So it's either, I don't know, maybe you could rearrange the elements to make them structural effective, or just eliminate these two beams, horizontal beams, because they don't, yeah, structurally.
Not
they-
required. Is that what you're getting at?
Yes, if you look at the right side, you could get the impression that, yes, this kind of member is receiving some force because the roof is like that. And
Leaning on
it's
it,
doing
yeah,
this,
yeah.
so it's holding.
Don't need it.
But in order for a member to be holding, it's not just need to be connected to an element that's transmitting load, but it needs to take this load and give it to some sort of other member.
Right.
And if you look on the other side, you have a post, and the post cannot take significant horizontal force. So
Right.
actually,
That's
this
the point.
horizontal member is,
Right, if anything, it would go all the way across.
thank you.
It would
Yes.
go- Yeah.
I learned that about Notre Dame, right? The arches of Notre Dame are being prevented from going out like this
By a
by
high
the
member.
flying buttresses,
Yeah.
right? But then they were concerned when the arch was in danger of collapsing, that the buttresses would push it in.
Yeah.
Yeah. See?
Thank you.
You're so right.
Okay. So, right, so I think we covered everything. Thank you very, we really appreciate that you are here. It makes it a lot easier. And I think.
I'm sorry,
Go
I
ahead.
would suggest instead of this configuration, it's up to you. You could make it one beam all across, like instead of 3 members, one at the top and 2 at the bottom, make it just one beam, and just lift this up like 6 inches.
Lift what up?
Lift these 2 beams
Then everything
up
will get
and
counted towards
bring this
floor
down
area.
and make it like one continuous.
Okay, but then he has a problem because he doesn't have adequate structural headroom. He needs his 7 foot so he can occupy this place. And then, so what we're talking about, so the magic number is this 4'11" that creates floor area, right? He's trying to keep it down below 4'11". We're saying, fine, keep it below 4'11", but don't try to have it both ways. So at the rear of the building, drop that roof line down, so it's 4'11", so you'll have some kind of a split hip roof, or you can, whatever it is your design wants to be, to just do that, okay?
Okay.
All
Thank
right,
you very much for having me. Thank you.
Thank you. Okay, so, and then, Ms. Altman, you got the list of other things, so we need to justify the straight line extension into the rear, like we always talk about?
This is actually the set of BSA-approved plans for the home to the right of this home. This was approved with a 20-foot rear yard for 2 stories. It was built as such as well.
Okay, so, but we need the, you know.
Of course, we'll show that to you.
Submission that
Of course, we will submit it properly with the rest of it. I was just showing you for discussion
Not just
purposes
this,
today.
no, but, you know, normally there's photographs of the rear yard, you're looking around, what you're doing is you're justifying why the building
course.
should be allowed to extend all the way back to the point it's extending on those 2 floors, and now your attic is going to drop down, so
The
that'll
attic
make
is
it a
dropping.
lot better of an argument, but you're imposing on the neighbors, both to each side and to the rear. So the argument is, why should you be allowed to do that? And the correct answer is because either everybody else did, or a few did, or something.
So we'll show
right?
this information to you.
It's an urbanism argument, and I'm also letting the architect know,
Right.
because
Well, Hamdan and I did some research on this yesterday as well, so we have
Okay.
some information to support our argument. We'll give it to your board in writing.
And then, what was the other?
There was an error in the statement, a typographical error. I apologize for that. I will, of course, have that corrected.
Okay, all right. So understood, instructions understood?
Completely
Are there any-
understood.
Are there any speakers on this one? Okay. So, how much time?
Can you have this ready for me? Can you have David ready when I- If we could have June 4th, that would be a submission in approximately 3 weeks.
We have the first on June 4th, so no.
No? Okay. Because it's a heavy day. And the next, June 11th?
June 11th,
June 11th, we have-
unfortunately, we can't do June 11th, or I can't.
Can't do June 11th. They can't do June 11th.
Oh, okay.
No, actually, because June 10th is a no-work holiday for our clients. I can't,
June 25?
until sundown on that Monday is a no-work day.
June 25th is 20.
That's okay.
June 25th? June 5th submission.
We can make that work.
Great.
6/5, 6/25.
That's right.
Thank you very much.
Thank you, appreciate architect comment.
It's June 5th submission for June 25th hearing.
Item number 15, 2017-20BZ, 555, 550 Fifth Avenue, Brooklyn.
This is just an adjournment.
Good afternoon, Todd Dale for the applicant. We'd had a discussion with board council. We're clear on, or not, board staff and council, we understand what to do, so.
Oh, great.
I don't know what, we can be flexible with the board schedule, but I don't know if there's any possibility of doing the last hearing in June or the first hearing in July with a corresponding submission date.
That'd be either June 25th, which has 21.
So let me, this one is the Dara, does
don't
Dara
have
have,
the,
she doesn't have?
Oh.
Yeah, I don't have an up-to-date one. This is because she has to review this financial.
Understood.
Either one. It's
Either
fine,
one.
yeah.
Okay, so it's either June 25th or July 16th, which has 7 cases.
Should leave yours in the office?
Give it July 15th. I mean, July 16th.
July 16th, yeah. June 26th submission for July 16th,
6/26 and 7/16.
7/16.
So noted, thank you.
Thank you. Did you get that, Ms. Mathias?
June 26th, July 16th.
No. Oh, yes, that's right. Yeah. Sorry. Yes, that's right. Thank you.
Okay, item number 16, 2017-34BZ, 311 Adams Avenue, Staten Island. This is also a request for adjournment.
Hi, Todd Dale again for the applicant. It's taken a little longer for the new architect, especially with review of the flood, which is one of the issues. They're estimating 7 weeks to submit, but we can be flexible with the board's schedule.
How about the same schedule?
Is that the same June 26, 7/16?
Yeah, and I think that gives you enough times. That's 1, 2, 3,
That would be perfect.
6, 7, 8, 9, 10. It gives you 10 weeks, yeah. Okay.
Since I will be here anyway.
Okay. So
Right,
submit
thank you.
on June 26th for a hearing on July 16th.
Thank you.
Thank you.
Item number 17, 2018 8BZ, 1820 Cropsey Avenue, Brooklyn.
Elise Fullader from Eric Polanic PC. We'll take the best date you have. We're about ready to file, and I heard the compliance officer visited and met with the owner, so that's very nice.
And met with the owner.
Yeah, he was apparently there. They hung out for the day.
We're full service. Okay.
Earliest? I mean, could you submit by Friday?
No.
No.
Okay. Just,
I meant best date you have where we can put together an entire submission.
Well, like what? Is that a month? How much time do you need to put together your submission?
I would say like 2 or 3 weeks.
1, 2, 3, that's the latest, that's May 8th. But this is a reinstatement. May 15th is, I'm sorry, June 4th is frick, so no. How about June 11th? We have 18 cases on June 11th?
That's fine.
Okay, so May 22nd submission for June 11th hearing.
May 22nd?
Yes.
June 11th. Okay, thank you very much.
We'll let the neighbors know. Item number 18, 2018-53BZ, 104 DeGraw Street, Brooklyn. Is all your people here? Okay, so everybody's got to stand up, raise their right hand if you're going to present. Are you an architect too?
You said they were just a minute away and then.
All right, so I'll swear him in when he comes in. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? Okay, so sign in and proceed. Yeah. Yeah, that's it. There you go. Okay. Yeah, good to see you.
Good afternoon, Ben Stark from Slater and Beckerman PC, here for the applicant, Brooklyn 11201 LLC. Yesterday, I attended the board's executive session and listened to the comments of the commissioners, and I just would first say that we intend to prepare a written submission responding more to each of the points that were raised at yesterday's executive session, but I wanted to orally address some of those comments today at the hearing. There they are. This application demonstrates that the subject property suffers from unique physical conditions that give rise to hardships in conforming strictly with the zoning resolution, and we will have the application's record reflect that. First, we think it's important to restate this application's foundational argument that the subject property has a unique physical profile, and that this profile is comprised of individual unique physical conditions that collectively create practical difficulties and unnecessary hardships in conforming strictly with the zoning resolution's use provisions. These four conditions together constitute unique physical condition within the meaning of 7221A. It's underdeveloped, vacant condition, it's narrow width and small size, its interior location, and the immediate adjacency along both of the subject property's side lot lines of non-conforming residential buildings. Yesterday, comments were made at the executive session regarding the subject property's uniqueness in the context of 7221A that are simply factually inaccurate. Generally, statements were made that the subject property is not unique because there are similarly sized properties located on the same block as the subject property or in close proximity to the subject property. The truth is, and the record shows, that there are not similarly sized and situated vacant properties on the subject block or in close proximity that are bounded by non-conforming residential use along either side lot line. There may be similarly sized properties located on the interior of this block, but they are not vacant, let alone both vacant and bounded by non-conforming residential use along both side lot lines. This is fact. The fact is that these four conditions give rise to hardships in conforming strictly with the zoning resolution and the use and development of the subject property. Those hardships, each of which limits and frustrates the marketability of a building constructed in conformance with the zoning resolution, are quantified by a financial analysis showing that as-of-right development of the subject property is simply infeasible. To the extent that as-of-right uses are feasible elsewhere in the study area, they are not feasible because properties elsewhere in the surrounding neighborhood do not share all four physical conditions, which in their totality, and as previously mentioned, are unique. Yesterday, comments were made at executive session dismissing our contention that 7221A was found just 6 years ago at a site identical in every physical respect and located a mere 35 feet west of the subject property, that it would be arbitrary and capricious for 7221A to not be found in the present application. It was remarked yesterday at executive session that times and economics have changed since the board's finding of 7221A in regard to the 96 through 98 DeGraw Street case. We disagree. In 6 years, the world and the economics of speculative office development have not changed. To our knowledge, there has been 0 speculative office developments constructed in this neighborhood or district in that time frame. 0. And to suggest that the WeWork model of office development is viable in this neighborhood and at the subject property is to speak to quantifiable hardships. In other words, the B finding. The application does quantify its hardships and summarizes that the marketability of the subject property for as-of-right commercial development is frustrated by its small size, its vacancy, its interior lot location, and its position sandwiched between two non-conforming residential buildings. Again, the collective presence of the four conditions is unique. To our knowledge, other than 104 DeGraw Street, there is only one other property in the entire neighborhood or district that until recently had these same conditions. That property is 96 through 98 DeGraw Street, 35 feet to the west, and that property was granted a variance just 6 years ago. So, to the charge that granting a variance in the present case would effectively rezone the neighborhood or district, we find this unquestionably refutable by fact. Other than the subject property, there are no other small vacant interior lots that are adjacent to non-conforming residential use. The subject property's physical profile is therefore unique. Its physical profile creates quantifiable hardships in its marketability, and this application's record will conclusively demonstrate this. Alarming to us is a misconception about the relationship between the proposed mixed-use building and an alternative as-of-right development scenario that includes office use. We want to make the following statement crystal clear for the record. In following this hearing, we will be submitting written materials at the same point. The proposed mixed-use building is intended to be operated by a single live-work user. All financial assumptions regarding the expected return of the proposed building assume such. Bluntly, the proposed mixed-use building, which our application cites an estimated office rent of $55 per square foot, relates only to this live-work arrangement. We will be submitting revised financial materials, including support from the local commercial broker community that shows that no one, and I mean no one, is paying $55 a square foot to work in that building unless they're also living upstairs. We, as the applicant team, made a good faith assumption about the return expected for this unique space in its unique live-work arrangement. We respectfully ask that the board appreciate that nuance. if the proposed mixed-use building is leased to a different commercial and residential tenant, separate tenants, the commercial space returns far less than our assumed $55 per square foot. Why is this so important? It is crucial in understanding the hardships caused by the property's unique physical conditions. As stated in this application statement of findings, the subject property's position, wedged between non-conforming residential homes, is unique in causing of hardship by its limiting of the marketability of the subject property for a conforming use. That limitation on marketability is dependent on who the commercial tenant actually is. Who are they? What do they want from office space? For those commercial tenants who are attracted to the prospect of living a flight of stairs away from their workspace, the presence of residential neighbors does not have as big of an impact on marketability. The need for additional square footage is not as important. However, for a prospective commercial tenant who is not going to be living upstairs and not going to be sharing a cup of sugar with their neighbor, or not going to be asking the neighbor to feed their cats when they leave on vacation, the presence of residential neighbors attacks the very reason for locating their office down the block, or down by the docks, away from downtown in the first place. The subject property's isolation, the freedom that it would present to make noise, or have a gallery open, or do a pop-up event, or throw a party until the early hours of the morning. The subject property cannot accommodate those types of amenities, the amenity of being in that location.
Sorry, I have to interrupt with that one. So in Chelsea, for example, because Soho doesn't really even have any galleries anymore, but when it did, and there were openings, you mean to tell me nobody lived upstairs?
I'm sorry, what's the?
In Chelsea, in the gallery district, or in Soho, when it was a more lively gallery district? Are you telling me that nobody lived upstairs of the galleries when they had openings?
I don't think it's appropriate to compare the office market in Soho to the office market and the types of tenants who would locate in the Columbia waterfront district.
Why?
I believe, again, that drawing those loose comparisons they're not appropriate. There's a variety of other factors that factor into a tenant's co-location in the center of Manhattan.
You just said that a gallery user wouldn't want to be there because then they're having gallery parties, and the gallery parties would disturb the residents who are located next door or upstairs or whatever, and therefore they wouldn't want to locate there. So I ask, well, how can you make that statement when in the Lower East Side, which is also a prominent gallery district, many of the galleries are located in the lower levels of residential buildings, as they are also in parts of Bushwick, and I can go on and on because we have lots of gallery neighborhoods now. Many of the galleries, if not most of the galleries, are located in the lower floors of either residential buildings or adjacent to residential buildings, so it isn't sort of a vague comparison. We have lots and lots of similar uses, and you're the one who set up the concept, the example.
I think maybe my statement was misinterpreted. We didn't look at what the expected rent would be for a gallery user. If that's something that the board would like us to do, we'd be happy to take a look.
No, don't change the subject.
I'm not changing the
looking at
subject.
rent for a
Let me respond to your comment. We looked at the marketability of the subject property for a conforming office user. My statement is that the types of tenants who are looking to rent office space in the Columbia Waterfront District do so in part because of some of the other non-primary activities that they can then engage in such a far-flung area. It is attractive to locate your office in that neighborhood if you can take advantage of what that neighborhood offers to you, which is, in a way, the ability to be a bit of a nuisance, the ability to drive the car up onto the sidewalk, the ability to throw a party until 3 a.m. I know many friends who...
I don't think you can ever drive your car
I
onto
don't
the
think that's-
sidewalk in anybody's
districts.
Well, then I don't think you guys have spent enough time in the Columbia Waterfront District to see how the...
Sorry, it's illegal in every district, so to use that as a standard is just not going to work out.
Move away from
I think I can appreciate what his argument is that it's without there being a residence there, less people are making calls complaining about the nuisances of having an office in that building.
Call the M districts throughout Manhattan.
Yeah,
right?
I'm just paraphrasing what his argument is.
I know,
not
I
to-
hear you, right. But it is called the M districts in Manhattan, right? The flower district, that's one of my favorite ones. People live upstairs and all the flowers are moving around. And sure, people are complaining about the nightclubs that are located on the block, but nonetheless, they're there.
As I said, we can't speak to the marketability of similarly sized spaces in the middle of Manhattan. That's not what our application is addressing. We're speaking to how the unique conditions at the subject property affect the marketability of that property to accommodate a conforming
Right, but
tenant.
first you have to convince the board that you've got a unique set of factors that lead to a hardship, not that there's a market issue at this site. And so I think that maybe one of my comments was misunderstood, but what I was saying is that I think that we as a board have to take care as to what range of acceptable frontages and widths qualify for uniqueness as being too narrow to function. And so whereas a 25-foot wide lot in a manufacturing district, one could argue that that's too narrow to have a large floor plate that would be attractive to manufacturing, and that's kind of like something that the board understands, and clearly there's a lot of precedent. With 35-foot width, it's not as convincing on the outset, and so therefore I'm not there. And because a 35-foot width could give you a more attractive floor plate, I'm not sure that even the adjacency issue of residential is as much of a problem, because you have more space. And that space could also be used to insulate you from your surrounding areas. So you also have more options in terms of how you would want to develop your property. Because you have more width, you have a better potential floor plate. And so I am not convinced that you actually have a unique situation that is a hardship for this site. You have to do a little bit more to convince me there.
Okay.
Then, after that, if I'm convinced, then we could look at B. Because it's so easy to make a market case here by saying that manufacturing isn't going to be feasible. Well, that's because manufacturing on such a low scale, low density is dying. It's dying throughout the city. So it's very easy to make that kind of comment, that kind of a case, but it's really a market-based case. And it's similarly easy to make a case about commercial presence in this area not working for market reasons, because the rents are really low. And kind of, you know, to purchase this property, site values are so high that other than getting a tippy-top rent, you're not going to make a go at it here, period. So that's why I want us to put A to bed, satisfy A, convince all the commissioners that there really is an A case here. Then let's move on to B.
And I think it's a difficult one, but in addition, well, this is kind of going back again, where maybe that's part of the market argument, but you had said in your own papers that the building would be sold either or rented either as one unit or optionally as 2 units. And then you said the board misunderstood, but I got that from your papers, so.
I'm happy to respond to that.
Let me just finish my sentence. And then the other is, again, which we've raised both in yesterday's review session at the last hearing, if an adjacency to a commercial use is a problem for a residential use is a problem for a commercial user, then why are you building a building that has residential above the commercial use, and it's actually sharing party walls, sharing demising walls, which isn't even really allowed under the zoning resolution, is supposed to be really separated. And so in a certain way, you're creating more of a nuisance, if you want to call it that. But then I go back again to the same question is, since when in New York City, anywhere, and I don't need to just be in Manhattan, I can be throughout New York City. And by the way, we have the mixed-use districts that even encourage manufacturing and residential to live next to each other and on top of each other. It actually says that in the zoning resolution. So since when is light industry or office use incompatible with residential use, that's the part that doesn't make any sense to me at all. So I don't understand the idea of adjacency to residential as being an impediment to use this for those kinds of activities. And we're not saying, and as Commissioner Otley Brown said, I'm not expecting it to be a shipping location because we don't even have those anymore. We've just had in the prior case, the idea of shipping is pretty much reduced to kind of little lightweight boxes that move from here to here. So if anything, it's a cupcake maker or a little catering company or something like that that comes into a place where they're light industry. And and it's incorrect. For one, we were not talking about the WeWork model. That's not correct. We were talking about other cases, and that's an incorrect statement that there are 0, because we had specifically another case where the proposal was actually for an increase in floor area in an M1 district to allow more office space for a user that it wasn't really a WeWork model, but it was tiny desk space in what was basically, I think that might have been a 25-foot wide building, where the operators of this thing have many other of these kinds of uses scattered around the Brooklyn area, the kind of the hip, cool neighborhoods, because they're finding that there's actually a need. So, and apparently they have a going business of that. So, incorrect that it's 0.
My comment about there being 0 speculative new construction office development is in relation to this particular neighborhood or district. If you're aware of new construction, speculative office development in the Columbia Waterfront District, that would be news to us, and we're happy to hear about that from the board staff after the hearing. But I'd like to respond to...
Isn't this a spec project? Yes. I asked you at the first hearing, is this for a particular user? No, it's a spec project.
I said, to our knowledge, there are no other new construction...
No, that's not what was my question. At the first hearing, I said, this looks like a purpose-built building. Is this a purpose-built building? No. It's being built speculatively. There is no tenant in mind, and it's not going to be owner-occupied or anything like that. So then we moved on, so it's a spec project.
Okay.
Spec project with an office, maybe live also inside.
Happy to clarify that again as well, and happy to get back to some of your comments and some of your comments from a second ago as well. So this project is a speculative or speculative mixed-use development because the owner and developer of the property cannot, under the oath of this BSA hearing, state that they wouldn't lease out the property. It is speculative because we were up here at our first hearing and you said, is this being built only for the owner? And we can't make that guarantee. So we're speculative. But what I had said earlier, and I really hope that the board can appreciate this, that the intended tenant for this mixed-use building is a singular tenant. And that is important because if it is a singular tenant, simply put, the office space is worth more. If the person can also live upstairs, it's worth more. So we don't think it's appropriate to look at the way the hardship is being, the hardships present that faced by the subject property, as if the residential portion of the building doesn't exist. It would be one type of tenant who would lease space in a only office building, a building only with office uses, and it would be a different type of tenant who would be in the market for a live-work arrangement. And the amount that each of those parties would be willing to pay is different. And that's just a fact. And we're happy after this hearing to work with some members of the local broker community to show you this. So earlier you had raised the issue of that you didn't think that we were getting past A. That you don't see that there are conditions here giving rise to a hardship. I want to clarify that the question, Madam Chair, is not whether or not office use is incompatible with neighboring residential use or or is somehow, just incompatible. The question is whether or not the adjacent residential uses have an impact on the marketability of that space and how it relates to the other unique physical conditions. I'm seeing some heads shaking, but the fact is that hardship has two sides. Is there a physical condition that is frustrating physical development? Is there dirty soil that makes it cost more to build? Or are there physical conditions that impact on the back end, the return? And when we look at variance cases granted in the last couple decades, we see that the marketability of a specific space does go to a hardship. That's how we analyze the impact of hardship on the back end, by understanding, well, if this space was built out, how is it that those conditions would impact a return?
But that's first, that only comes after you've proven there's a unique situation that provides a hardship, and then you explain it and show it.
And then we quantify it. That's right.
But you have
So
to meet your threshold.
I understand. So we, in our papers, and we can provide additional information to this effect, have shown that the subject property is one of only 5 total properties in the entire study area that are small and vacant. But it is the only property that is then affected by additional physical conditions.
You don't think that this is, it might be helpful to find analogous cases to this one.
So I would appreciate if the board would review a couple of the BSA resolutions that were submitted in our April 22nd submission, which show that in the last 15 years, the board has found that sites over 3,500 square feet, including a site as wide as 47 square feet, was deemed...
7 feet wide, you mean?
Thank you. A site as wide as 47 feet was deemed to be narrow, and that 4,700 square feet was deemed to be small. And in that same case, the adjacency of residential uses was found to contribute to be a contributing unique physical condition giving rise to a hardship.
But many of the cases that you included were 25 feet wide. And if they mentioned that they were also adjacent to residential, what the board was really relying on was that they were 25 feet wide.
I appreciate your response there. And so this is where I would like the board to go in its thinking. We, in putting together with the owner a development scenario that we believe meets all 5 findings of 7221, looked to the E finding. This site the proposed building is the minimum variance because it is not asking for what some of these other examples have asked for. For example, at 96 through 98 DeGraw Street, the hardship presented by its unique physical conditions could only be outweighed by a grant of the Board of Standards and Appeals of close to 2 FAR, around 7,000 square feet of residential space. That's how they got to their minimum variance. We're not asking for 7,000 square feet of residential floor area. We're asking for 1 FAR of residential floor area. It is a lesser variance than what 96 through 98 DeGraw asked for.
You have to start, it has to first be I understand what you're doing, you're balancing it out, and I get it. But you have to first show the hardship.
Okay, again, we are the only property that is 3,500 square feet or less that is vacant in the surrounding neighborhood or district. I'm not sure how else we can say that is unique. If there are 300,000 plus square feet of private property in a surrounding area and only 5% or so are composed of properties that are vacant and narrow, and of that 5% of property, only one property is also bounded by non-conforming residential use in an interior lot. And all of those conditions, small size, narrow, vacant, and bounded by residential use, have repeatedly been conditions found by this board to be unique and giving rise to hardship. So I keep hearing that it's not unique, but I keep looking back at the tax map, and I keep talking to brokers, and they say, the small size impacts the marketability. The narrowness impacts the marketability. The adjacency of the residential uses impacts the marketability, because there's only perhaps one conforming use that could ever make sense here in the chair landed on it. It could be commercial office, but...
Or a gallery, or a restaurant.
Or a combined, like, bakery, factory, back office, kind of small showroom area in the front.
We would be happy to look at other conforming uses. I will say, and I know that this will be backed up by our financial consultant, it's going to be very difficult for us to find comps specific to a bakery or specific to the type of makers that you're describing, but we're happy to try to take a look.
What we're trying to say is now, and this is in answer to your statement about 96, 98, and the fact that we granted there, we should grant here, is that, as the chair said, over time, the industry has changed, and what may not have gone over 5 or 6 years ago is now an option. And so now, it's not so much a floor plate issue anymore. And so, because there are so many different types of uses that are now coming into fruition in neighborhoods just like this, neighborhoods that are still relatively low rent, low sales prices as regards other hot neighborhoods.
Look, the comment that times have changed in the last 6 years is speaking to the marketability. It's speaking to quantifiable hardship. I interpret the statement as saying...
It's speaking to the whole unique hardship issue, because it lets us look at it and go, 35 foot wide, it's not such a hardship. It really isn't. It's just a factor. It's a characteristic about a lot. That's what it enables us to say now that maybe we couldn't say 5 or 6 years ago, when the only types of uses that would have gone into this were traditional office space, a company comes and takes a floor, or manufacturing. We have items on skids, large skids, and we have these little hand trucks and all types of motorized things that don't move around inside a narrow building very well, or make an awful lot of noise when they do it. And so adjacency is really an issue, because it's narrow, and these are the types of things that happen in this industry, in this type of zoning district. That has changed.
What I'm hearing though, is that in the last 6 years, there is now a perhaps speculative office market that would not present that if developed here, would not be faced with the same hardships as there existed 6 years ago. So I would say, am I misinterpreting again?
We look at what's the as of right versus what's the proposed, right? In terms of that hardship argument. And back then, 6 years ago, to propose an as of right that would appeal to what we called yesterday, like a hip office tenant who would be really responsive to the idea of having double height space and a little thing in the backyard and all of that sort of stuff, didn't exist. So we wouldn't have been able to say that's an as of right option. We would have said never heard of it, never seen it, so it wouldn't be a typical proposal. But now we look at that and say, well, that's what we're seeing in the marketplace in terms of use. When I say marketplace, it's out there. These buildings are constructed, they're used like that. So, and just to use as an example, in these M districts up until recently, a hotel was one of the things we required people to look at in the M15s, where you had a lot of floor area. And now we can't look at a hotel anymore. So hotel is off the list because you need a special permit to obtain one, right? So that's a change in conditions of allowable uses or viable sound uses that exist.
I think that I understand your point, and we disagree. We disagree that 6 years ago the office market was somehow substantially different. If 6 years ago, the only desks that would fit into office spaces were 35 feet wide, and now there are 25-foot wide desks, maybe. But the fact is that each person who would occupy an office space is occupying the same amount of square footage.
Nope.
They are asking for the same amount of movement.
Have you been to a .com type office?
Okay,
recently?
but again,
They
you're
walk
suggesting.
around like this.
Understood,
They
and you're
sit on a
suggesting,
stool,
again,
and
this
then
is why I
they
brought
sit
up
on
about
another stool.
whether or not the WeWork model, the shared office model, is something that would work here. Your statement that we're not faced by the same hardship because that model is available is implying that our property is marketable for that model to such an extent as to absolve the hardships faced by its small size, its narrow condition, and the adjacency of residential uses, and that's simply not true. To the extent that someone could be in that space and could occupy it and find it useful, that would have been the case 15 years ago if I was in an office space that was only 20 feet wide. My office does not occupy a space wider than 8 feet. But the fact is that we're not leasing to individual people. This is a speculative space that would need to be marketable enough to overcome the hardship of the site's small size.
So I just-
It would have to, and marketability is about the return.
Can I read the A finding? As ZR 7221, there are unique physical conditions including irregularity, narrowness or shallowness of lot size or shape, or exceptional topographical or other physical conditions peculiar to and inherent in the particular zoning lot, and that as a result of such unique physical conditions, practical difficulties or unnecessary hardship arise in complying strictly with the use or bulk provision of the resolution. So it doesn't really talk about the marketability. It talks about your inability to develop this lot.
Right.
Then we get to marketability. But you even showed in your creative, mixed-use proposal that you could create a different type of office layout. So you could. There are options there. There's an industry out there.
Ma'am, this is Stuart Beckerman.
Sure, I just want to
Sir,
correct
I
one
could-
thing that was said in the record because it's not a correct statement. You're not asking for 1 FAR, you're asking for 1.9 FAR, which is almost the 2 FAR that DeGraw was asking, okay? So it may be 1 is directed to residential, but it's
Right.
1.9 FAR, okay.
Okay, I'm Stuart Beckerman from Slater and Beckerman for the applicant. I just have a question. I'm a little confused by the discussion, so I'm really asking the board for some guidance. So 6 years ago, when the application for 96, 98 DeGraw was considered, the board found uniqueness. And it looked at, I don't recall exactly what the as-of-right scenario was, but it was determined that these were unique conditions that gave rise to a hardship. And so let's say they looked at a 2-story office building or a 1-story office building. So I guess what I'm a little confused about is, and maybe I'm a little dense, but I hear the board stuck on the idea that in the last 6 years, there have been changes in the market and there were new models of commercial development taking place in neighborhoods such as this one. So I guess what I'm a little confused about is why is that not just a scenario that we can look at for purposes of the B finding? Because as was pointed out, in determining hardship, unnecessary hardship, you quantify it through the B finding analysis. So I guess what I'm trying to understand is, so let's say we analyze the type of office development that you were suggesting, that you're saying, I'm a little out of the loop these days on that sort of thing, but if we did that kind of an analysis and let's say it showed that we couldn't get a reasonable economic return, would that address
No, I
your
think we
concern?
have to go one step further, and the way we do that is, let's look at, I'll give you an example. For manufacturing, a 25 by 100-foot lot. So people have now when they do their whole uniqueness finding for that type of a lot in a manufacturing, go to shorthand, which is why I often ask applicants, fill out the argument. Don't just go to narrow street, no loading zone, bloppity blop, give us what we want. Go back into your uniqueness and why it can't support any kind of development. Then talk about feasibility. So one way, we had an exercise where the applicant for industrial showed us on a 25 by 100-foot lot, you had to accommodate a certain amount of skids for storage, and it wasn't enough skids. You had to have a clearance lane so that you can maneuver your moving machinery within that lot, and there was no way you could really do it or store anything in the process. They actually laid it out and showed us. So now you have a 35 by 100-foot lot, and we're saying, we think the industry has changed and that you can develop this lot. You show us and say, given the new types of office developments, this is still a very constrained lot. This is what the layout would look like on a 35 by 100, and there's no way you could make this work. Show us. And then we could say, okay, looks like we're convinced. You have an A, that even though the industry has changed in terms of what people are looking for, there's no way you could make it happen on a lot, even of 35 by 100.
And just to pick up on that as examples, right? The 25 by 100 being the most obvious one, where, for instance, the construction of a new building now, especially if it's office, requires, just for argument's sake, a staircase of X width because of the new fire code regulations, an elevator because you're required to have an elevator that fits a stretcher, and by the time you put all of that in, there's no place to be, right? So that's where the 25 by 100 lot works so well. We also see with existing buildings, where the buildings are narrow and many floors and all of that, and they want to convert it to residential use, and they say, how can we have a commercial use in this building with a residential use when we need two separate elevators, and we can't have the commercial tenants interact with the residential tenants, and there's no place to put a second lobby, there's no place to put a second elevator and fire stair and all of that. That's how they make those arguments.
Let me just raise one other point. I mean, there's no question that there's nothing that physically prevents you from constructing, let's say, a one-story art gallery or a one-story store. There's nothing to prevent you from doing that. And yet, I don't think that you would suggest that that is something we necessarily need to look at for purposes of the A finding.
No, but so the thing is...
That's what I'm a little confused about.
What we talked about
because-
yesterday, there's a difference between having a unique physical condition that presents a hardship and having bad zoning. My feeling about all of this is what the reason that we're seeing this case is because the zoning only allows one FAR, and consistently people are asking for a number like 2 FAR. This is the problem with the M1 districts. This isn't a problem with the site. When it's a 25 by 100 lot, it's a problem with the site because they can't comply with code and provide the uses. Like, for instance, the skids, or an office where whatever, the toilets and this take up all the space, and then there's nothing.
Okay. Well, to that point, we do think there is a problem with the site. In addition to its small size and its narrow width and its vacancy, as we've talked about, the adjacency of residential use has a profound impact on how the property can be marketed to conforming. Let me finish. When the M1 district is mapped, it is not, you say, oh, this is it sounds like you're complaining about the zoning. Well, the way that the zoning is applied with a wide brush. So the drafters of the zoning resolution did not intend to zone property in such a way that the relationship of non-conforming uses adjacent to those property. What I'm trying to say is a similarly situated property in an M1 district surrounded by other conforming uses is not faced by the hardships that this site is. Zoning, the presence of non-conforming residential uses is a problem for the application of a zoning ordinance.
Why?
So
Why? That's what I don't understand. There are non-conforming uses all over the city in districts where they're no longer permitted.
I'm glad that you asked.
Yes,
So,
please explain.
Commissioner Monroe, give me just one moment.
Not a
I will
commissioner. I'd
happily
appreciate
respond.
if you
This is-
just addressed me as counsel for the board. I think I'm entitled to ask you a question.
You are.
If you
Don't
could.
regulate how the board operates, please, stay on your
I
side of the
apologize.
table.
I apologize. Why? Why does the presence of nonconforming uses impact the ability to, or why does that present a hardship in the use and development of property? Well, for small neighboring properties, the development of these properties, people make investment decisions with the idea that they can, no, let me finish. You asked a question, I'm going to respond. There are a very limited number of conforming uses in our district. L'Oreal, I'm serious.
I'm listening to you.
I know. Let me finish. There are a very limited number of conforming uses in an M district. Nowadays, the uses that can generate return, whether it be office, whether it be certain manufacturing uses, whether it be certain retail uses, they present from an investment decision the ability to a small window to make modifications. So for instance, when you think about a property that's already been built out in an M district, they already have a building, they can pivot. If they can't find a tenant for use A, they can pivot to, say, from office to restaurant, or from restaurant to retail back to office. The presence of non-conforming residential uses at this subject property impacts the ability to pivot. And that,
Why?
okay, I'll happily bring back that, something we talked about in our early papers, that retail and restaurant use at this particular location is incredibly frustrated by the location of the adjacent non-conforming residential uses. That limits the pool of conforming uses that can use this property. It limits the marketability of this property.
But if I could return to, I'm sorry.
This is a statement, this is not an explanation.
If you could support that.
Why?
Why does the...
Yeah, seriously, why?
Why is the...
If you have two conforming uses right and left, and on another side, very similar in every other aspect, you have two non-conforming adjacent uses. What is the difference?
Okay, we will happily, in a revised submission, provide more detail as to why the adjacent non-conforming residential uses frustrates the ability to develop the subject property with retail or restaurant use.
And if I could make the question more specific, I'm talking about the development of this site with a conforming use, because as Commissioner Otley Brown read in A, it's about practical difficulties or necessary hardship in complying strictly with the use or bulk provisions of the resolution. What you keep saying is about marketability and the ability to pivot. So my specific question is, how is it that the condition of the non-conforming uses on either side of the site prevent you from following the zoning resolution here?
Right. And just to pick up on that, according to your logic, a 50-foot wide site would also be able to complain. And so would a 75-foot wide lot, because
we're-
that gallery
Right.
that loves a 75-foot frontage is going to have such parties, and so that also makes sense.
We're obviously having a very, we're having large disagreement as to whether or not the marketability of a site can contribute to the hardship, and we will happily respond in papers.
So I think we've already beat the dog a lot. Do you want to
I just want to add, I mean, based on my field visit, and I'm kind of in the minority on this board with regards to how I see the uniqueness of this site. Based on my field visits and being familiar with this neighborhood, I have a friend who used to live there, so I used to go there quite often. I have not seen that much of pedestrian traffic along that street. I mean, it's a more of a truck route that takes the trucks turn or to Van Run to go to all the manufacturing uses. It's not an ideal site where a retail would want to locate, because you need enough pedestrian traffic, foot traffic for people to want to go there. And there isn't a concentration of restaurant along that block front for a restaurant to locate there. Those are my observation as to why I think those uses may not work there.
But
I mean,
that's
just
again a
because they're
market
That's a
Then
market.
I understand,
Yeah.
but that's also, I mean, so you have a site and you push a use there, just because the use is permitted, doesn't mean therefore that's what should go. I mean, is that use then is that space viable? Is that space can be occupied? Fine, you force someone to build a commercial building there.
forcing.
No,
Their
no,
option.
no. Okay, so it's somebody, because it's an as-of-right retail use, one builds an as-of-right retail or a restaurant use, but then nobody's coming because it does not have the foot traffic, because it's not close to any of these things. Is that then in hardship?
No,
Is that?
No, that's a
unique to
market
the
issue.
site.
That becomes a market issue.
No, but no, it
You
is,
know-
because there is a site is located in an area where it's no longer viable as a manufacturing use, it is no longer viable as an office use either, because
That
it does
hasn't been
not.
proven yet.
No, that's,
That's the question that we're asking them to prove to us.
So-
You have been convinced, and that's fine. But there are four of us who haven't been convinced, and we really do have a right to ask as many
enough.
questions
And
as we
I'm-
need
I'm
to.
just, I'm just trying to see if you
May I,
can.
I'm sorry, I'd like to just sort of add
And the
something.
other question I have, sorry, I just want to say,
Sorry.
other
Yeah,
question.
sorry.
You had submitted a document prepared by Mr. Valletta. Can
Yes.
you explain the reference of that, relationship to that, to uniqueness?
We will do that.
Because you were using that as an argument
Correct.
for
I think we threw that in a
how
footnote.
that ties into the uniqueness.
That's correct.
And I read the document, and I'm not a lawyer, I read it several times. I would like it if you can clarify that connection.
We will definitely do that, but if I just may just add, I would just like to follow up on what Vice Chair Chanda just said, because this is where I'm a little confused. I think whenever the board does an as-of-right analysis, they look at the universe of reasonable as-of-right uses. So, for example, what Madam Chair pointed out, when they were looking, 20 years ago, at vacant sites in Chelsea, they didn't think to even look at a hotel development.
Or a gallery.
Or a gallery, exactly. So I think what Vice Chair Chanda is suggesting is we have to determine what is a reasonable use in this neighborhood at this location. And I appreciate what you're saying in terms of the office use, and we will do that kind of analysis, and we'll look at the types of office uses that are, if not being built, but at least being, sort of created within existing buildings, and see what it would involve in terms of doing that at this location, and see if it makes sense. But I think ultimately, when the board looks at, a reasonable as-of-right use, they have to, there's a reasonableness that has to be applied.
Ability, or?
Yeah, exactly, we can, I think it's fairly safe to say that no one is going to put a restaurant at this location.
I don't know
And
if
even-
it's safe to say.
The question is whether or not.
Or even in my view, even an office, because generally, unless it's an end user, a singular user, as Ben said, office uses generally, if they're going to have employees, they want to be near mass transit, and this is not well served by mass transit. I'm just pointing that out. But I hear what you're saying. I think we've sort of exhausted this debate. I don't want to sort of take up any more of your time,
Had
but
a question from council?
Yeah, no, it's not really a question. I just wanted to point you to the resolution under calendar number 168-15-BZ. So that address is 58 Grattan Street, Brooklyn, which is obviously a different neighborhood. But a lot of the discussion that the board has had right now was pertinent to the discussion in that case. So you might want to look at that.
we will look at that. Thank
Grattan
you.
is the building that has that unusual office type use,
Right.
right?
Yeah.
In a very small site. I think that's a 20,
It was 25 by 100 and it was
Right.
vacant. And according to Google Street Maps, it looks like there's a multiple dwelling right next door.
oh, for certain.
And what did the board do in that case?
That was the one that was the unusual office. It was a what? Sorry? It was floor area. Floor area only, right? Yeah.
Good.
Hi, Barbara Cohen, real estate and planning consultant. The Grattan Street, I knew that was one you were referring to in terms of the increase in commercial space. So one that was in a very different neighborhood, more developed in its transition towards the more creative, media-related startups, that kind of commercial use. If you remember in that case, the applicant, who wasn't a developer of those very small spaces, of spaces that could fit the tenant requirements of sort of hybrid retail producer idea. There was a lot of discussion about that, and there was a lot of discussion about tenant requirements and their relationship to space and their needs of space. Now, I've been, sitting here knowing exactly what you're speaking about, because that's exactly what we did, and I did for the prior DeGraw and other cases as well, in terms of being able to really illustrate and show it out as to the how the size and how once you put in, you build things out and you put the requirements and you meet building codes and so and so and so, and what do you get as a product in the end? And how does that match tenant requirements in the marketplace? Does it fit? Doesn't it fit? Is it a small pool that you're working with or a larger pool of prospective tenants? And what is their capacity to pay rent, given what they do, how they do it, and what fits their needs? So I think that linkage and the illustration of that is really what you're looking for, certainly in terms of the commercial office scenario, which we did here. The manufacturing thing, I think that's been, illustrated and doesn't necessarily have to be played out, because has been in the past and it applies here. In terms of looking at a hybrid producer, or the ceiling rates, and making that one-story commercial scenario hip, or as I think it was Rabbi Rosenbaum who had come to say, we'll make it nice. We can make it nice, but you're not going to get $40 a square foot, okay? And I have to say that when I listened to the comments and I reread all my materials, I have to say that this strenuous effort to make this commercial office scenario work, and undercut the financial report, which is based on market comps, based on what exists in the area, and to then say, well, if you manipulate a little here and you put 40 here and you take a little cost here, yeah, we can make it work. Well, if that's, kind of the way we're going here,
Right, but understand, we don't do that with every case that comes across us. When do we do that? We do that when we're not convinced by the A finding. Then we start picking apart everything else.
I know, but you shouldn't even do that. It's distressing. It's distressing to do.
I know you're feeling hurt and all about your finances.
Because I spent.
But the bottom line is, what we could do, which would be worse, is we could close the hearing on the very first or second hearing and say, we don't see it, but we're giving you a chance by showing you what's problematic with the A, and showing you how that is distorting B for us.
Yes, and I think the struggle is about size, because there is this, gut feeling about 3,200, 3,500, whatever it is, works, regardless, period, end of story. I think that it is the burden here to show that is a small site, and for the following reasons and how it all plays out to be small. If we were talking 5,000 square feet, there's a market for little warehouse guys, looking for 5 plus, that's there. They only pay what they pay based on what they do and so on. And yeah, they have requirements of spilling out on sidewalks and all of that. But this is small, and it's small. And, but yes, I absolutely agree. The issue of size and how it actually plays out and impacts prospective tenants, and yes, it does lead to the marketability and how the construction costs and all the elements that come into play that result either in a return or not a return, and is supported by market comps and what's available and so on in a proper manner.
And understand that the board is very concerned about the up creep in terms of frontages that are claiming uniqueness because they're too small.
No, I understand.
And so the board has to be careful to hold the line, because otherwise every single lot will come in right behind you.
And to the point of changing markets and different users and so on, I think it's absolutely appropriate to keep up with that change and to keep matching the tenant requirements, the real understanding of profiles of tenants and tenant requirements and their space and what they deem acceptable for their operation to the site and size and so on. And that connection has to always be played out. And in Grattan, those guys knew their tenants like no one's business. And they talked about, everyone's desires and what they need and so on. So, I mean, we all looked at that building going, well, who's going to put the 300 square foot on the front and the up and down? We all kind of went, huh? And they go, no, this fits this market and this neighborhood. This neighborhood is not quite there at all. And it's also, it's on the off-beaten track and it's not as well positioned as the Bushwick and
This isn't
it's
Bushwick.
farther as hard.
This is basically the wondrousness of expanding Red Hook world.
No, I'm not saying it's not in transition. I'm not saying that, but I will say that based on a lot of discussion with the broker who looked at this case, is she was absolutely saying the request for live-work situations is, coming every day, so that unfortunately the product can't be produced as of right? And there's nothing else out there to sort of point to in terms of how the relationship of the resident rent and the commercial rent sort of fit together when there is a live-work situation. And we can go into, some of the other comments about the resident comps, and we can argue that out if you like. But as far as the A and the connection of the size and so on, I think it can be done.
Okay, so, all right, so are there any speakers on this? Okay. Yes, you can speak. Well, you don't need to be called as a speaker, you're the owner, right? Yeah. But
You have to be sworn in.
I'll try to be nice. No, but you have to be sworn in because you're the applicant, actually.
Yes, do you affirm, raise your right hand, you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to all the questions. You can go, I speak.
I'll be quick and relax. I'm not going to go crazy.
State your name, please.
Marshall Sohn. I'm very familiar with this neighborhood. I've worked in this neighborhood. I've built in this neighborhood. I've probably done more projects in this neighborhood than anybody else. I was seriously disturbed by listening to your executive session on YouTube. It was very interesting. I don't understand how, a lot of it had to do with the B filing, the speculation with respect to what you saw as listed rents without any further understanding of what those rents are and what those rents mean. And I think we could really clarify that, but I don't think we're there yet because I think we're still on the A issue that has to be determined. I'd be glad to go into that and show you that how dangerous it is, the speculation that the board did without further investigation and taking some form of judicial notice of that could be. But with respect to the A finding, it seems like...
Sorry, I didn't understand.
Yeah, I
Additional
don't even
notice of what?
understand what you're talking
Well,
Trying to say
okay,
that- just say that-
I'll clarify it then. With respect to 69 Columbia, you spoke of a rent that you saw online, a very high rent. That's in a building that I was asked as a developer to look at for the brokers. And I did this prior to you mentioning it at the last board meeting. And the brokers were asking, what do you think of the value of this building? The 69 Columbia at the time was up for sale for approximately $10 million. The brokers were Meridian Capital. And they wanted to know what I thought. I looked at the building and I told them what I thought. I told them I thought the rents were ridiculous. I said, these rents that you're asking, they're not real. I said, you're not going to be able to sell this building on a pro forma basis like that. Of course, I said, it's bullshit. And I said, I wouldn't even take this assignment because I don't think you're going to be able to handle it. Since then, obviously, the $10 million price has dropped to 9, and now I got an email today, which I can show you on my iPhone. It's 8.25, and they're still trying to figure out what to do. It's not rented. I mean, these are facts that you'd want to develop if you're going to take judicial notice of an online listing.
We don't take
No,
judicial
what we're
notice.
doing is we're analyzing the information or the lack thereof that's given to us and providing
Okay, but-
feedback. So getting angry
I'm not angry, but...
up at the podium is not going to help you. What will help you would be to actually go back, do the analysis, and give us extra information like we asked. That's the fastest way to get to Z.
I'd be glad to get you the real rents, because I'm more aware of that.
That's fine.
But-
There were
but-
also a few other comps that I presented, and you should address those in writing in the
170,
same way.
170 DeGraw, I also heard you say.
And 96 DeGraw
Nine,
as
okay,
well.
okay, 170 DeGraw. It's on the other side of the expressway.
No, I said 135 Sackett Street.
You said 170 DeGraw also.
I said 96 DeGraw and 170 DeGraw.
Correct.
And you have to address
I
them.
can address it right
Not
now.
by standing here and yelling back
I'm not
at me.
yelling.
Okay. This is not helpful for you.
Yeah,
Okay? It's not helping you.
Okay. 96 DeGraw happens to be the building that you granted the variance on, and it's a house. Okay.
Okay, so, yeah, so this is the thing, right? You hear the comments and you need to respond to them. You have a lot of skeptical commissioners up here about the A finding. We're talking about the A, right? We're not talking about B, A, right? So, how much time do we need for this?
Of course, the comments include the comments from the...
Yeah, you have to respond to all the questions, but you know that you have a threshold
Right.
of really first come in the door question, right? So how much time do you need to do this? It should be careful. It should be backed up by solid information that responds to everyone's comments and concerns about other price ranges and so on. What are you asking?
And,
I asked about speakers.
and engineering issues as well.
Someone want to speak on
We
this
will.
from the public?
Yeah, I said including the comments from yesterday's session, yes.
Didn't feel like we had gotten there yet.
Anyone from the public who wishes to speak? Speak now. That's it? No? Good. Let's go.
Okay, did we?
No, how much time do you need?
2 months.
6 weeks?
6 weeks to submit.
Or a month to submit? 6 weeks to hear?
Give them 6 weeks. You have a lot to do. Should be ready, should be really nicely tied up in a bow. Case law, and to the extent that you cite to other BSA cases, don't just hand us the resolution, give us more. Because we don't actually know how what the board based its decision on. And do understand that there have been changes in opportunities for development. And so we look at those. And if there's something that you can show us that demonstrates that somehow it's not relevant here in Red Hook, sure.
Oh, that's 6 weeks is June 5th for a hearing on June 25th.
D-Day, thank you. That's June 6th.
Thank you.
Thank you.
It's 2:14, so.
So we're going to take a
lunch
30-minute break.
We'll be back on 2:45.
You taking a break?
Yes.
Okay, ladies and gentlemen, we're back on the record. Okay, we're back on the record, and we're on the zoning calendar. Item number 19, 2018-52BZ, 159 Bourne Street, Brooklyn. Raise your right hand. Do you agree to, sorry, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond on city board member questions? Okay. I forgot to put my mic on. I don't think I can hear you now. No, this one, honey, I'm sorry. This is the swearing sheet that you signed. This is the neighbor's opposition. Yeah, sorry. No, it's done the same thing. Okay.
It's a lot taller than me. Good afternoon, Chair Perlmutter, members of the board. Nora Martins from Ackerman LLP on behalf of the applicant for these two cases. I'd like to just I'll start with 159 Bourne Street, 2018-52 BZ, responding to the comments.
Sorry, the calendar item that was called is actually 10, sorry.
No.
I'm mistaken. Sorry, continue.
Okay, no problem. Just responding to the comments made by the board yesterday at their executive session. First, address the regulatory agreement from 1980 that was submitted to the board. That was submitted in response to a request because it had been cited in a prior submission, and it's cited in a city council resolution approving an extension of a tax exemption. That city council resolution was also submitted to the board previously. The chair is correct, though there are actually two other resolutions that were issued by the city council in connection with that whole approval. The other two resolutions were for the modification to the project and for the conveyance of the property on connection with Article 5 of the Private Housing Finance Law. We just didn't submit those resolutions because they weren't pertinent to the issue of the tax exemption specifically, but we are happy to submit those to the board to clarify the record.
No, actually, was the in a grant, I look at PDFs, and they're in different folders, and I'm not necessarily finding everything in a folder, but the one that I found in our folders was the city council resolution that had to do with allowing for the conveyance of the property to the subject developer, and not the one that allowed for the extension of the tax abatement, which is easily findable online. But I didn't find it in the record. It might be there, but I didn't find it, so if you don't
Well, I
mind
apologize.
resubmitting-
Yeah, we'll resubmit all three of them to make
Okay,
sure the
that
record
would
is
be
clear.
Mhm.
And then in response to Commissioner Shanda's question, I've reviewed and have found no evidence that although the site was located in the former Lindsay Bushwick urban renewal area, which was established in 1969 and has since expired, there's no evidence that this project was built pursuant to a large-scale residential development. The CPC report for the plan and project and land disposition in 1980, per the private housing finance law, does not refer to any large-scale approval, and nothing is referenced on the certificates of occupancy for the existing buildings.
Thank you.
And also, we would like to just say that the applicant is willing to enter into a restrictive declaration. It's been the subject of some discussion with the board, but we understand the board's position on this issue. We're still reviewing the language, and we'd like to work with counsel's office. I know you obviously still need to review it as well. And then lastly, on this matter, questions regarding the parking layout. To clarify, the parking layout itself was not reviewed by DOB. The comment was in response to some other parking layouts that the architect has submitted to DOB for review for attended parking, which this is attended parking, that's always been the intent.
So it was in response to another site that they were
Right, it was
working
just,
on?
right, it was a comment where they were not allowed to use, because for attended parking, you calculate the maximum number of spaces based on the square footage of the parking area. Previously, DOB had allowed a ramp, square footage of the ramp to be calculated, included in those square footage calculations. They were never proposing to park on the ramp, but just using it to confirm the number of maximum spaces they could have based on the square footage. We took a look at the layout. Obviously, it's illustrative because it's attended parking, subject to DOB approval and review for maneuverability. But understanding the board's concerns, it didn't make sense that the ground floor had so many spaces shown when there was space in the cellar. We've actually already revised the plans to show a clear travel lane on the ground floor at grade and to add more spaces in the cellar, and we're happy to provide those plans to the board. Are there any questions on this?
No, so just to make sure that when the plans are revised, so is this supposed to be valet parking?
Yes, it's always been intended to be
Okay, so
valet parking.
so then
Yeah, the plans show a valet booth, attendant booth.
So should we approve it, maybe we can add a note in the plan saying, should we, Chair, this is my suggestion, should this be approved, then there should be a note in the plan that the total number of parking spaces is X, and the layout is subject to DOB approval.
Yeah.
I think we may actually already have that note on the plans, but we'll make sure to include that.
All right. So, but the...
Yeah, layout is subject to DOB approval.
Okay, it says that, okay. Okay. You can also make that as one of our conditions that way. Yeah, as not just on the drawings, but in our conditions. Yeah, that's, okay.
As long as we lock in the total number of parking spaces.
Right, okay. All right, that's fine. Okay, I think those were the issues, so the main outstanding thing is the RD, the restrictive deck, right? And then you're going to resubmit the plans, obviously, because you're changing the parking layout.
Right, and we'll submit the council resolutions to
Right,
clarify
okay.
the record.
Okay, so in terms of scheduling, I don't know how much time you need for turning around, back and forth with the RD.
It shouldn't be that intensive. It's a
Right.
simple document.
Yeah, I think the document is fairly straightforward, and the other items we're ready to submit anytime, so that's really the only item.
Is this light enough to put on these?
Yeah, this is light, well,
This
you're
and
doing the
Johnson,
work.
it would be both.
Yeah, no, I know, but we can easily set a schedule because it's the same, well, arguably it's the same question, right? I don't know.
Like,
So
would
the next
you be
one-
amenable to putting it on June 4th?
No, so I think maybe can we hold off on
Scheduling?
scheduling because the next one has more complicated questions?
Okay.
Does that work? Is that okay in terms of how we do
The idea being that
calendar?
you want them to travel
They
together.
should travel together, and the next one has more complicated questions about the parking.
Okay, so I'll call that one?
Okay.
Yeah, you have to be sworn in.
Are there any speakers on this one? Okay.
Okay. Oh, no, wait, are speakers or?
No, they're not
Oh, okay, fine. Item number 20, 2018-55 BZ 222 Johnson Avenue, Brooklyn. So you raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions?
Yes.
Okay, you can sign in later.
Nora Martins from Ackerman LLP for the applicant. On this project, 222 Johnson Avenue, response to comments there's some overlap with the last item, so we have the same responses on the board's comments with regard to the regulatory agreement on large scale, as well as the restrictive declaration. I think the board did have, specifically on this matter, questions regarding the updated parking study. So I have actually Aviva Laurenti from Sam Schwartz Engineering to help me answer your questions, as she knows better than I do.
Hello, I'm Aviva Laurenti with Sam Schwartz Engineering, and I can answer your questions directly.
You already know what they are, or?
I can speak to some of them at a high level. There was one question about discrepancy of auto ownership in adjacent census tracts.
Yeah, the issue is, they're right next door to each other. One has almost 20%, and one only has like 7% auto ownership, and the one that's 20% is right next to the subway. So why would that be the case?
So I can only speak to, speculating an answer for that because it's the census data. I mean, the census data that's presented here is based on the American Community Survey, which is done annually. It is only a representative survey, unlike the census, what happens every 10 years. So it could be the population that was surveyed, it could be the population that responded and how they responded. Other than that, there's really no way for me to know the answer to that.
Okay. So, and then to pick up on Commissioner Otley Brown's question was, I think, this is going to be occupied by market rate units. So if the census tract that is being considered here is primarily low income who might not have cars, then doesn't that require a shift in census, in the modal split data, because you're assuming people who can afford cars?
Well, when we do these analyses, the standard methodology is to use the census data, and it doesn't account for the difference between affordable versus market rate housing. But part of why we did the supplemental analysis related to the four other developments that were studied is because they were actual developments that we have specific data on that we could relate to. And so we used that information primarily to come up with our conclusions.
So what is the relationship of market rate apartments to regulated apartments in those other developments that you've looked at?
For all of them, it's about between 20 and 30%, which is much less than our project, but primarily because
20 and 30% what?
affordable.
Okay.
Sorry. And ours is approximately 57%.
Just to clarify, that includes the existing income restricted, the 57%.
I'm
We look
speaking-
at the project as the whole zoning lot. the
Right,
existing and the
understood.
proposed.
That
I just want to
we
make sure it was clear that
Yeah,
we're not proposing.
So you're saying that in the other projects from which you culled this information, the mix is basically 70 to 80% market?
Correct.
Okay, and therefore resulted in whatever we found in there.
Right, so, I mean, right, we looked at 4 different independent variables to come up with parking rates because based on the information we have. So how many parking spaces leased based on the total number of spaces provided, the rate of parking based on the total number of dwelling units, and then the parking rates based on either market rate or affordable. And each of those was looked at as an independent variable, and then we looked at the average of each of those conditions and applied that to this site. Because we don't know exactly which one would tell the best story, but even in the worst case, we would still have enough parking on site.
So just asking, what's the car ownership rate amongst the market apartments? The average for just market apartments?
Yeah, the information to that level of detail is not provided by the census directly. And even when we tried to dig deeper based on your comments in the last session, it's still not provided at a census tract level. It's a much larger, what they call them, a PUMA area. So since that information wasn't directly applicable, we felt that the 4 actual existing uses would be more useful.
Okay, which have a few lower
Percentage of
percentage of affordability than this one, arguably, if we're counting
yeah.
both.
Lower percentage of
Yeah.
affordability.
Yes, okay. So therefore, then I ask again, is everyone okay with the idea that the demand rate is being determined to be 28 based on that low neighborhood project data, as opposed to 63, which is based on the combined census tracts? Everybody okay with that? Because that way there's no shortfall in what's being provided, right? Okay. All right then. Are there speakers on this? So, yes?
So this is the most recent parking study, and you should revise the EAS to include the most recent study and submit that as a final EAS for this application.
We did also update the parking study to make sure the methodology was consistent for 2018 52BZ. So we'll submit updated EASs for both.
Right. But then that one, we didn't, in any criteria, you didn't have a shortfall.
Right.
So,
Right, but just to make sure the record is consistent.
okay. Okay, so in that case, then now we could set a date, because the only thing missing is then updating the EAS, which is really just updating the EAS. I don't think it needs further review by DOT, does it?
Restrictive declaration.
And then the restrictive deck, so now we're back to the turnaround on that.
How do you feel about putting it on June 4th?
June 4th or May 15th, that gives you 2.5 weeks to turn around. Is that enough?
Or
Not even. I don't know if
1,
that's
2,
enough.
3, it's 3 weeks.
3 weeks?
I'm fine with it if
That works for
they're
us.
fine with it.
Okay.
Okay, so.
So both cases will be the submission date of May 15th and continued hearing date of June 4th for both.
Okay, and I would ask, is it possible at that hearing date, if we submit, that it would be closed and granted?
Yes.
Hopefully granted,
Closed and
determined at that
voted.
hearing.
Yes.
Thank you.
Thank you.
Okay.
Thank you.
Thank you.
May 15th. Okay, yeah. This one. Thank you so much. Item number 21, 2018-64BZ, 2018-65A, 725 Mobile Road, Queens. Everyone? This is it? Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions?
Richard Lobel of Sheldon Lobel, PC for the applicant. I'm joined by Fan Baton from my office. Chair, we were at the, we had a representative at the executive session, so we heard the board's comments. I first wanted to clarify one important issue, which was that first of all, we appreciate the compliments on the legal memo and the great strides we've taken since initially submitting legal precedent. I would just note the chair's comments with regards to the St. Albans case, particularly with regards to the deference due to religious institutions and the board's ability to condition potential variance grants such that the impacts on the surrounding community in terms of health safety would be mitigated. I think that there may have been a misunderstanding with regards to the fire department's view of the current application and the nature of the plans. It is our understanding that after the operable hatches were placed in the roof, that the fire department indeed did not have any further objections to the application. Since that time, we did reach out to the fire department and determined that they were okay with the current iterations, but I would actually ask Chief Daly to respond to that if possible.
The hatches on the roof?
Correct.
What got to do with a 20-foot wide road?
It has to do with the fact that there's no longer a GCL application that's warranted here, and the question of access to the site and whether or not the fire department had any further objections to the case, I think that was central given the fact that that fire safety and access was a large consideration in the board's discussion, and our understanding from the fire department is that is not an issue.
Okay.
John Daly, Fire Department. I did get a chance to review the plans again last night, along showing it to other members of fire prevention. The original plan had called for a slope roof of 6 feet depth. That has been revised to show a parapet wall that's only 3 feet, where our bucket can reach over and we'll be able to have access to the roof line. With respect to the road width, I mean, it's an existing 20-foot wide, but we also know that the Department of Transportation will have to put in no parking signs in front of the house of worship because we are not allowed to park in front. I know people do disregard. I did have an opportunity to talk to the battalion chief of the Far Rockaway district. He understands that they're dealing with an existing condition road width there, and that they have pre-incident planning already in place to respond to areas. They are aware of the proposed synagogue, and they have no objection.
So I'm kind of confused. So I know this isn't a GCL 35 waiver anymore.
Right.
And it's not a GCL 36 where you would be looking at it in a different way.
Yes.
But we're looking at, and sometimes we have this issue with DOT also. It's like DOT looks at an application for something. We had this situation with a gas station actually on Fordham Road where the board was very concerned about the traffic situation on Fordham Road and all these crossing.
Yes.
All the traffic was going to cross in all different directions, and the turning into the gas station was giving us concern.
Right.
And DOT was being sort of cooperative with the idea of having a gas station there and suggested, for instance, well, what if they put up bollards? What if they put some kind of hatching in the roadway and so on in an effort to try to make it workable? And the board was very concerned, having driven on that very spot, that DOT's efforts to make it workable wasn't actually the question being presented to DOT. The question really was, is this a bad idea? And ultimately, the board concluded it was a bad idea.
Right.
So this is a similar kind of a question. So it's not that the synagogue goes there, because this is a residential street.
Yes.
And that normally a house would go in that location where the firefighters would be only egressing whoever's in the house. And if the roadway were blocked by illegal parking, which we know happens all over the place.
Yes.
Let's just perhaps the danger to the community and even to the occupants of the building that's engulfed would be less, right?
Mm-hmm.
Because you're not dealing with potentially 400 people at the site,
Now,
right?
correct me if I'm wrong, but you are proposing to sprinkler the building.
Correct.
So, okay, so that's another factor in their decision that the building's going to be fully sprinklered. And, it'll be fully sprinklered.
So let me ask it a different way. So The typical argument that's given about houses of worship that have congregants who live arguably, let's just say, in a half a mile of the site, is that they're all going to walk, so there is nobody going to actually be driving a car. But that's not, in fact, what happens. It's true that arguably with this particular congregation on Friday nights and Saturdays, that people won't be driving to the site, maybe, not sure. But certainly on other days when there are events, they will be driving to the site. And so there's no parking that's provided, and so the parking, we just know, is going to occur on this 20-foot wide roadway. So then so where does the truck go?
Yeah,
It'll be operating down the block from the synagogue, so in the event we had a situation like that. But
You wouldn't be able to get your truck in front of the building.
that's correct, yes.
And that, I mean, I know fire department is willing to put up with anything, right? They just deal with whatever.
Right.
But in the realm of what's best for the safety of the people in the community, not to mention the occupants of this structure.
Yes.
I don't see it as, and this, by the way, I've learned this from fire department, right? It's not that.
I understand. No.
Oh, right?
Yep.
So you would be fighting this fire from down the street as opposed to from in front of the building because there'd be cars in the way on the 20-foot wide roadway.
Well, according to the battalion chief, that whole neighborhood, the street widths are typical of 20 to 30 feet. Not I would love to have the 34 feet, but it's something they deal with and they work around. And of course, when the structure is built, they will have their pre-incident planning and map out situations where they had to respond, hope not, but to a fire at this location. But no, that's again. The battalion chief, his assessment is they have no objection, and I'm pretty vocal with reaching out to everyone in the fire department, and they respond back, and that was their response.
Right, but I'm having trouble with the,
Yes.
so the idea of fighting it off the site, the closest place to go is Reed's Lane, and I don't know the width of Reed's Lane, and it's far away from the subject site.
Do you know the
So-
distance off the hand?
No, without
No.
somebody
You can do
quickly
a-
do a Google, I don't know how to find it.
Oh, it's not-
It's not
It's not
triggered for, yeah. Oh, Zola is the one.
Would you
Okay.
fight it from another property? Would you go onto another property to get access if you needed it?
Yes, ma'am, you would, from the rear, from the side.
So you would possibly drive right onto the property of the next door neighbor, the residence, and get it from the back?
Yes, we would. We would.
Yeah.
Fire hydrant.
Right. So, okay, so let's try to wrap that. So,
Just note on this.
sorry, Chief Daly, I just want to pick up, so on the GCL waivers.
Yes.
Where we're looking at whether someone, it's not really so much the GCL 35s, because usually that's to build right there in the bed of the roadway, and that's the end of the roadway, right? But on the GCL 36, fire department often gives testimony, always gives testimony, that the 20-foot wide or even the 30-foot wide roads are inadequate. And so the comments to us are, not okay, can't have parking here. We object to this application because there isn't room for the fire trucks to pass.
Right.
And if the roadway isn't a clear 20 feet that we, in the case of one house, those house behind houses, it's the clear 20-foot width behind, where the truck can pass by, where we have to insist that there's no parking, and that's privately owned site, so it's actually possible for there to be no parking, arguably. So fire department is quite strict on that. So I don't actually understand, without potentially undermining all of the comments the fire department makes about our GCL 36s,
Right.
how it's not having the same concern about this site when, as I said before, this use is not a foregone conclusion. They're asking if the use is okay on this site.
Right, but now the fire department knows that, both sides of the street, I mean, to widen that whole length of...
We're not asking whether or not, what way, how can we make this work? That's
Okay.
not the question. The question is this safe? And if it was a GCL 36 just from my experience.
Right.
So GCL 36, I'd be receiving, I think I would see a very different letter in the file.
Okay.
And I believe that's because the fire department thinks that's not safe.
Right.
So I'm more concerned about not so much the how we get there. I'm more concerned about the actual safety here.
Okay.
And if it comes down to safety, it should be the same whether it's a GCL 36 or not. Would you agree to that?
I agree with that, but...
Okay.
So if
We should be using the same standard that we use on the GCL 36. That's where all of this is coming from, where we're told that 20 feet is terrible.
Okay. What I can do is go back to city planning and operations, and bring this up again with them, and get a more written statement I can provide to the board.
I'm just actually, I'm actually concerned because I think we're in agreement that if this was a separate type application with the same exact facts,
Right.
if it was a GCL 36, we would say that this is a safety hazard. That brings a level of concern for me that I don't know if I'm able to overcome by simply saying, oh, well, it's not a GCL 36.
I understand your point of view, Commissioner, and I will go back to go to city planning and ask them to review this application.
City planning is in your
I'm sorry, yeah,
office.
in the Bureau of Operations, City Planning Unit. I apologize. And, sit down with them, and we'll go over all the conditions on the site, the fact that it's going to be sprinklered, also factor in the number of persons, the number of exits that we have here, and we'll get a written statement from them.
Now I'm trying to understand again.
Yeah.
So if we started again with a GCL 36 waiver, GCL 36, all the houses are sprinklered on those GCL 36s,
Right,
right?
right, yes.
And at the same time, we still have this requirement that there be no parking.
He said there would be requirement.
No, but that's only if DOT, well, and then we always talk about how, okay, it'll be no parking, but we all know that fire department can't enforce on those private roads
Yes.
because they always park anyway.
Right.
And so there you are stuck with a situation where there's going to be a car in the way. And we talked about it in one of the house behind a house situations where what if the delivery guy is there?
Right.
And delivering a pizza and then the house catches fire, right? So during the time of the delivery trucks there, you can approach the house, right? Or,
Correct,
or
yes.
more importantly, the guy's repairing something and his truck is there, so it's taking
Understand.
longer,
Right.
right? So again, the GCL 36s present a situation where the owner then has to take responsibility for the no parking area, right?
Right.
And so we try to enforce that with a restrictive declaration. Here, there's no way for it to be enforced, and there's going to be parking.
This
So-
being a public road, that's, we got a problem. But again,
In this calculation that will be done,
Yes.
does the amount of people inhabiting or using that structure at one time, does that come into consideration?
it does. As per the building code, you exceed 300 people, you're required to have a fully sprinkled building with, I believe, a fire alarm system as well.
I have a question.
Sure.
So in situations where we have GCL 36s and 35s, we typically require restrictive deck, HOA, I don't know if HOA is there, but something like that where we make sure they're responsible for no parking signs, making sure no parking is maintained, all of that. Even though GCL 36 is not required here, but the fact that the property, I think the lot goes into the bed of the street.
Yes, but they're not building in the
No, they're
bed.
not building into the bed of the street, but that's where the road would be and possibility for parking. So there's a way of kind of ensuring that whatever is open, it's marked as a front yard, but that there would be no parking along that frontage.
No, so there's no parking on their forest front yard, but there is potentially parking because that's just what we see within the 20-foot road bed, right? So then what's the truck supposed to do?
But then, but we do issue a lot of restrictive deck with various GCLs where we say no parking and other things, so.
But that's when the developer has control over the roadbed. Here, they don't have control over the roadbed. It's a public roadway. That's the...
If, under the same circumstances, if this was a GCL and the owner said they won't change it, the roadway, they won't make any modifications, what would the fire department say at that point?
They would object. They would not support the application.
And it could look just like this one?
Yes, if it was a private street, yes.
Got it.
So maybe a fair
Does it
question.
make it, I'm sorry.
Go ahead.
Does making it a public street make it any other way safer besides just how it's labeled?
That's how it's labeled.
So it's only because there's nothing the applicant can do about it?
And that's correct. Not that I've never heard of an applicant be able
That's a
to.
jurisdictional question.
Yeah.
So this is maybe the question, right? On the GCL 36, the nature of the GCL is that the board asks certain of the agencies to weigh in on whether this is a good idea, right?
Okay.
And so what it does is it gives fire department authority to tell us whether it's a safe idea to create this roadway. What I'm hearing here is fire department saying, what do you want us to do? It already exists. And which is a different question, which is similar to what I described about the fire department, about the Fordham Road gas station, where DOT was saying, what do you want us to do? It already exists. And what we wanted to know from them is, this sounds like a bad idea to us. Can you help us understand whether we're right that it's a bad idea? And they were never willing to say it's a bad idea, so instead, we said it, right? So I think the distinction here is apparently jurisdictional, where GCL 36 hands fire department jurisdiction to determine whether there should be a road, whereas here, it has no jurisdiction to determine whether there should be a road. It's a road.
Yes.
So
So then that's kind of, it's maybe the wrong
I
forum in a certain way, right?
I do think that, at least what I was trying to get at is the safety concern the same? Even though that's not, that we don't have it's not jurisdictionally in their hands to decide, is the safety concern the same? And I'm getting that it is, but there's nothing they could do about it, is how they see it in this particular case.
That being the case, I don't know that it's necessary for you to go back and seek a written submission from anyone at fire department. I think your testimony is sufficient.
Oh, okay, all right.
I have a
Thank you.
question.
No, Commissioner, yeah?
No, this is for
Oh,
Julie.
okay.
Thank you.
Thank you very much, Chief.
I have a question. Let's say if this zoning lot was not subdivided, technically from a zoning regulations, one could have a mix of residential and a community facility.
Sure.
You could have the existing residential building and the community facility.
Yes.
But they wouldn't have to come here.
Well, that's my question. Would you be able to build the community facility at this location as of right, without triggering any,
I think we'd have to.
in terms of the side yard waivers and other things?
We'd have to further review that. I don't want to, on the fly, just, I don't
I'm
want
just
to.
trying to see the comparison between
Right.
if you did not subdivide it
Understood.
subdivide this lot, what is the degree of variance you would need? Would you need it?
Right.
And if so, what is that versus what you're proposing?
Yeah,
So that's
I wouldn't
the A
represent.
question.
That's the A
a
question.
completely different one.
Because I wouldn't represent what you could do there.
Self-created question.
We can represent what the as-of-right building, as it exists in the current subdivided form. We've submitted as-of-right plans, but to the extent that you're asking what a maximum build could be on that parcel as subdivided without any waivers.
No,
We haven't
not
looked
as
at
subdivided, unsubdivided.
unsubdivided. We
I think
could,
this goes to the finding
Sure.
B. That's
yeah, no, we'd be happy to demonstrate that.
If it was unsubdivided and you're trying to put a separate synagogue on the site, that's a whole other question. Unsubdivided, you have a distance between buildings rule, and no one said, we talked about this at the very first hearing, no one said, and we've seen many houses that have been converted into synagogues, right? No one says that this house couldn't be converted into a synagogue, and then you expand the house compliant with zoning to use up your floor area, right? So to say that the site must receive a second building, and of course you're not going to be able to fit two buildings on the lot because the distance rule says 50 feet or 60 feet or whatever it says, right? And so right now, they're showing the synagogue 5 feet away or something like that from the adjoining house. So I don't think that exercise is useful. The exercise would be if you converted the house or tore the house down and converted it to a synagogue, could you build, as of right, a complying synagogue? And the answer is, of course.
But
right? Nobody's telling you to keep the house standing. Nobody's telling you to keep the house as a residence.
Yeah, I think, Chair, that, the only reason that this was raised now was because the board made comments in the executive session regarding health and safety, and so that's particularly why we reached out with regards to the fire department. And understanding the conversation regarding the jurisdictional question, I just find it somewhat problematic to discuss potential illegal parking as a barrier to potential grant of a variance application. I mean, I know that we benefit from, for example, D'Amelio versus Bennett, the 1989 Second Department case, which demonstrates that proposed future illegal use cannot be used as a bar to an otherwise valid application. So we would cite to that and say, at our core, and the rabbi from, Rabbi Sandler is here from the congregation, it's of tantamount importance to us that we not create an unsafe condition for our congregants and our congregants' families. But in truth, we just, we're trying to take the right steps to ensure that fire safety is met, and we can't see as how that here would be an impediment, given the fact that we have basically gone through typical review at BSA through fire department to demonstrate that the variance, would not raise any of these concerns.
Well, but then you're asking us to forget, I don't know how many GCL 36 waivers that we've done in you could just say the last year, not to mention the last years, where we've gotten clear information from the fire department that there's a problem, that these 20-foot wide roads are not safe. And when we're asked to give a GCL waiver just to extend the road a little bit to add 3 more houses, there's always the concern about putting 3 more houses down there because the fire trucks can't get down and people just ignore the no parking signs. So it's not as if we're making up some fictional moment of paranoia where somebody's going to open up a hashish den or something like that on the site. We're not doing that at all. This is actually based on our direct experience with these narrow roadways, and for us to ignore the experience seems unreasonable.
Yeah.
And then again, it's not the only point. The other point is, we went through this several times, and we found that now that seems like the congregation is unwilling, not doesn't seem like, it was stated in the submission, congregation is unwilling to change the size of its building and insist that this is the only building that works. And sometimes a site is just not the right site.
I think, Chair, that the Chair's couching this in terms of unwillingness. At the prior hearing, there was a conversation about the D-finding, which was very clear that this was a threshold issue of this case, and that the board at the last hearing was not going to consider a discussion of, for example, the C finding with regards to this application until that finding was discussed discussed and vetted. So to the extent that the board wants, look, at some point, we're gonna run against an issue where we just don't have enough space to satisfy the program of the synagogue. But if the chair's saying, that we're unwilling to address CME, we're not. If the chair sends us back and says, make it smaller or address the size of the synagogue, we're happy to do that. I think that there's a limited amount that we can do, but we can do that.
Your papers, in so many words, said, your submission, this last one said, the synagogue looked at the building and determined that this is the smallest building
Yes,
possible.
Chair.
It says that in your
Yes,
paper.
Chair. And
So that's final.
To the extent that the chair tells us that we're going to be denied due to an inability to make the building smaller, and we have to give up certain program space in order to make that happen, given the eventualities and the choices that the synagogue has to make, there's a serious discussion where they would have to make it smaller. Do I feel that the current synagogue building barely satisfies the programmatic needs? Absolutely. But does the synagogue want to go through potential further action in order to get their synagogue building? No. So they would take a hard look and see whether or not they can do something.
You mean
This is, we
on
just,
the
we just
threat
did,
of being voted out?
Absolutely.
Now, all of a sudden, the synagogue is willing to make it smaller? That just tells me that whatever.
willing to remove a library chair so that we're down to the bare essentials. It is a painful process for us, but we're now looking at a synagogue which prays in a trailer in a school parking lot for 114 people. So
Sometimes the site isn't the right site.
we have no other
The
site.
synagogue has a congregation of X, which you claim, but it changed all the time during the course of this hearing process, so I actually don't know what the X is. And it claims that it needs to have these many rooms and all of that sort of stuff. And it's completely overwhelming the site, and I just want to, in terms of this whole deference argument, right? You don't get deference no matter what.
Understood.
If the congregation said, we have 4,000 members, and we need to have a 14-story building on this site, and this is the only site in the neighborhood that fits the 14-story building, and that's just the way it is, and there's this Cornell doctrine, and you guys just have to accept it, we wouldn't accept it.
Chair, I've made that very point repeatedly over the course of my legal career, but we've got a two-story building here, which is not overwhelming the site, and as we've submitted character, in terms of what waivers that we're requesting, does it overwhelm the site? We submitted case law, we've submitted BSA precedent demonstrating that the waivers requested here are quite frankly, on the low end of waivers that have previously been requested in other similar religious uses. I don't think that's a meritorious argument.
It's providing 0 side yards, minimal, as if it were nothing.
4 feet.
And it is overwhelming the lot. And
We've
it's
reduced the
ignoring
size.
its impact on the adjoining property.
We reduced the size of the
I
synagogue.
don't actually think we need to talk about this
Oh.
anymore. So what I would say is, I want to just, are there any speakers on this? Anyone you'd like to speak? But you're actually the applicant, so.
He's already sworn in. So.
You're sworn in, so if you want to speak, please speak.
Thank you very much for giving me the opportunity.
State your name, please.
My name is Alicia Sandler. I've been the rabbi of the synagogue for the past 4 years. Just to give a little bit of a perspective of what we're dealing with now. Our synagogue has grown. When I joined, there were 25 families. We've grown now to 80 families that are part of this particular synagogue. We're in a trailer. We need to leave the trailer by the end of this summer. We've been looking, I would say for the past 3.5 years, we've been looking at various sites. We found houses. It wasn't a money issue. We were ready to raise money primarily from the people within the synagogue. And as soon as people go wind of the fact, selling a house, that we were a synagogue, so who wants to be neighbors to a synagogue? And we tried with one. We have members of the synagogue who have bought houses that we've went to look at. When we saw this lot originally, it's on a small street. The location is very convenient, but we brought the whole membership together to vote on it, whether or not we understood at that time that parking, the parking issue came up, that parking was not going to be feasible on the block. Where we are now, there's no parking either. But we understood that. We brought that up at that meeting. We discussed it at length at that meeting. I believe that, could I guarantee nobody will ever double park? Of course I can't do that. But I could promise, and I'm under... Park. But I could promise I'm under oath that we will do whatever we can to stop that from happening.
What about your neighbors who live across the street?
What about them?
You can't do anything about them, right?
I'm not
The
trying to-
issue is, you have a 20-foot wide road, this is one of the issues, you have a 20-foot wide road, and people will park on the street, because that's just what happens. And then, from our perspective, we have a danger situation, where the roadway is clogged with people parking.
I don't believe that we're going to be adding, maybe I'm naive, I don't believe we're going to be adding to the parking issue because we will be enforcing it, just like we enforce other things. We're part of a school. The school complained to us that children are running into classrooms and wreaking havoc. And we disinvited people from praying in the synagogue, if that's what they're going to be doing. And we put an end to it very, very quickly. We definitely will work on it. We definitely will. Certainly if we get a complaint by anybody, we will address it. We'll have clear signs saying that one can't do that, and we'll address it. Ever since we went into contract with this particular property, we've been paying $5,000 a month in order to secure it because we knew we had no other place. We really knew we had no other place. We were given notice that we need to leave where we are now, given July or August. We pay, again, at this point, just for the property itself, we put over $60,000 into it. We're paying lawyers' fees for over a year now. All this money is coming from the membership itself. All that we're trying to do is just have a place that's our own, so that we could pray, so that we could learn a little bit. And to be quite frank, there's nothing else to this than that. We're not trying to make a whole community center. We're not trying to use a place as a social hall for big events. It's simply a place that we could, that we could use in order to pray. As the chair said at the beginning of this discussion, on the Sabbath, the parking is not an issue. Nobody drives to shul on Friday night or during the day. This is an issue for let's say for morning prayers or evening prayers, and we will do whatever we can to enforce that our people are not parking there. And I can't state it any clearer. We're good people. We want to be good neighbors. When I spoke to the neighbors, one of the concerns that they had brought was pedestrian traffic, the people from the shul on that kind of a road, that there's no sidewalks. We agreed to put in a sidewalk on our dime. We've discussed the width of that. That was in response to the concerns of the neighbors. We agreed to put in a speed bump or speed bumps as considered necessary. We'll do what we can in order to preserve the safety of the neighbors, our safety. And that's what we're committing to do. We're committing to do whatever we can. If somebody comes, just like it's been in the last 4 years, if somebody comes in and raises a complaint about something, we'll address it immediately. And if we need to ask people to find another place to pray, we'll do that. The question was asked that, what the chair was alluding to, why do we need so much space? Honestly, the only space we need is a sanctuary, is a place that we could pray. There was a library, as the council just mentioned. We did ask for some library space. We'll move that down to the basement. It doesn't have to be on the main floor. We could put that in the basement. The basement is more so that after we finish praying, we could have like a get-together downstairs, put out a little something to eat, to drink, and just for people to socialize a little bit downstairs. There's nothing more that we're planning on using our downstairs for primarily. We currently have between, as I mentioned, we have about 80 families. It's not only men, the men and women daven separately. In the men's section, men have boys. The boys pray with their parents. The reason we fit into where we are now is because not everybody shows up every single week, because sometimes there's different events that happen. But with the space that we have, honestly, we're asking for 166 spots in the men's section. With 80 families, that means it's basically, if everybody shows up, it's one father and son. We're not asking for more. We're really not asking for more. We're not asking for a kitchen on the main floor. We're not asking for the library we had put in. We'll take that out. All that we're asking is for this space. We're not asking for anything else. You know, it's not like we just found a cheap lot and said, you know what, here, $500,000. We found something cheap. We've looked, we've gone from place to place. And we're still looking at other houses until they get wind of the fact that, because this has schlepped on and on and on, it's costing us money per month. It isn't this big fancy organization that has, every time I myself go and ask people to please contribute more and more. I don't draw a big salary from this. I have a day job. I'm the dean of a school, of a rabbinical college. You know, it's nobody's business. I really hope, I'm imploring to you that you look at this favorably. Nobody's trying to cause harm. You're not trying to take advantage of people. We're good people. We want to do the right thing. We want to comply as much as we can with safety. You know, the issues that you're bringing up, I'm listening. These are all the real issues. Nobody's saying that these things shouldn't be addressed, but we will address them. The fire trucks have to go down that street now also. They always have to go down that street. We will do what we can. I don't know if there's any way that you could give us a court order or something like that, that we need to enforce this, and we will.
Only we had that authority. Okay, thank you. Thank you very much. Thank you. Okay, so here's the thing. You know that we have this issue of self-created hardship, right? This is the first I've heard of a willingness to reduce this building, right? And I hate that after all this time, it's when we're just about to close this and vote this, and everyone is basically in agreement that you're failing on 3 findings, that all of a sudden there's a willingness to work on the findings, right? So the building is too big. You need to do what is the minimum necessary for the facility to do its job, right? Take out all the fluff. Don't have 2 of everything. Don't assume expansion in 10 years. You have 80 families now. Don't assume that it's a 400-person facility. Double function it, right? So the multi-purpose space and so on, those things double function. The site is too small for what you want to do.
If I could just respond.
Yes.
If I could just respond to that. We're not doubling any space. The men and women do not pray on the same
We
level.
understand that. We
So
understand that.
we need 160 spots. If every father brings 1 child, we need 160 spots. We can't make it smaller than that.
So that's 160. That's different than the 400 that we're told are needed.
No, the only 400 is the mezzanine. That's for the women. Every man is married. Right? So you have 80 women coming with daughters.
If the
There's
building
nobody
turns
else.
out, no matter how you do it, to be still too large for the site, then you're still not responsive to our request that we mitigate the impact of this building on the community, okay?
So what is the chair
need to
proposing?
be whittling down the size of the building significantly. It's too big. It needs to pull away from its neighbors. And this is an extremely large floor plate on a tiny site. And in terms of this subject of self-created hardship, which is not something that you would know about, that's Richard's department, in terms of the self-created hardship, the subdivision of the lot by the seller is forcing you to require us to make these waivers of the zoning regulations.
If I could ask the chair.
Mr. Sanders,
Sure.
so if you can just let her finish her statement before you respond.
So by subdivide, so, you know, if I can make this a lot easier, had the property owner of the house instead sold you their lot, you could have taken the house and expanded on the house and built a synagogue that fulfills all of your needs, right? But instead what happened is the property owner subdivided their lot so that they have enough land to support, in terms of zoning, their house, and sells you, and by the way, he made a very good business deal, $5,000 a month for an option contract, where you don't even know if you're going to get a variance, right? So, you know, good deal for him, right? But the assumption that it's okay for him to create a hardship complained of, which is what's happening, is a big problem, and now I'm really addressing this to Richard. I don't want to see, and we will, because Richard will bring them, other cases where another property owner on a nice big lot subdivides it, and up comes another religious institution that makes exactly the same argument as you do, and as you are doing right now, and says, what are we supposed to do? We're in a trailer, we don't have enough space, and therefore, we start to see an entire genre, right? A lineup, frankly, of cases that are exactly like this one. That's not what deference was for. And this is what, and deference, because again, you're not a zoning lawyer. Deference is the issue of that a religious institution is allowed a particular sort of pass on making certain kinds of arguments, but it was not intended to create this kind of never-ending opening of opportunity for property owners to take advantage of both the board and the institution that comes to it unwittingly to set these kinds of things up. I'm still extremely uncomfortable with it being set up as a subdivision like this. And so we're working carefully with the case law that, let's say, impacts how we make our analysis, and the willingness of this institution to bring this down to absolute minimum, and I'm not sure that we're going to see the absolute minimum, but let's see.
If I could just add that the definding by the explicit terms of the section 7221, it's not, it doesn't defeat a variance application if the other findings have been met. And so that in mind, I just want Mr. Lobel and his team to consider. We've heard a lot of the concerns of this use at the site, in particular the traffic and parking. And so if you may want to consider off-site parking facility, you're asking for a parking waiver, and we're learning that the streets can't handle if this site is visited to the extent anticipated by the zoning resolution. So if you could explore an off-site parking arrangement, that I think would go a long way towards mitigating the impact of this use in this.
But I do want to add that I'm not only concerned about parking by the congregants, which I am concerned about.
Okay.
I'm concerned on the Thursday night when there's a bris or something like that, and everyone's coming and they're all parking all over the place because they have to go from there off to dinner or something. I am concerned about that.
Okay.
But I'm also concerned about the fact that it's a 20-foot wide roadway, and we have been told by the fire department on every GCL waiver that a 20-foot wide roadway is a risk to the users of the roadway, and that's even the case when we've got an existing 20-foot wide roadway and 3 houses want a GCL 36 waiver, and fire department gets nervous, and then we just had a case where we just decided that a minute ago, and we have a restrictive declaration, no parking, all that, and we know it's kind of a useless effort, but nonetheless.
Again, this is a public road, and use group 4s are permitted at the site as of right.
Well, as of right, well then have
Chair.
at it.
We get it.
Yeah.
We thank the board for its comments. We understand that, with regards to religious deference, a religious deference application is at its most powerful when it is for, a sanctuary, a place of prayer. We will make sure that this institution is at its core that it is, which, as the rabbi has attested to, it is basically for prayer. And so we've gotten all the board's comments. We understand with regards to the term fluff, and we can address that and come back to the board.
I was looking at the elevations on the sections and the ground elevations, and I see that the elevation is kind of like, it's about elevation 20. If this is in AVD, would you consider like putting another cellar? My experience with this area is that the groundwater is probably about 0 or maybe even negative.
Okay.
So if you're willing to put a sub-cellar, I believe it might be very possible.
We're happy to look at that.
And in addition to this, you have a typo on the elevation for the cellar floor. It says negative 7.46. I believe it's positive. The negative is not, shouldn't be.
I think the only thing we would say, Commissioner Shea, with regards to a sub-cellar is that to the extent that we're required to have contiguous worship space, that obviously affects it. That would allow us to have additional accessory space, but again, it's something we're happy to look at.
Sorry, and to clarify my statement on the record, it's not that the D finding says that it alone can be dispositive of a variance, it's that the purchase of the property alone cannot itself defeat the variance.
Correct.
And
Purchase-
I think what that means, and if you want case law to try to explain that to us, but I think we've talked about this 2 hearings ago, I think what that means is, in a sort of innocent purchaser situation, when I say innocent, not created by the current owner, which is the case here, or a predecessor in title, right? That in 1959, the zoning lot was subdivided, and it wasn't called a zoning lot then, maybe, I'm sure. It was subdivided and created a little triangle, right? So then the owner of the triangle comes to the board seeking a variance and complains that zoning is preventing it from using the little triangle, right? In that case, we can't say you created the hardship because the subdivision occurred prior to 1961, right? And yes, by a predecessor in title, but prior to 1961, and that's the standard we use, right? So in that situation, the purchase of a zoning lot that's subject to the restrictions complained of, that are sought to be varied, are not self-created. But it is self-created when you self-create it, and so I don't think that D is excluded if it's the only finding. Obviously, the case is stronger if it's the only finding, but I think D can be a standalone, and that's when we asked you way back when
Right.
to brief how have the courts treated D in terms of deference. There aren't really any cases that
Thank you,
treat
Chair.
D in terms of deference, but there might be, if you wanted to beef this up, D in terms of whether, and I don't think there are any cases either, I think we talked about this, where the court actually looked at D as the sole reason for denying an application. And in other municipalities, they don't have our zoning resolution.
Right.
So they're relying on a different standard where the courts apply it differently, but the zoning resolution basically trumps a
Correct.
more lenient common law.
Right. I mean, what we have found, and again, the chair's correct, when applying town law, there was a balancing test that was employed by the courts. But we did draw a distinction between area and use in our papers, and additionally, what we did find, to the extent that there is limited case law on this, was that cases where self-created hardships were found were ones where there was a view towards purposefully taking advantage of the zoning law, the fact that an applicant created the hardship with an eye towards receiving a variance, which would, the evidence that we've submitted here was that was not the case. Commissioner Shanda previously commented on evidence we submitted that there were plans here for subdivision to residential, that this was marketed as a residential property as of right for, a period of time, and only after that did the synagogue come in, which we think is a mitigating factor here. We understand what we have to do.
Your cases didn't show
to
the
add-
owner. I'm
Sorry, go ahead.
Your cases, the case that you attached were not the actual owner who created the subdivision.
Right.
Well, the case,
Purchasers thereafter.
right, there was a case that we submitted with regards to the fact that a subdivision was found to be just self-created hardship in that regard. But we can clarify the law.
Right, okay, but I mean, I just want to say that if, reminding ourselves constantly that that there's an owner of this property, right? The owner who subdivided to allow residential. So if we look at it, the owner is the applicant, which is effectively what this is, because the owner is making money every single month in its option contract. So the owner is benefiting from sort of the future deal, right? And the future deal is dependent on this variance, right? And if this particular deal doesn't go through, he can go back to marketing the site as a residential site with a pretty wackily designed house, but nonetheless, you can get a house on that site. So then I ask, what's the hardship that the owner, the actual property owner, suffers here? None. So, and that is, for me, that's another part. The purpose of a variance is to cure a hardship caused by your unique physical condition, right? And if we just remember that that's the kind of underlying reality when the owner is a non-religious institution.
Although again, not to belabor this, but we've got.
You can have a contract vendee, what? I get it, but at the same time, look at the situation that's being
doesn't
set
make-
up by the owner.
It doesn't make that statement.
Understood. Just
Yes.
understood that, again, we're a religious applicant, we have a valid interest in the property, but again, we get it.
And again, what do I do about, I'm just looking at actually the site that was in the case that was cited to now, on 100, what was the boulevard? It was one of the cases that was cited to of the subdivision of Lot 63. Now I can't remember what the street is, but anyway, I'm looking at this long street, this long lot, and they could have easily subdivided the really nice, fantastic lot to allow only for the little piece that has this little wedge cut out of it. And then a religious institution could have come to us and said, oh, look, we want to build our, whatever it is, house of worship here or school here, give us all the waivers, even though the neighbor still owns the site and is subdividing it intentionally so that we go for a waiver because the BSA is bound by this Cornell doctrine. I'm just, huge floodgates.
Okay.
Okay. All right. I really wanted to close this today. I think we should close this, and if there's anything that is persuasive in the submission, we'll reopen. Otherwise, we won't, because we've been at this far too long, and the issues have been the same since day one. So, yeah. Okay, so a motion, did I ask, I did ask if there were speakers. A motion to close.
Chair Carmona?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right.
Okay, so your submission,
How much time would you like?
If you can give me one moment.
Yep.
We don't have the benefit of the project architect, but we would say that at a minimum, they would probably need into late May, early June in order to prepare materials.
so like a month to prepare. I think we have too many on the 25th. The July 16th?
Yeah.
Exactly.
Okay, so the earliest we have available is July 16th hearing for June 26th submission.
June 26th submission.
2 months, a little more than 2 months.
It's a little long.
We just don't have anything.
It is closed.
It's
but
closed, but there
they
might
may
be a
submit
very
a lot.
large submission, we don't know.
Hearings.
So, yeah. Let's just do that.
Okay.
Yeah.
Okay.
So next hearing is July 16th, is the decision hearing. Submission, June 26th.
Thank you, Chair, Commissioners.
Thank you.
Item number 22, 2018-95 BZ 120 MM Brooklyn.
Oh, sh. That's 4 o'clock.
Can't see hands. Thank you. I should memorize this. As I tell you, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board in response to the board member questions? Yeah. Okay, go. You start. Thank you.
Richard LaBelle of Sheldon LaBelle PC for the applicant. I'm joined by David Rosenberg from our office, as well as representatives from HASC and project architect and environmental consultant. We expect this will be a very substantive hearing due to the fact that we had a representative at the board's executive session and understand and agree with many of the board's comments with regards to substantiation of the programmatic needs, as well as making adjustments to the program space to better fit those needs. We understand the board's comments with regards to the bulk that is requested and that there are certain adjustments which can be made which would allow a reduction of the waivers here. I would first note that with regards to programmatic needs and the case law cited with regards to treating the subject institution, HASC, as an educational institution, we appreciate the board's consideration of this. We understand that pursuant to Asherokan versus Patasi, that there are critical elements that have been found to allow for consideration of an institution as a school which would benefit from educational deference, those being, one, a curriculum, two, a qualified staff to institute that curriculum, and three, a physical plant sufficient to house the education that takes place. And so we will be happy to submit further on those particularities in order to substantiate our educational deference, but we do note with gratitude the board's consideration of the Clifton Park case and the consideration of the Saratoga Springs Center in that case, where it was specifically found that developmentally disabled students may not have the same educational indices as you would view typical children as school. They may not, again, as was cited in the case, be attending orchestra recitals, but that their needs are serious needs and that the programs that are engaged in by those students are just as important. With regards to that and with regards to the curriculum, we do note that there is intake which takes place at the school. There are standards set forth by the Office for Persons with Developmental Disabilities. There is a qualified staff and professionals who institute that curriculum and individualize that based upon the needs of each of the students. So we feel that we're going to satisfy those requirements.
You'll go through
Correct.
the training,
Yes.
skill sets, et cetera, of all the faculty.
Correct, yes. I think at this point, I might have the project architect discuss some of the particularities with regards to the bulk of the building. I know that it is my job and David's job to provide further evidence to the board regarding the educational program, but I would note the chair's and the commissioner's discussion of potential reductions in building height, street wall height, bulk, et cetera. And what we'd like to do to make this more substantive is really have, a very thorough discussion regarding what the board feels should be accomplished here and be able to accommodate that when possible or to provide further evidence when we feel we cannot. But I would say this in the spirit of good faith and that, we've had our serious conversation with the school and they get it and they understand that there will be a reduction in the size of the building. So, Charles, do you want to?
State your name.
Charles R. Schwartzaffel. Good afternoon, board members, chair. We can discuss the building, all right? So much for that one. Give me 1 second. Okay. I guess the best way, or do we want to use the plans? I think would be the best way to do it, to show how the process works. We went through great. Okay. Just bear with me 1 second. got so many files open. Excuse me. Okay, so,
Need to take the mic with you, sir.
sure, thank you. Okay. We have generated through the programmatic needs report and the utilization chart and all of the potential growth in the next 5-year process to bring into the building all of the services from the multiple facilities and the satellite facilities throughout Brooklyn. And the process to have the system work effectively, would be that with the numerous day habilitation programs that, because of their existing and their particular needs, we did on the first floor coming in off of Avenue M and then off of East 2nd Street, we put in a co-ed station for those that are ambulatory that would have the easiest access that are wheelchair bound.
Can you point specifically to where
Where the process is, yes, if this is Avenue M, McDonald, where the transit is, and then East 2nd Street, we have incorporated a facility here that is, I could give you the square footages, which may help.
No, that's okay.
Oh, we'll do that after? Okay.
We have that
So within this area, so we've provided not only a day habilitation program for the co-ed facility where there is a facility for some cooking and preparation, there are classroom facilities, there's some meeting area facilities, some staff and toiletry facilities that will service coming off of one side of the Avenue M and 2nd Street. We have coming into a central location, we had addressed for the Article 28, that we tried to do a central area for the facilities for medical, for dental, for psychiatric evaluation for all the clientele that would not only come in off of the main area to maintain, but also provided some of the staffing effective for on this floor. We did incorporate into this floor also the refrigeration trash receptacle for housing of that, so that could be kept indoors.
Before you change, what's the other lobby that's on, I can't see what, McDonald?
We have a recreational area here with an auxiliary emergency entrance for any kind of medical where we may need ambulance or...
Sorry, where's the recreational area?
When you have certain clientele come, they need to be isolated, so they can't stay into the same area with the rest of the waiting areas. So there's a secondary area that also provides for, in the medical facility for observation, that they have other staff and that sit with the clients that get agitated and can't sit or can't stay with.
So it's labeled as a rec room. What does this mean?
The rec
It
room.
says rec room, auxiliary entrance. Let's hear better what goes on there. Is there somebody here from the program? Let's hear from the program administrator. I don't like all these different people who are guessing. Let him answer his own question.
Please state your
Hi, I'm Samuel Kahn. The rec room at the end over here, we'll call it a rec room, but it's a waiting room / a rec room. You have some people with psychiatric issues, and when they sit amongst other people, they're just not appropriate, so we have to create something different so they can sit by themselves with less. There's different type of recreations for them, maybe different games and toys and things that they can keep them busy so they keep out of trouble while they're waiting for services, whether it's medical or psychiatric or psychological services.
But it's a very large space. That's why I'm wondering, if you're talking about a person who needs to be isolated,
sometimes,
why is it and shouldn't be with other people because it would make that person...
sometimes it's people it may not be a slew of 10 or 12 people, maybe 3 or 4 people, and sometimes they're wheelchairs. Wheelchairs need a huge amount of space to turn around and just to be comfortable. So just as another entry area for wheelchairs, just for wheelchairs to come in, and for wheelchair people, sometimes a regular waiting room gets a little bit jammed up, so people in wheelchairs can also come back to this area if there's no other disturbance. And it will be used very, very well as a waiting room. It's called a waiting room, rec room. It's a lot of different activities are in there too to keep people busy while they're waiting and keep their minds working. This has been created through our psychologists who, it's not something that we just figured out we want something like that. The professionals who will be working in the medical center, in the Article 28 Medical Center have requested that type of a facility.
Okay, ascending to the second floor, we have the separated men's and women's rehabilitation programs that come off of the elevators into a reception, at which point they're guided either into men's facility as well as the women's facility, both having the similar programmatic needs in the classrooms. They're training for their kitchens areas, for some computer processes. We've tried to consolidate and bring in a laundry cleaning area into one area here so that will handle all of the soiled linens for all of the 3 programs, as well as then some staffing facilities. We're also coming to the women's facilities too. We each have a shower within that setup, classrooms, and also have some proximity on the same floor that we provided the OPT and the physical and occupational therapy that comes off of a separate area.
Did you prepare the programmatic needs analysis? Who did it?
My office did, I did.
Your office did it, okay. So when you sat down with your client and you went through the various things, right? How did you decide, or what kind of statistical information were you given to determine how many classrooms, how many treatment rooms, how many this rooms, et cetera, et cetera? So, for example, how many classrooms? How did you decide the size of the classrooms? What was the occupancy? Because the way you're showing these classrooms is they're really tables of 4 each. I mean, maybe it's just furniture for informational purposes, but is that how you were looking at it? 12 people per classroom sitting at tables? Is that what the
Yes, for the classrooms there were, we went through the programmatic requirements for each one of the departments. I spent a great length of time giving out questionnaires to all of the directors, meeting with them personally, having them not only submit their responses and their answers, then going over with them and having further interviews with them, and then determining and generating the program. Went through a number of iterations. I have all of the documentation with me that I brought from last July of 2017. I have all that documentation with me because I know you had requested it the last time we met.
Right.
So that's here, but what it did, how we broke it down, if you go to the different reports, each one of the reports, on each one of the programs with reference to the rehabilitation programs, we have the number of occupants, of which in the 5 classrooms, we have 12 occupants in each classroom, at 350 square feet for each classroom. We put in lockers that counted for 50 square feet for the lockers, and closet storage as well. We also needed to, in the layout of the plan, to do mobile partition walls so that we can, if they're going to do programs or events or, day parties, that they can open all of the walls together, and they could also share within the programs when they're doing individual rehab
Right, understood.
entertainment or facilities. Some of them will do arts and crafts, sometimes they'll have, with holiday parties or such. So that was just for, and again, the example I give you is just for one of the day. I've done that for all of the program. We did that for all of the, each and every one of the programs that are required.
Okay, so here's my question. A lot of the times we see programmatic needs analyses that actually done sort of after the fact. The project is designed, and then we see, oh, look, this number of classrooms is absolutely perfect because it satisfies the now described need after the fact of the drawing. What I would, so in other words, kind of backing the drawings into the programmatic needs as opposed to the other way around, since you're both the architect and the creator of the programmatic needs report, and your client, you sat down with your client to work out programs so you could start to draw, which is the way it's supposed to be done.
Yes.
I would be much more interested in seeing your initial tabulations where you sat down with the director of the DayHap program and the DayHap program.
Can I grab them?
Yeah, yeah.
Great.
I mean, you don't necessarily have to do that in front of us, but that would be something that I'd want to see submitted. Because it's actually unusual that you have an architect who programs it with the client in most of these cases, right?
I did not start any graphic detailing or any type of
Understood.
bubble until we went at great length to, I could submit these later and I'll scan them all in, but just to give a level of the paperwork that was done, we met for each of the programs, and starting in July of 17,
That's when you were more
That was, I
around
was,
when you
you
were
know,
hired.
correct.
Yeah, okay.
Before I walked the building, because I wasn't sure, they hadn't told me they had the building, they told me that they wanted to review what we needed so we could come up with the intention. Once I walked the building, it was kind of trying to, with the empty slate, to pick and choose and see how I could then make a Tetris kind of game for it. But from these initial, from the initial notes, then carried on. Would you have a seat?
Can we approach?
Chair.
Mm-hmm.
I think maybe we might want to kind of organize the data and
Yeah,
present
but
it.
let him talk it through a little bit, and then we'll have him organize the data.
These were my transcribed notes from
Okay,
the,
right. Okay.
yeah, these were what we had sent out, all the questionnaires that we had sent out.
Okay, that's really good. Okay, so what I would like, and this is something that you would do, is get us from your, what you learned on the interview process, your interview and so on process, what the set of criteria that gave you, and then, that's all I want. Then I don't need to see how you got to your answer. We could see that in the floor plans, right? So, right?
I thought that the programmatic report took all of that information and brought it into the program.
But the thing is, you were given a floor plate of X, right? And so I'm just guessing your floor plate, so it's never that the client asks for everything, for all the stuff, and then you give them every single thing they ask for, right? You say to them, you know what, we're not going to be able to do this thing, right?
Absolutely, and I
Right,
have
so-
about 100 of these pairs from, even going from iteration after iteration and moving back and forth walls, moving back and forth spaces. We did have the confines of the physical walls.
Right.
But even that, we're up an additional 2 more stories, we're trying to accommodate
Right, understood, okay.
what we can. And after the last meeting, and the issues with the EP where we had sound issues we knew we couldn't deal with when coming up to the 3rd story, which used to be an exterior, I don't know if this is the one, an exterior terrace.
Is the mic
we
on?
enclosed
Can
that.
you just touch it to see if it's on? No, not on.
Would you turn it off?
Yes. No? Oops, what happened? Tony.
Unplug it.
Try it again? No?
What?
There's a, I don't know what happened.
I don't want her to bend.
Up here?
Now we lost our mic. Oh, great. Give us a second. Do we have a second mic? No. Of course not.
No, we have the other mic.
Oh, yeah, maybe play around in the back room. jiggling buttons.
Not you, Tony.
Talk louder.
I'm just not sure whether we pick, oh, there is another mic. There's another mic. Fire department to the rescue.
I don't know if that works, that's the problem.
They're prepared.
Try. Yeah, Mike one.
There you go. There you go.
Thank you for noticing that your mic didn't work.
I have echoes in my head, but that wasn't them, so. Okay. I'm not sure if we need to backtrack at all, or move forward.
No, just start where you said the recreation area.
Okay.
Yeah.
So on the third floor, we had designed in for the recreational area we were going to do was for an outside terrace, and again, their recreational facility is in a basketball court, and they're not running and dribbling. They're more like convalescing. They're out to get fresh air or to just to change their environment. But we still were told that, with the report, that the noise mitigation was something that we were going to have an issue with, so that's why we enclosed it. And we enclosed the space, and also at the same time reduce the training. We tried to multitask the room, not only as a gym or outside, for activities, but also to do the training, and also to have, when they have big assemblies, because there are times when they'll have all of the day hab clientele in one space, so they can have a party or an assembly of what have you.
So I'm a little confused by this space, because for one, in your programmatic needs analysis, or maybe it's in the statement of facts, but I think it was also there, it says that that space is actually for training, because all the staff needs to be constantly trained, right?
That makes it a I'm sorry.
It's located on the third floor, and the adjacencies are all administrative, agency maintenance, vocational training room, which we learned is actually the people who run the vocational program. It doesn't look like any participants in the program normally come to the third floor. So I'm confused about locating this use on the third floor. If this is actually supposed to be the recreational area that's replacing what was on the roof.
Correct. So we need the space to house all of the clientele. So on the first and second floor, to put the multi-purpose room, that didn't make sense. Granted that it's located, Sam, if you would like to also comment on it. Okay, the fact that the adjacencies are the ComHab or the quality assurance and also some of the maintenance is part of my layout to work the flow of the space. We did put 2 larger elevators in that house up to 4 wheelchairs in each station, on each one coming up. But to locate this room, to locate the multi-purpose, whether it was for training, because there is a lot of training that's required, there's also the times when when the first and second floor clientele need to come up and use this for their for relaxation, or what would be activity, for them would be activity uses.
Question. So on the second floor, I'm just trying to get to the plan. On the second floor, the PT room and the OT room.
The PT room?
The PT.
The physical therapy and
an occupational therapy, okay.
And occupational therapy room. Why can't those be used for training programs? I'm assuming those training programs are going to be held after the day hab program is over, because the training program is for the case managers and the staff, not for the day hab programs.
I'm not sure if I could answer that one better than perhaps Mr. Khan can. I know that the physical therapy and the occupational therapy programs, they have 2 to 3 different clienteles that come in to do that, and the utilization chart says, and indicated when, in fact, they have, when those rooms are being occupied and by how many occupants, and I believe there are conflicts between those, and when staff is going to be brought in to train 2 to 3 times a week on staff training. So I'm not certain that those can be interchangeable. I know that we ran that, let me have it here.
Well, and to follow up with that same thought, when you look at the utilization chart and you look at when the lunch areas are being used, the lunch areas are actually not used except at lunchtime. And we see in many schools, many schools, that they fold the tables up and they move them to the side, and then that becomes the multipurpose room. So why couldn't that be the recreational room that's used apparently occasionally because it's being shared by the training room? So, yeah, and all of this in the interest of reducing the size of this building, right? So there's these large expanses which don't seem to be used all the time that could be multi-purpose and are instead treated as if they can that the tables are bolted to the ground and can't be relocated.
Let me just grab that one chart.
Okay.
Yeah, so PTOD therapy lasts at 15. So based on the utilization chart, the PTOD rooms are last used at 3 p.m. And then third floor.
Yes, and the dining in the day habs are used between what looks like they have 12 p.m., but they use at 9 and then use at 10, 11:15, and again at 1:30 and 2:30 as well. Not as ostensively and as maximized, but they're being used throughout the day.
No, throughout that period, not throughout the day.
Yes, well, throughout those specific periods, yes.
So that's the question. I mean, I don't know.
I'm just trying to find on the other. I had enlarged these a little for view. I can see.
Find the third floor rec room.
Training rooms.
I don't find that.
Okay, thank you.
The I don't actually find the, that recreation room / training room doesn't even show up on your chart.
Also, having the training room and the multi-purpose recreational room next to the therapy rooms will be disruptive to the clientele as well.
But it would be super disruptive to the administrative office, right? You're putting, what you're saying is recreation next to administrators. That sort of doesn't make any sense.
I located the multi-purpose room next to what would be the maintenance department, a kitchen lounge, and then some of the vocational, which are the vocational offices. So most of the other administrative or operational facilities and offices are on the west end of that, or the east end of that, the west end of the building.
Can I help Charles out for a second?
Yes, please.
I'm Sam Kahn. The third floor,
Identify yourself for the record.
He just did.
No, you're affiliate, what are you, the,
I'm the director of HASC.
thank you.
The third floor, what we call it, Charles called it the admin part of the floor. That's program admin. It's not admin for the agency like the accounting and the...
No, we're not disputing that. It's more that...
And I'll explain to you why the training needs a separate area. First of all, when the individuals come out to the lunchroom, they're not sitting in their classroom all day long and just come out for lunch. They're in and out continuously. Many people, we have like in a day hab room where you have, say, 8 or 10 individuals, there are about 3 or 4 staff with them. Why are 3 or 4 staff with them? Because they need to, many of them don't behave. They need to be walked around. They need to be held. They need to be taken out of the classroom, the four walls of the classroom, and just walk out of the classroom because they start to get uneasy, and they display their behaviors in many different ways. So that's why we have a heavy staffing. Besides all that, besides the staffing that gets trained that's in the building for Dayhab, we have close to 40 residences, group homes or residences, I don't know if you know what that is, where individuals live in the community. And that has a lot of staff. Many of the homes have as much as 20 and 30 staff. And all the staff people have to be trained. They're trained when they come on, when they first start working, and there's continued annual trainings at OPWDD and make sure that we train them in many different ways, anyway from feeding and the size of food. If people have seizures, how to control seizures. People have behavioral issues, how to control behavioral issues. And simple ways of dealing with people with disabilities, respecting them. All this is training. We have driver training because we have so many vehicles on the road, vans and cars which transport the people. So there's continuous training going on. A training room is a very, very, very important thing. Sometimes there's only 10 people. We even have training to give the individuals meds, medication. They get psychotropic meds, so staff need to be trained. So the training room on the third floor is a very, very important room for us, whether it's a few feet bigger, a few feet smaller. Sometimes we have group training where there's 20 or 30 people together, and sometimes 50 people together, and sometimes like an AMAP, that's called distributing of medication, that they only have as small as a small group of 20, 15 to 20 at a time. So that is a very important part of the building.
But for example, your dining room that's on the first floor, just one of them, there's a couple of dining rooms, right? And it's got movable walls, right? The dining room shows it's not occupied after 3. Why couldn't the trainings go on after 3?
I'll tell you, the prime time of people in our residences are from 3 to 11. We run around the clock, 24/7, 365 in all our residences. And we have several hundred people working in our residences. So most of the prime time is either from 3 to 11 and 11 to 7. From 7 to 3, from 7 a.m. to 3 p.m., most of the people are not home. They're in the group homes. And we have very little staff. So those few people when they go off duty at 3 o'clock, they can come for their training. But the bulk of the people have to come during the day for training because they work the afternoon and the evening and the night shift. So you can't always use a dining room where people are for training. And another reason for that is when the individuals come out of the classrooms, they're basically emptying out into the dining room. There's not a special corridor running across, and because of that, it's very interruptive. So we do need a more quiet space for the individuals, and also when individuals see there may be their own direct care person in the hallway or see them, they just get disoriented. And
That's an effect of the architecture. You could put up walls or.
That's taken.
That and scheduling, I feel that this issue could be resolved with some scheduling and as the chair just said, some walls put out in appropriate places, as opposed to every use needs to be individual.
You see, what we're doing right now is we have training off-site because we don't have place for training, and it's very costly and it's very cumbersome. It's very difficult to schedule that type of training. The people that are on duty.
Schedules, right?
I have a question. Sir, you mentioned that right now the training is happening off-site.
Right.
Why is it important for the training, the staff training, to be located on-site?
Because because the trainers are there, and it's important to have everything together. If there are any issues, it's very costly. If I have to go rent space, if I'm building a building, I might as well,
No, I need to understand more from a programmatic point of view, not from the space need. It's, do the trainers need to be close to the day hab clients, participants? Do the trainers need to be close to the medical facility that is provided? If the training is happening off-site, okay, maybe the best way to answer it, what is right now happening off-site, the training? What kind of training are they given, and who is providing that training, and where are they coming from? And where is the connection between that and your currently the 3 locations that you have where the day hab programs are being provided?
they all come to a central site. All the training is done in the central site. We don't have training in the different day hab sites, or very little of it. It's mostly coming to a central site. The administration is there. When the individuals come, when the staff come for training, there's also other things that they have to take care of, paperwork, and it's very programmatically correct to have the training in your central office, in your central building. To have training in different sites, people just get lost. There's no computer hookups over there. We're working, right, if everything is in the central office, we keep track of every individual. We employ close to 1,000 people. And everyone knows where their trainings are, when they're due for different trainings, because certain trainings expire every 6 months, or every year, or every 2 years. So having it together it becomes very efficient, and you're running a good ship. Having it spotted in different sites, the computers don't work right, the internet is not up. Having it on site is the right thing to do. That's we're building a building. We're building a nice building, and having it again splintered outside in the community is not really what.
I can appreciate that. You sound like you have it very organized as of now. I'm suggesting that perhaps while using that organization and scheduling, we can use one of these other rooms at a different time. And that would save on space, and I'm sure there's ways to, being that all the benefits you're going to have from having this all in one building, I'm sure there's ways to work that out.
Mm-hmm. David Rosenberg of Sheldon Lobel PC. Just to reiterate what Mr. Lobel said at the beginning of this, understanding the board's comments about the bulk of this building, we're going to go back and look at these more carefully to see if there are other spaces to do. But Mr. Khan's point is really to underline, and there were a lot of comments yesterday from the board in the review session, that a lot of this administrative space seems extraneous. And what Mr. Khan is driving home, and what we're going to continue to do in more submissions, is to really drill down that all of these functions are key to the actual habilitation programs run by HASC Center. And they're not just things that we do to cross off the books, but they're vital functions of the program that the habilitation can't continue without these programs being able to do regularly. But as to space, and as to scheduling, and as to combining spaces, we're going to be going back to look and see if there are some other things that we've overlooked before, or if necessary, some places where we need to find compromises that we can make.
I would say I'll find it very difficult to understand how fundraising has a direct correlation with a day hab. Yes, I understand you need to raise the fund to operate this program, but there is no direct correlation on a day-to-day basis in terms of adjacency. So I think you need to keep that in mind when you're describing this and why they need to be right. We understand the need for, I think you've explained it very clearly in this submission, the need for the medical facility and the day hab. I still have not gotten to the 3rd floor and the 4th floor.
So I distinguish between the 3rd floor and the 4th floor, just because I know that you pulled out the fundraising in particular, but the difference between the offices on the 3rd floor and that take up some of the 4th floor, and then some of the ones that we call central office functions, that 2213 refers to as central office functions, is permitted uses alongside use group for nonprofits in residential districts, is that a lot of the level of care that we're giving, especially with Medicaid-funded programs, and we're going to talk about this more in the submissions, is very bureaucracy-heavy and requires incredible amounts of record-keeping and paperwork and compliance work that requires more intense involvement from back office staff, as we think of it, than a traditional medical office that has a couple of people to make sure that the billing records are in place and that the bills go out. The Medicaid compliance here and the the Office of People with Developmental Disabilities guidelines that regulate what we do at HASC Center make this a lot more complicated, which necessitates a larger back office footprint, which is what we have in a lot of that. As to the other central office functions, and our papers in this submission touch on it, and we can expand on it more, they are an accessory use to this. We have a nonprofit. The zoning resolution contemplates with nonprofits that nonprofit organizations have central office functions, and those central office functions need to be centrally located with the nonprofit. And the zoning resolution talks about limits them to size and scope. And here, when you add up the numbers, it's actually pretty limited in size and scope. And that's why these are here, because these are central office functions critical to the organization. And the examples that we give, most of the other cases that we cite that have the Article 16 and the Article 28 medical and clinical facilities alongside with their rehabilitation also have their central office functions there.
Okay, but before, when you're speaking, I'm fearing one of those, we give you an instruction, you come back and try to argue with us, and this goes on for 6 hearings. I don't want this to go on for 6 hearings. I don't think you do either. So I'm going to make it very simple. You can't have 4 floors. The 3rd floor has to be justified in a way that's persuasive to the board. It has to have the required setbacks of front yard and side yards and so on, because we always, on all the schools we look at, we require that the administrative floor complies with all the setback requirements. We just never are persuaded that you need the office to be that big or the conference room to be that big, and lots of people sit now in collective offices where everybody sits at a tiny little cubicle, and so can all the administrators except for maybe the head of the organization needs a corner office kind of thing. So just to make it super simple, that's what you have to do. No 4th floor, 3rd floor, pulled back to comply with the height and setback regulations. And then I go to my question to the architect again. The existing building is 35 feet high. It's got a floor-to-floor height on the 1st floor of something in the way of 20 feet. I don't know, because we don't have the...
It's 12 and a half feet.
Not according to the section that was provided to us of the existing building. It's showing a very high 1st floor and of the existing building, and then a standard, because we don't know. So it's showing the floor-to-floor height of the existing building is 35 feet, street wall, but it's actually to a floor.
I think that was, I think those lines were those dimensions were for, as of right, and for the documentation.
No.
They weren't, I don't think they were for the actual building of, even though I saw the section showed it to be.
I think so. So, but the point is this, it's a 2-story existing building that is rising to the maximum, Richard? It's rising to the maximum height allowable in the district, or it's not, because it's a non-complying building, so I actually don't know what it's doing. But the point is, we're not married to the floor-to-floor heights of this existing building. It was an existing illegally built building, right? So, which never got a sign-off. That's why it's in the mess that it's in, right? And it was not subject, it didn't come here, it wasn't a deference decision or anything like that, right? So to the extent that the floor-to-floor heights of the existing building can be modified to drop the height of your building down and maybe squish your program into a shorter building, that could work. The problem is you're married to this existing structure for no reason. Right, for no reason as far as our waivers are concerned, right?
What if you did a mezzanine on the 1st floor and put in some of your necessary synergistic office spaces in that area?
Not knowing what the floor-to-floor heights are.
Yeah.
I'll need to verify the floor-to-floor heights. I don't think that the way this is projected is,
Yeah.
it doesn't represent a dimension, but...
I think it's 20 and 10. You need to look at the dimension and see if there's a way to kind of fit in some of the spaces that are on the 3rd floor with the as of right setback can be accommodated on that.
I shall confirm that.
Yeah. We're actually looking at your drawing, I guess it's your drawing.
I think it is on the-
That describes it as existing floor, existing floor, existing floor, new floor, right?
Yes, on an A105?
This is one of
So
the
is it
original
a
submissions.
A005.
Right, okay.
Right? And so, and that's why we're guessing, because we don't know, 20 feet between the first and the second floor, which sounds like plenty of room to slip in, for example, a mezzanine.
I believe
or
it's
even another
closer to
floor.
15, but I'll confirm that, and I'll verify that in the field.
Okay.
And if it is lower, it may be able to accommodate,
Okay.
if it's lower, does it accommodate a fourth floor?
Chair, I think that we understand that regardless, our programmatic needs need to justify the waivers that we're requesting, and we can't rely on an existing building for that.
Yeah.
So we'll successfully make our case, and if modifications are warranted, we'll include that in our materials.
Let's do this again.
Okay.
Let's do this one more time, okay? The proposal right now is for a 4-story building that rises to a height of 55 feet. It's too high for a neighborhood filled with 2-story buildings, 2-story little houses, adjacent to which you are, right? And so, either you eliminate entirely the 4th floor, or you realign the floor-to-floor heights in the existing building to squish your 4 floors into something that would be the equivalent of a 3-story building. I don't know what the 3-story building would have been, because we don't have that height.
40 feet, I think, maybe a little bit more than 40, maybe 40.
No, if you measure, this is to the top of, that's the top of the 4th floor. Yeah, exactly, to the top of whatever the 3rd floor.
Right, that would be approximately 40, probably 46 feet, if I'm looking at the 40 feet
Yeah,
to just above the
Your proposed building
parapet.
is 55 feet high. Oh, there you go, because we don't see it on that section. Your proposed building is 55 feet high, right? And when you get to the 4th, the roof of the 3rd floor is 40-something. So from my perspective, that's the tallest you can be. If you want to squish 4 floors into the existing envelope plus that, what would have been a 3rd floor, then I would be okay with that additional 1 floor, but not additional
Okay.
2 floors.
Chair,
But again, you still need to make the proof.
We will
that
make the
those
proof. We
administrative
understand-
functions must
Right.
travel together.
Understand.
Right? Otherwise, they don't need to travel.
we understand that in addition to the program findings, we need to discuss the character. We will do so. We have the chair's comments with regards to the building.
But did you hear me?
We did hear you, we did hear.
Okay,
We just
okay.
want to
Yes, we want to
note, we
discuss
just
the
want to note that
character.
we want to make sure that the area is characterized correctly with regards to massing and the buildings in this area.
You can,
But
you can
we
do
get it.
that, but we're still losing on height.
Understand. Well, we understand the
Alright.
chair's point. We intend to fix the massing such that the impact on the residential buildings will be lessened. We get that. But we also just want to note that the community board did unanimously approve the application. We just want to put that on the record. But again, the chair, we understand the statements that the board has made. We will adjust the massing of the building accordingly.
Please don't make us have 6 hearings.
We want
We don't
one additional
six
hearing.
hearings on this either,
We're
because
gonna
it's
actually-
costing you money every time.
We're going to ask that you close and vote on this at the next hearing. That's what
Okay,
that's what we're
we
seeking to do.
want.
Good.
We will keep the height of the building.
Sir?
Can't hear.
No,
You need- if you speak-
Okay,
No, no,
we need to make an additional submission. Sam.
Khan,
Sam.
Mr. Khan, please say what you have to say.
We will keep the height of the building as you requested.
Okay.
But can you vote on this today?
No, because you need drawings that we,
But we will get the drawings to you.
no, well,
We'll
we can't
get-
vote it on it today because you don't have the drawings.
Okay, but could you give us a closer date than July?
That I can't promise.
Give us a closer date than July.
No, that I can't promise. Right. Okay.
Okay.
By the plans and email them.
That's okay.
Okay, so Mr. Khan knows what the story is.
He does.
He understands it completely.
He really does.
He will inform his counsel and his architect to proceed accordingly.
Understood.
Okay.
Great.
All right. Are there any speakers on this? What'd you say? Parking. We left out parking. So we need to talk about this subject because it's not a small subject.
Yeah. Kevin Williams with Equity Environmental.
Yeah.
Madam Chair, members of the board, good to see everybody. So I took down all of your comments, and I think some of these things we were expecting. I think some things were overlooked in the environmental assessment. I just want to go step by step, because obviously parking is a concern here, because we're seeking to waive the requirement. So the first thing that I wanted to note is, based on the building volume and size and the requirements for the C-zone, 37 cars was the minimum. And so we stepped that up and did a similar analysis to one of the preceding traffic engineers based off of census journey to work data, and came up with that 67 number, because I think it more fully reflects a conservative analysis. And we usually do this when we provide a traffic analysis, is don't just assume that, the zoning is going to provide, particularly for a multi-fold, multifunctional type of building like this. So I wanted to note that, but I'd like to get out some of what I think are some of the easier questions to answer, or that will be more direct. The first one is on the the minibus and the van drop-off zone. So we have a diagram, I think it's on page 53, that shows the loading, unloading zone on Avenue M, not on Second Avenue, as I think was stated on the record. And it's clearly marked in the EAS, shown there. There's
Sorry,
no...
if you can just pause for a second. There's
Yep.
a lot of noise in the room.
Yep.
If you could just keep your conversations to a minimum. Thank you.
So just to clarify that, we definitely did not want to have it on Second. You got right-hand access to the sidewalk. There's no fire plug present in that diagram. We investigated it, and it's also provides the most direct access on a nice wide sidewalk into the entrances of the building. So, yes.
This would be in the secret document, right?
Yes, I think it's page 53 of the PDF. Actually, if you would like to see I could present this, if I may.
This one has this issue with the
It's on 53. And so the black line
I
there is,
see. Okay.
so that's the intent. And I can discuss the volume and the capacity, so you get an understanding of is this going to hold water? So of the day half participants, we hit 147. And so the way that they currently operate is with minibuses and vans. And so the minibus is approximately 25, and then the van is, 12, something like.
Capacity of each one.
Yeah, the capacity. And so the analysis, though, I think there's some, and this is one of the things with seeker. When you calculate the number of trips, it's trip ends. So we cited 112 on our traffic analysis, and that's a car arriving and departing. So it's actually just 61. And then the idea is that because we don't have parking at this facility, basically the people are dropping off are almost entirely the program participants in minivans and buses. And then also when we look at the traffic analysis, you have to do what's called a passenger car equivalent, meaning you multiply a van by 1 point whatever of a car. So actually we only have 5 vans and 4 minibuses dropping off during the 30-minute arrival window prior that would be staggered and planned. And now, so in terms of, one of the other concerns was family members and dropping off their loved ones, or a caregiver dropping off, and where do they park? Where do they go? And so what the analysis shows is, and based off of the current operations, there's very few people in private cars. Okay, so we're really talking about a very de minimis number, say 4 or 5 different passenger vehicles taking a private auto. Now that's just for the day hab. So it's mostly 96% is what's cited, currently utilized. So what happens when people come for a la carte services, the ComHab of participants that were referenced, the 700, and I think I want to clarify some of that, because that's the universe of users of HASC services. The day hab is the regular people that come all day for care and for habilitation. And then there's a certain amount that was quoted in the testimony, or in the board, 20 a day, which is 20 out of that universe of 700 that would arrive throughout the day off of basically, you call in and you have arranged monthly, or you have an acute care situation where folks would come for centralized services here, or for the, unique habilitation programs, for the medical or the training type of programs. And so the idea is that those can't be taken care of home. And so how do they, when they arrive or depart, how do they get here? And so For those, the fact that we're only looking at 20, most, in all cases, and I've discussed this with HASC Center, how is this currently handled? And usually, on almost all cases, you have a driver, you have a caregiver, you have the patient. So the driver drops off, and in that case, it could either be a paratransit, New York City vehicle, sponsored vehicle, it would be, or could be a private car where the caregiver drops off the patient and then they're stewarded into the building by a handler from HASC Center. And those are the reason why we didn't propose, which I have proposed this recommendation of a shuttle if somebody needed to park. And so I wanted to discuss this option because certainly there's a few patrons that we need to consider ourselves with, and how do we deal with family members, or caregivers coming in the middle of the day, which is it's now to provide, say, an all-day, shuttle it's overkill. What we are recommending is to do a valet. And upon the schedule, if somebody had the need where, they're driving their child, and these people are all family, they have enduring relationships with the HASC, is that they would have a valet go and park their car and then bring back, particularly if their caregiver is staying for an extended period of time. Rather than running a shuttle all day, for what amounts to, 20 individuals throughout the whole day, that kind of assigning and placing that person is more difficult. And I also think a valet service is probably even better. And then, so we're discussing that, that is the way that we would like to approach this, and that's the way they've handled it at other locations. Let me see some of the other questions. One of these questions is, this notion, is this similar to a school? Right, that was one of the questions. And it's similar to a school, but it's unique, right? The difference here is you don't have students walking from neighborhoods, right? You don't have them crossing crosswalks. But the zone around the school needs to be treated like a school, like a K through 3. And that's the idea, is that the zone around the school, when the minivans and the vans arrive, in the morning period for the day hab, is that would be a controlled operation, as it currently, is handled when multiple parties come at once. It's like, I've visited some of the HASC centers, there are people out to greet you, arrive with you, make sure you get into the facility safely. If you have a wheelchair, that you're accommodated. So that is part of the expertise of how HASC handles its business and how they would continue to do so in the future. So I'm not sure if I missed anything. I think the other, I guess the last concern, was in terms of staff parking, and of course, so I personally, this is one of the few jobs, I toured this area morning and night, looked at parking, acknowledged in the report that it's very constrained, even though there's a bunch of on-street parking throughout the area, identified a nominal amount, which meets the zoning threshold, but doesn't meet what I identified, what I felt was the conservative demand threshold. And then we looked at other parking options locally. There's a wholesale place, the large parking field next door that's underutilized. And they said, absolutely, we could have you here, but they're not willing to sign a regulatory agreement and tie you up. So there's 2 public commercial parking operations. They would be happy to have the personnel here, utilize them to have a degree. But one of the things that I note in the analysis.
Those are the ones that are a mile away, almost a mile away.
Right, 3/4 and one is a mile, and acknowledge it's a long hoof, and I was quite surprised that there's really nothing else available. But one of the things, so we did a survey, we didn't use it here because we thought it was inordinately low. I think the intent is to, give you really a reasonable conservative assessment. People are going to drive here, even though it's right next to a train station. There's 2 other train stations. If you wanted to locate and centralize your operation for workers, there's tons of bus routes. This is a great spot. And I think we want to engender people taking public transit, and walking. However, we have identified these 2 options. I think we're willing to entertain what the board has to say on that matter. But, the parking is available, and we're talking about staff and not about patrons. So I feel, it's right at that edge of, 15-minute walk, which, is extensive. It's a hike.
Yeah,
Right.
especially in February.
Well, one of them is a hike. Yeah, the other one is not so bad.
A mile is a hike. Right. So, I mean, it's good for you, it'll get your 10,000 steps, et cetera, but it's.
Well, in one way, I look at it, first of all, it's a very, to me, it's a very positive thing, because it lessens the impact at the site, you know? I mean, it is a hardship, you know, it's New York City, you know, people can deal with this, and we're trying to engender healthier walking cultures. Having said that, you know, Haas Center loves their employees. We discussed as the team, we can use one of those shuttles prior, you know, they have, you know, like literally a whole parking lot full of these shuttles they use to bus, you know, their patients. And that certainly would be something that they could do during the arrival and departure hours, is help their employees out who don't want to, you know, make that hoof. I certainly wouldn't want to do it. I could probably benefit from it.
Yeah.
But yeah, so we discussed that, and I think you know, that was one of your recommendations, and I think we take that to heart, you know, to assist in solving the parking dilemma.
Okay, so to make it, because we learned that there are these training programs, for example, for the people who are in the group homes who come at
Right.
certain times for training, we need to understand better about these different types of staff arrivals, and when and how they would come, et cetera. Some of them might come, for instance, the ones from the group home, I'm not sure, might be coming in one of the minivans with their participant, but I don't really
I think
understand
so.
that. If we could break that down a little bit better.
I think we could organize a generalized approach to this that answers your question, but that's such a detailed component, right? Until you're sort of operational and it's weighted into a little bit more detail to put together like a detailed programmatic for that. But I definitely think we can put in like a policy, like, you know, if people can be brought together, you know, and assisted in their transit to the
Mr.
location.
Khan knows his program.
Exactly,
so
better than
I think
anybody.
it's really
Yeah.
better that you work together and he can
address
sort of
that.
test the reality of how many, you know, if it's only a few people who are arriving and are inconvenienced, it's different than if it's 50 staff members who are wandering around wondering what to do in their cars, right? Driving around
Absolutely.
the block.
Yeah, I mean, that's I think the major concern is, having, you know, one of Hask's other locations has no parking, and then until I was informed, oh, there's a Hask parking lot X over here, you know, I drove around a very similar location, drove around the neighborhood, and that's the thing that, you know, causes issues and drives employees nuts. And so, yes, to our ability to respond to that effectively, you know, we'll
And then the other question that I have is in terms of when we look at the drawings, there's something called these caseworker locations where I don't know if that means a person who's in the community hab or somebody who might join the day hab meets initially with a caseworker, and so those people are new to the program. How are they getting there? Where do they park? That kind of thing. That's different than the people who already are participants in the program and have a routine. Right, so that's another.
So to address that that's the same issue you'd have at the opening of any new community facility, right? You have a new school, people need to be oriented. The patients here particularly would need to be oriented. You need to build a process and a regimen, but for the most part, these are people that are already using Hask services, have been in the program, have people, you know, and that's one of the reasons for all the space is, you know, they acclimate them to the area, they need space to breathe, but they have a caregiver and a case handler that they know every day that can help with this transition. And, I think definitely the transition period will require a lot of effort from Hask, but I think a lot of this stuff gets blended out from operational experience and that sort of thing, and it's very hard to sort of predict. You know, everybody who's coming to this new facility from Hask is going to go through growing pains, you know,
Right, but my understanding is the current facilities are handling X number of people right now. And this new facility is intended to welcome new people who are not part of the program. So those people would end up coming for the very first time to any Hask center. No, it's not the case, but, and anyway, would need to meet with a caseworker and drive there for the first time to be introduced to the program and decide which is the best one for them and all that stuff. So that's That is people arriving, need to park and all that, and we don't need to get into any more detail, but these are the
You'd like
issues
that, just to have an
Yeah.
answer, and I can imagine it, and I won't take up more of your time, but I appreciate the detailed concern.
Okay, did I leave anything out? Anything else? No? Okay, schedule, are there any speakers on this? Because we didn't actually finally get public, okay. Schedule.
June 26th submission date with July 16 hearing?
July 16, where we have variance? 9, 2 variances. Yeah, just 2?
Yeah, there are no variances already on the calendar.
Okay, yeah, that's fine.
Okay, so your next hearing will be July 16th, submission date of June 26th.
Okay, thank you.
Nice when they come up with their own hearing dates, right?
July 16th, submission date of June 26th.
I think we take a break.
Yes.
You want a 5-minute break?
Yes, please.
5-minute break.
June 26th.
Boy. Okay. Okay, we're back on the record. Item number 23, 2018-117BZ, 2060 63rd Street, Brooklyn. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board questions? Okay, thank you.
Thank you.
Elise Bolzer from American Planning PC. These were submitted last night.
I saw them.
But I've highlighted for you all the items that were added.
Thank you.
This is a regular set or a bubble set?
It was too quick turnaround to also get a little, so I didn't. So I highlighted.
This is the set.
Yeah, things weren't taken off, things were only added.
Okay, so this is the one to, should we grant it, we approve it, we vote it, or whatever. Just want to make sure.
I apologize for not having a bubble set. But we added to the almost every page removal of more than 50% of existing walls and or more than 50% of existing floor joists in excess of that shown on BSA approved floor plans will avoid this special permit.
There you go.
So it's clear, it's the biggest words on almost every single page.
Good.
We also, the architect understood that the legend was kind of unclear, so he made it a darker hatching color to match
Okay,
the legend.
let me just make sure.
And he also added, to make it clear on a bunch of the plans, existing first floor joists to remain, existing second floor joists to be raised,
Excellent, thank you.
and third floor joist to be replaced because it's attic.
Okay, good, thank you, appreciate it. All right, I forget whether I asked if there were speakers. No? So then I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right.
And a motion to grant on condition, the condition being the usual removal of existing exterior walls and joists in excess of those shown on the plans will void the special permit.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right.
Thank you so much.
Granted.
Oh, yeah.
Didn't she have a second call?
She has a second call.
Yeah.
Item number 10, second call, 20803BZ, 2555 Shell Road, Brooklyn.
Elise Bolzer again from American Palatnik PC. We had a lease drafted. It's a little liney, sorry.
A little liney, but.
There's just a lot of lines. Because it's where the blanks were filled in.
They're not really blanks. Because you used a standard
Yeah.
piece you found online.
Yeah, and but it has added for 80 parking spaces located at 2569 Shell Road, so that part is specific. And it also has to continue in perpetuity or until the catering hall use is ceased. So that part isn't, and then he signed the document.
It's not notarized.
Does it need to
Supposed to
be?
be between the LLCs, actually. What'd you say?
It's not notarized.
Do you want me to call?
Not notarized. And in addition to which, it really shouldn't be signed by the lessor as an individual, now that we didn't notice it was not notarized. So there's one LLC.
Yeah.
Renting to another LLC.
Yeah.
And it could be that Mr. Jamal is the managing member of both of them, and it ends up being his signature on both, but it's
Yeah.
supposed to be between the two corporate entities.
So
not
we
an
should write the
individual.
bottom,
Yeah, nice try, but,
We have
And it
space
violates
next
the rule
week.
against perpetuity.
yeah, we do have space.
okay, so next week we'll put his name, we'll add to,
It violates the rule against perpetuity.
It violates the rule against perpetuities.
What?
Leasing the hotel.
Please.
In that it's not,
You need to set 99 years, and that would resolve it.
I didn't see the.
oh, 99
It
years.
says 99 years. It's supposed to be for the term.
I thought it was more than 7
Oh, it says in continue in perpetuity.
Say
No,
two?
it just doesn't have to say in perpetuity, it just says until the use, the catering hall use is.
We'll take that part out.
That
Cease.
arguably,
Well, so
Okay.
if it ceases in 100 years, that's a different thing, but we won't have to
so
worry
if,
about
since
that
the
now.
contract reads that, since a contract can, if a contract can read that, it allegedly never will cease as that.
No,
that
not
catering-
never, at the end of this catering hall. In 98 years, there won't be such a thing as a catering hall. And by the way, it's actually a banquet hall.
We'll change the words to banquet hall, because we have to change it up. We'll take away perpetuity, and we'll write the LLCs on the bottom.
Yes.
And that he's the managing member.
He's a managing member of the different LLCs, right? Right.
Okay.
So, all right, so we're changing the LLC?
It was a nice rapid try, that's what happens.
Changing
when
the
you try.
LLC.
It's just
and
really very
notarizing.
quick.
Yeah, I understand.
Great.
Changing
Thank
something
you for
loud.
trying.
Yeah, great attempt.
Okay, so this is on for May
We always know
7th?
you try.
No, I was suggesting that it go on for next week, because we have 7 adjournments, and the only thing, or 6 adjournments, and the only thing we have is a
On
lease.
second try, we can get it right.
Yes, you'll
That
have
was
time
my
to think
suggestion.
about it,
Yeah.
remember the
5,
rules,
5.
all that stuff, right, okay, good.
So what date?
So, can you submit by Friday?
Yes. If I can submit by today, I can submit by Friday.
Great. So then it'll be on for continued next week on April 30th.
Okay, thank you, and we'll be here anyways.
Great,
Thank you, perfect. Thanks, Elise. All right.
Okay, let's go. Oops, that's my calendar. New cases on the zoning calendar. Item number 1, 2017-265BZ, 318T20, 54th Street, also known as 5401 3rd Avenue, Brooklyn. Okay, raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions? Okay, please sign in and proceed. Has to be on this one.
Go through one of those
yeah, just a second,
chelation therapy programs. Please state your name.
Good afternoon, almost evening, Chair Perlmutter and Commissioners. My name is Emily Simons, and I am with the Law Office of Emily Simons, PLLC, and
I just want to say something before you go on, just to clarify what are the parameters of our review are. So we are not considering at all the other variance that has to do with the billboard, right? We're just here to look at whether we're continuing the use or permitting the continuation of a commercial use at this site, which happens to be this Venetian blind store. And that's it. And what happens to the billboard is not before us, okay? Okay, go on.
okay. I represent LDR Realty Corporation, who is the owner of the premises located at 318-320 3rd Avenue, also known as 5401 54th Street in Brooklyn, in the Sunset Park neighborhood of Brooklyn. It's located currently in an R6B zone. It is a 100 by 100 square foot full lot coverage corner building that is basically a manufacturing use pursuant to variances that go back prior to the go back to the 1916 zoning resolution. So there are a couple of moving parts in approvals for these variances, but I'll start.
Yeah, so we're here for 2017-265BZ,
Yes.
right? That's all we're here for, right?
226-81BZ. Isn't it?
2017-265BZ. That's the one where you're asking for a reinstatement of a
Oh, I'm sorry.
previously approved variance to permit the storage, warehousing, office, and showroom, use group 16B, and assembly of
yes.
Venetian blinds, use group 17, which expired in 91, so you need to reinstate the variance, and that's why you're here.
Yes.
So, did you attend the review session?
Yes, I did.
So can you just focus on the questions that were presented
Yes.
at the review session?
Okay. The first question came from the chair, and she was concerned with the signage. And I went back.
Signage on the building itself.
The signage on the building itself, yes. On the front, there's, the building obviously has two frontages, one on 3rd, one on 54th. All the signage is on 3rd Avenue. There are currently 3 signs on the premises on the front. There are 2 small signs that are illuminated. There is 1 large sign above the door that is non-illuminated. The chair was concerned about, primarily initially, the fact of a sign exceeding the height of the roof. Okay. Pursuant to zoning resolution 32-656, no sign displayed from a wall of a building shall extend above the parapet wall or roof of a building, except that a vertical sign, the horizontal width of which, parallel to the wall, does not exceed 28 inches, may extend no higher than 15 feet above the roof level. Okay, so there are the 2 vertical signs that are 17.5 square.
Sorry, you read that and it applies to a C1 zoning district?
Yes, it does. It applies in the C1 zoning district. Yes, it does.
We're just checking ourselves so we can follow along.
Okay. I'm cool with that.
Can you repeat the citation to the zoning resolution?
Sure. It's 32656.
32656, thank you.
Find it?
Height of signs above roof, 32656.
Yeah, I know I have it there. 32656. Okay.
Okay.
In the districts, no sign displayed from the wall of a building or shall extend above the parapet wall or roof, except that a vertical sign, horizontal width of which parallel to the wall does not exceed 28 inches, one of which does exceed 28 inches, may extend no higher than 15 feet. So when we look at the photograph,
Okay, I'm sorry. The photographs, I have to say, the photographs are out of date, and they are not, the photograph, I think it's 5, 6, and 7 are out of date. There were plans that were submitted with the notice of comments that show the actual state of the signage on the building today. There are only 3 signs.
one is 1'8" or something like that. It's really hard to see. 1'8" wide or something like that. I don't know.
Right, 20 inches wide.
And then the other one, though, is 14 foot 8 inches wide.
Right, there are
standing
two-
above the roof line.
I'm sorry, there are two that are the 20-inch wide ones. There's on both sides.
And the one in the middle.
And the one in the middle is oversized.
Yes.
Okay.
What do we do about that?
Yes. What we're going to do about that, I've talked with my client, and number one, he's going to remove it from where it is, and he's going to place it on the wall of the building, the front wall of the building, not above the door. So it will not, it will be well below the roof. So,
Okay, so that's the first question.
Mm-hmm.
I'm not looking at the photos, I'm looking at a Google
Mm-hmm.
truck, advertising Google again, one of the truck views, which is a recent view, and it's showing on that frontage, 1, 2, 3, 4, 5, 6 signs on that frontage. 2 of those signs do not, 3 of those signs do not show up on the elevation that was provided to us.
okay, my client removed, I don't know what you're looking at on Google, I must say, I'm sorry. My client removed all but the 3 signs. And I am under oath, so.
Yeah, so we need a photograph, no
Yes.
offense, but we need a photograph.
Yes, I understand.
To indicate that, okay?
A photograph of the existing signage, okay. So, given that there are 3 signs, 2 which comply with, okay, there are 2 signs that are, each measure 20 inches, 1 foot 8 inches in width, and extend 10 inches above the roof level. These signs comply with the C1 district regulations governing height of signs above roof level. The sign in the middle, that I believe is approximately, it's 14.8 by 9, does not obviously comply with this regulation. That sign will be removed from above, the doorway is below there, above the doorway, and will be put probably if you're looking at it, to the left of the doorway on the facade of the building. So it will be, no longer will extend above the roof.
Good,
okay. In addition, there is one other issue. This sign is 135, the large sign is 135 square feet. The 2 signs, the 2 vertical signs that are permitted are 35 square feet. That equals 170 square feet. In a C1 district, on the corner, you may have only 150, maximum 150 square feet of signage per frontage. Okay? Obviously, 135 and 35 is 170, and that is 20 feet over what is permitted. Spoken with my client, and the new sign that will go to the left of the door will be reduced to 115 feet. So when added with the 35, will equal the requisite 150 feet.
Okay, good. Okay.
And I spoke with him, and he's perfectly amenable to these, obviously, Canterbury
Needs to be
zoning.
amenable because that's the law.
Because that's the law, right. He has to comply with the law, yes.
All right, I think the zoning, the mezzanine issue.
Yes, okay. Now, unlike you, I don't have 2 degrees, I only have 1. And so I have brought my architect with me, who is here, Mr. Colin Cathcart, and he's going to explain, I think, Commissioner Commissioner Shanda was concerned with perhaps the mezzanines now being excessive in comparison with what was shown on the prior plans. And so Mr. Cathcart is going to explain.
I think the issue is, this is a pre-61 variance, and you're not allowed to increase the size of the...
We're not allowed to increase the size of the zoning lot.
No, the use
Or
either...
the floor area of the use that existed, the date that the zoning resolution came into effect. It's 11, it's Article 1, Chapter 1.
Yeah, 11-4-13 or something like that?
Right. No, I understand that. You need to ask for a different kind of, you actually could, but you need to ask for a different kind of request.
No, you'd have to come back for a new variance.
Yes, okay, which is not, would not be.
I don't think your client wants to do
No,
that.
I don't want to do that.
Pursuant to 11-4-12, you are limited, so the use of any building shall not be extended, and the building or other structure shall not be enlarged in excess of 50% of the floor area of such building occupied or utilized by the use on December 15th, 1961.
But this is.
So it could be, you can do it, I believe, but.
Sorry, there was a change of use?
No, there's no change of use.
Wait a second.
Well, there were changes of use.
Maybe change to a conforming use, and in appropriate cases, the authorizing to be changed to another non-conforming use, which would be permitted, relating to the, provided that the authorizing agent, in permitting a change to another non-conforming use, sorry for the change of use, I thought Carlos said you can't, rats. Now this is a Carlo phenomenon. Okay, so for the moment, because we don't have our 11-4-1 expert in the room with us, unfortunately.
May I say something?
Yeah.
Okay. 11-4, it gets a little convoluted, but 11-4-1, the one thing that it does absolutely require is that the zoning lot on which is not enlarged. Okay, that's fine. So, that is, I know Carlos is out today. And he told me he would be.
So what I would like to do is therefore for you, so that because we're doing this in a hearing, for you to talk to staff to clarify what the parameters are of 11-4-1 on the allowability of expanding the use compared to what it was in 1961. Because our conversation yesterday was something to the effect of the mezzanine expansion is not allowed. And it's possible that it already used up its allowable expansion compared to the original grant, which is what you compare it to, right? You don't compare it to the last time, you compare it to the first time, right? So
you mean I have to go back to 1956?
You would have to go back to what the pre-61 determination, whatever is the pre-61 determination, to see how much floor area was in the building. That's the way I understand it. And then the proposed mezzanine couldn't exceed that 50%, right? That's the way I understand it, but an acceptance provided and no structural shall be authorized for a new non-conforming use. And that's the other thing is it says no structural alterations, extensions, or enlargements, which is what that is, shall be authorized for a new non-conforming use authorized under 11-413, which is a change of use.
Yes, right.
So that's the problem right there. So it's not that the Venetian blind store has changed use, because it hasn't, right? But the potato chip store was the original use that was granted the change of use, and then a change of use was granted. So it went from whatever the potato chip use was.
To a wine bottling.
To wine bottling, right? So there were changes in use, and that's the problem. That's where you come up against 11-413. Tony's making a face,
I'm
but
sorry.
let me go
So
through
it's the
this
same-
again.
It's the same use group.
No, so it was a change, it says in the text.
16B to 17?
Yeah.
It went,
okay.
Well, 1981 amendment went from, 16 to 17.
No, there was,
So the 1957 variance was from garage to wine bottling.
Right.
CO issued in 1958 and 1971. Then it was amended in 1981 for the warehouse Venetian blind assembly.
And storage.
And storage, which is different than wine bottling.
well, the 67 amendment was also approved, and the 71 amendment, I believe.
Was the same, was a wine bottling.
No, they actually, they actually increased. In the 71 amendment, they added warehouse and storage, and there were issues about the mezzanine.
Right.
I think they changed plans.
Amended the use change to storage, warehouse, and office. And it required a new CO.
Right, there are 1, 2, 3, 4, there are COs for every single one of these.
I'm not suggesting that there aren't COs. The issue has to do with compliance with section 11.413, which does not allow enlargements where you've got a change in use, and where they're talking about the change in use is with respect to 11.412, right? The use of any building shall not be enlarged, no, sorry. Sorry. Opposite?
12?
413 is change of use. It says at the end, for the purposes of this section, a change of use is a change to another use listed in the same or any other use group.
There you go.
The change in ownership or occupancy shall not by itself constitute a change of use.
Okay, I understand that.
But then the prohibition was from 11.412.
412,
Where
that-
the end of it.
For the end of it, that says, no structural alterations or enlargements shall be authorized for a new nonconforming use authorized under 11.413, right? So in terms of the history of the site, and that's why I suggest that you speak to Carlo specifically about this, in terms of the history of the site, if it seems as if, based on what our documents, and I don't have the COOs piled in front of me here, that there was a change in use in this, maybe arguably in the same use group, not sure, but then that hits into 11.413, and then you go back to 412, and that prohibits the enlargement. So maybe sorry.
May I say one thing?
Yeah, sure.
I do believe that one of the variances that we have allowed for, if I may, I just want to say this. Sorry. And I know you're all tired, and you're probably sick of me, but, why don't I have that? If you'll bear with me for 1 minute, please.
Sure, I'm just, while you're doing that, we're looking at the C of O. So July 30th, 1982, C of O was the Venetian blind use group 17 plus use group 16. And I don't know if we have earlier than that. So that's only 82, I guess.
I don't have all the 82.
Yeah, I don't see.
Where are the other minutes?
Because you were just proving continuous use, basically. So you didn't give us the Cs of O for the prior uses. Yeah, I just don't find it. Oh, in the response to comments. Oh, okay.
All the other CBOs were in there.
Okay, just a second, I'll look.
And the reason I bring this up is because, okay, there was,
I only see 2 COs.
You see 2?
I only see one, the latest one.
The one.
okay, in 1971, and this is just, in the variance that was approved in 5471, it says that reopen and amend the resolution adopted by adding that this variance shall continue for a term of 10 years from the date of this amended resolution, and that the building may be altered, rearranged, and used substantially as shown on revised drawings of proposed conditions marked received April 23rd, 1971, 2 sheets, on condition that other than that as herein amended, the resolution above cited shall be complied with in all respects. So in 1971, the building was altered, rearranged, and rearranged and approved.
Can I see a copy of that resolution? Do you mind?
Yeah, sure.
I just wanted to see what the application was for.
So there's, and if we look at Mr. Weinberg's drawings from, when was this? 81. Yeah, I guess 81. It shows a mezzanine that's 19 feet deep. 19 by not very much. So I don't know whether we're talking about a bigger mezzanine. Yeah, please. Please tell us what mezzanine we're talking about.
Okay, I'm gonna clear out.
No, you don't have to clear out, it's just to answer a quick question.
Colin Cathcart, Principal, Kitchen Cathcart Architects, 44 Court Street, just down the block from Weinberg and Kirschenbaum Engineers from, I think this is the 80s. Yeah, if you look at his drawing, there's a mezzanine across the front, okay? It looks like it says storage above and one, this was likely built as 2 garages rather than 1. And it looks like there is storage going across the front.
Only half.
The 54th Street facade of the building. Deep, we don't really know. It could be 19 or 20 feet deep. It's hard to tell from this drawing. There was also a storage mezzanine that was, under this application, going to be removed, okay, at the back of the building from the streets.
Sorry, the drawing that you're talking about, I'm just looking at a drawing, that drawing from 81, right?
81?
1980, March 27, 1981, which is referred to in the BSA's resolution, which points to a mezzanine above.
Right.
I don't think there's actually a floor plan of the mezzanine itself. And it says, if you just look at the dimensions there, it's 19 foot 7 deep, and it's only the width of half the building, so whatever that is. It's 20 plus 16 plus 11, so 30, maybe that's 50, is that what you're saying?
Yeah, there's no
That's 50.
dotted. Yeah,
No. You don't need to see the dotted above. It just points to enclosed mezzanine above, and you can see that it's sitting on top of what was then in 81, the kitchen, offices, and a little entry area.
Right.
And then when you go to the next drawing, you can see, that's actually kind of hard to figure out where we are, but there's that mezzanine, it says mezzanine removed. So I'm
Yeah,
not
at the
even
back
sure
of the
what that's
building,
about, at
mezzanine
the
room.
back.
Right.
Right, and so if anything, there was a mezzanine that was 19 by 50. That's
Yes.
19.7 by 50.
There is also evidence at the building site and also on the first drawing that you're looking at, enclosed mezzanine above, that there was a mezzanine or something like a mezzanine storage above with a couple of indicator lines, quite vague in terms of the depth of that storage above and whether it was a mezzanine or an open mezzanine or an enclosed storage box or accessed by ladder or what, we don't know.
But that could have just been the roof of the little storage area. It's not
Could be
really
the roof of
mezzanine.
a box room that is
Yeah.
just
But
piled high with boxes.
if anything, that's 16 by unknown little dimension, like 8, right?
Yeah.
So we're not talking about really anything. because it's
We're
16
not,
by 8,
we're
right?
not talking about a lot of mezzanine space, no.
So,
So if you can turn to my drawing, drawing A4, first floor high plan, okay? And look at that in sort of,
that context, it's a lot more than 50 by 19, or it's actually, not even sure if it's dimensioned. It says 39 by 46 foot 9.
right, if you look at the designation of that space, though, and the sort of fainter lines, you'll see that it says storage racking. It's not a mezzanine. It's not all a mezzanine. And storage racking is also in the area where the old mezzanine was removed in 1981. If you look at then the ground floor plan, the first floor plan, A3, you'll see the sort of outline of that racking.
So before you go on, I have no idea which way is up on this drawing, because you don't label.
This is a real problem.
Yeah.
In fact, and it comes from this as well. This is 3rd Avenue, and this is 54th, I guess, Street? Is it 54th or 56th? And basically, north is down.
No,
okay?
I'm talking about your drawings.
Oh, okay.
You don't label the streets.
No, I don't have streets on this. They're on the site plan, but they're not on the floor plan.
You don't see the streets on the floor plan.
I know,
Because I don't
it
know
makes it
which way
hard.
the site plan is facing relative to your orthogonally drawn floor plans,
I know,
right?
I know. All I can say is that it's the same we preserved the orientation so that it matched the old.
Okay.
You know,
Okay,
and
please
maybe
put the streets
that's
on
wrong.
your first
okay,
floor
but,
plan.
You know,
So it seems the storage rack is fronting on 3rd Avenue.
the old mezzanine, okay, if we don't know the extent of it, okay, completely, but it seems to be that the mezzanine that was removed and the mezzanine that was indicated to stay, and remember, enclosed is not a good idea. You're supposed to be open. But those two mezzanines are along the 3rd Avenue side, okay? And with the important note that this is towards the Verrazzano, okay? And this is
Right.
towards the Brooklyn Bridge.
Let's talk about your plans, okay? The drawings, the existing drawings, the approved drawings show a mezzanine that's 19 by 50, simple, right? At the
The
bottom
old-
of the building, which
Yeah.
is 3rd Avenue, right? And
Right.
I don't know if it's a mezzanine, but that little bitty box of 16 by 8 or something like that on the left side, right? So on the right side, 19 by 50, and on the left side, 16 by 8 or something like that, right?
Right.
That's
Right.
it. Your drawings are showing, hard to understand, which is mezzanine and which isn't, but it looks like you've got a mezzanine in a place that you didn't have before, and maybe no mezzanine in the place where there was a mezzanine, unless you've turned your floor plans around, but I can't tell.
In 1957, the board granted an application that was an appeal from a decision of the borough superintendent regarding egress. And it states that there's a mezzanine with an area of only 360 square feet and its occupancy only 2 people. And this application was granted on condition that the second floor referred to, actually a mezzanine, shall not be extended in area, that the existing means of reaching the first floor from such mezzanine shall be maintained in accordance with plans showing such conditions as filed with calendar number 539-56 BC. So it appears that in 1957, that the mezzanine had an area of 360 square feet.
Right, and then it was enlarged, because if I just did the math on 360, that's only a 7-foot deep mezzanine, and we have a 19-foot deep mezzanine. So sometime between that and Mr. Weinberg's submission in 81, the mezzanine increased to 19 feet.
It looks like it was at 70.
You'd need to come to the mic.
If you speak, you must be at a...
It looks like there was some changes in the 71 variance that I gave you. There seems to be some rearrangement, et cetera.
But it doesn't really matter. We're looking at the most recently approved one, which seems to be the only drawing we have, the 81 set,
Right,
right?
right.
The 81 set shows a mezzanine, which the board allowed, so I'm not going to go back to whether the board should have or couldn't have or
Okay,
whatever. But in 1981, the board allowed a mezzanine, just to be very direct, that was 19.7 by 50 feet. And that's it, right? And whether you can, I don't know even that you can move it under the terms of 11.3.
Right, you said
to 412, because it says no reconstruction.
Yeah, no, we just-
da-da-da-da.
Yeah, we,
Right?
just, we don't want to be confused. What you were talking about was a mezzanine that was in 1957?
So-
Okay, and
No,
now what we're looking
right.
at here is a mezzanine in 1981.
Correct.
Right.
So it sounds like the owner didn't listen to whatever the instruction was in 1957 to maintain the 360 square feet.
No, they just had a variance case.
But they had another
Something changed
variance
their
case,
conditions,
right?
yeah.
And the new okay, right? And so it doesn't really, so in 1981, the board approved this 19-foot-7 by 50-foot mezzanine, that's it. Basta così, right? That's what you get, right? So you're not allowed to extend, enlarge, what's the other words? Alter, it says alter the size of that mezzanine, that's the issue.
But you said you didn't.
Yeah, no, this is, we drew what we saw there. We didn't actually go from Mr. Weinberg's plan.
Right.
This is what you see.
You're drawing in an
This plan
existing
is what we
condition.
meant.
Unfortunately, the existing condition is not allowed according to the terms of, according to rules that
Yeah,
are
no,
our jurisdiction.
I'm not
Okay.
saying that there's more than the square footage that you mentioned.
The drawings are showing more.
No, it's showing
So
the extent, they have an awful lot of racking. This is a 15 or 16 foot high.
Sorry.
So the racking goes from floor to ceiling. And they have windows and blinds and doors.
Okay, so that is
you can pile things double high. So that's what I'm referring to when you see at that high level plan, storage racking, you're seeing the top shelves
So
that
here
are
we go.
7 foot high.
You need to take off of these drawings furnishings. Furnishings and fixtures out, because furnishings and fixtures are not floor area. The only thing that we're interested is the floor. The thing that creates floor area. That will help us.
Are you sure? Because some of these racks go from floor to ceiling.
Furnishings
They
and
could-
fixtures, they're movable, right? Right. They're temporary.
Well, these are stud
Yeah, but don't
frames.
talk yourself out of your own client's project. I'm
Okay.
just telling you, it's a shelving system.
We're going by way floor area is defined in the
Right?
zoning resolution. So.
Okay, so I appreciate your honesty. It's a very valued characteristic. However, we do not look at shelving systems when we're looking at floor area, okay? So that might mean you don't even have a section through this level, because and when I say section, a horizontal section, which is showing walls, right? Demising walls which exist on the floor below, right?
Yeah. We'll fix
So-
it. We'll get we'll fix these drawings and we'll show the actual extent of mezzanine. We won't call it
if there
storage
is one.
racking, we'll call it mezzanine, and we'll
Okay.
just, where we have high racking, it'll just be open to below.
Good. If a guy can come with a ratchet wrench and take it out, don't count.
Battery operated,
Okay?
screwdriver.
Yes. Exactly. There we go. Okay?
Excuse me, may I?
Come to the mic.
You need to speak at the mic.
I'm so sorry.
That's okay.
Excuse me, so I just want to clarify for myself what I have to talk to Mr. Cathcart is going to revise the drawings to show the actual existing mezzanine as it exists today, right?
If there is a mezzanine.
If there is a mezzanine and the dimensions.
Yes.
And that, hopefully, that they match Mr. Weinberg's drawing, the mezzanine that Mr. Weinberg has indicated, right?
Or there's no mezzanine.
Either there's no mezzanine, or there is a mezzanine that matches.
Right.
Okay, so there's one of two things, or a mezzanine that matches Mr. Weinberg's, which is what we actually, which is actually what we would like to see here, is that the
Well,
plans.
if you want to put back, no, you can't. So if it's out, it's gone. It's gone. And if it's in, excellent. but-
Okay.
Right.
Okay, that's what I'm asking. That's what I'm asking.
So,
Okay.
reread those sections, 411, 412, and 413, because that will give you the instruction about what we have the authority to allow on these old variances, right? These are the pre-61 variants.
May I ask you a question? If the mezzanine matches Mr. Weinberg's mezzanine, that's what is permissible, right?
Right, but if you took it down, that's
If it
the
took
end
it
of that
down,
story.
took it down, no good.
Yes.
NG. So if there's no mezzanine, we have a problem. If we do have a mezzanine that matches Mr. Weinberg's mezzanine, we're okay.
Correct.
You only have a problem insofar as you've abandoned that mezzanine. It's fine, your application here is not impacted by the disappearance of the mezzanine. Just wanted to clarify.
Right,
that.
right, exactly. It doesn't affect whether you can use this as a Venetian blind
Yes.
store, or whatever it is, warehouse. It has an effect on whether you get that additional floor area that equals the mezzanine. Understood?
Yes, yes, which I think my client needs.
Okay.
Okay?
Can I ask a question? On, this.
Can you go to the mic, please, Mr. Cathcart?
This was measured by a couple of interns, and on my A4 high plan, there's a line that seems, it's indicated at 8'8", and it looks like maybe it's a mezzanine, and it looks like maybe it's not exactly where Mr. Weinberg's mezzanine was. If we have the same square footage that Mr. Weinberg had, but it's in another place, does that
It
work?
means it was reconstructed, right?
Sorry?
It means it was reconstructed, which it's not allowed to be,
Okay,
right?
all right.
I would suggest, depending on the skill set of your interns, someone with a little more skills, go back and check this, because your client really needs it. That would be you. I'm-
He really needs the mezzanine. He really needs the
Yeah,
mezzanine.
so much for beginners.
Yeah. Okay, so
Okay.
you would like a photograph of the existing signs,
Yes,
and we would like the the new drawing, right? When I come back.
and please put streets on your site, on your floor plans.
And what, and put streets,
Label the
Arrows and
streets
street
on
labels,
your
yes.
floor plan.
labels
Absolutely.
and streets on floor plan.
And
Okay.
I had noticed barbed wires along the roof line abutting the residential, so that needs to be removed.
There's barbed wire on the roof of the
Yeah,
building?
on the interior lot line.
Oh, we don't allow barbed wire.
There's barbed wire? We have to remove that.
Yes.
Yes,
Yeah.
okay. All right.
Okay, so how much time would you need to submit? I can volunteer a date if that would be helpful.
I don't think we'll need that much time. I mean, a photograph and,
Give us a couple months.
no, we can't take it a couple of months.
How about a month?
What, a month?
1 month.
1 month is fine.
Great. So that would be a continued hearing effectively June 11th? June 11th with a submission May 22nd.
May 22nd.
For submission, yes.
Okay, with the hearing on June 11th.
June 11th, yes.
Thank you.
Thank you. Yes, of course.
Take care.
Item number 2, 2018-34BZ, 10202 Metropolitan Avenue, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I affirm.
You can stand at the podium
I
while
think
you
we'll
do
go
it
back
each
and
time.
forth. Makes more sense.
These will be fast, I promise. Good evening, Todd Dale for the applicant. So for this particular application, we heard the comments from review session, and we agree with all of them. And we are going to use that to work with this engineer who is new to the BSA to impress upon them the need to revise the plans with the information required. But it's very clear that it was listed, and we agree with all those changes, and this will help in our efforts to get that done. We did receive the fire department letter, and we'll also address those comments that were included. I think a lot of them go hand in hand with the questions that the board raised. But we'll get all that information, but yes, we concur.
Okay.
How much time? Oh,
Oh, no speakers, see, oh, maybe the fire department. Do you want to speak on this one? They already know your comments. Okay.
You asked to reach out to the community board, I think.
Yes.
Yes, so, but that's what we're going to do.
She called.
We called. Oh, you called? Oh, I'm sorry, I didn't hear that part.
But we didn't
Okay.
chat in email, they just verbally told me they have no issues.
They told you verbally they have no issues.
Yes.
That's what they've done for us as well, so I'm glad that that was back.
Okay.
Timeframe, I would like to request a little bit more time because I want to make sure that we can work with this architect. We can be flexible with the board's schedule. I would say I would want at least 7 weeks to submit. But that could,
So that's, I guess, 2 months generally, 8 weeks, June, late June submission. How about July 16th with a submission date of June 26th?
sure, I'm here for all other things.
And if you wouldn't mind, please, before the drawings are submitted, since you know what good drawings are supposed to look like, if you would please look at the drawings before you submit, so you say to the architect, you know what, still not making it.
We will say that again to this
Okay.
particular architect, how's that?
Yeah. So maybe give that architect a very tight deadline from your end, so you have like at least 3 or 4 turnarounds?
No, we agree, we understand, and we think that
Okay.
it'll be easier to get this done now that we have the board weighing in on the issue.
Might even have him or her listen to our video where, to quote Commissioner Sheta, terrible drawings.
Understood. No, I understood.
It wasn't my comment. I wasn't the only one.
I know, and I also said that.
I believe maybe
I fear the board is
maybe
getting.
Todd agrees with me.
We're getting
on that.
punchy,
Next
but I
case,
do
next
want,
case,
I do
next
want
case.
the architect or
No.
engineer to hear our comments, so.
I understand,
do that-
and
do
at
have
times
them.
it's easier when we're working with
Yes.
new architects when we have the boards
Okay.
officially weighing in on comments. How's that?
Understood.
Item number 3, 2018-174BZ, 1440 3rd Avenue, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
I affirm. For this particular application, I believe there was one key issue that was raised at hearing. The sign analysis was, the plans changed, the analysis did not change. A new one was submitted last night to reflect the 42 square feet, so it should match up.
Okay, so we're done. Yeah. Good. Seeing no testimony from anyone, I would
Or
like.
seeing no people in the
No
audience.
people to testify, thank you. I abbreviated that sentence. Therefore, I'd like to make a motion to close.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
All right.
And motion to grant.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
All right.
Item is granted. Item number 4, 2018-182BZ, 22005 Hillside Avenue, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and you respond honestly to board member questions?
I affirm. From review session, I understand that the DOI was outstanding, but I think that that was just received.
DOI we have.
We have,
Okay.
and by the way, it's both blink on this one and on the next one, so DOI is DOI, right? If you think about it.
They're
both blink.
They're both blink. Same property.
Same.
Okay.
Same partner.
The same as it's been
Same
for
partners.
Yes.
years.
Yeah,
Okay. With respect to the 2,500 square feet, just to clarify, it's all Blink operation. That area that's designated physical therapy is just a special area that's set aside for one-on-one training with individuals, but it all falls as part of the same
So massage
operation.
would be provided.
No massage.
No massage.
No massage.
Physical therapy, like the gym I go to, it's like when someone has an injury, sometimes they have a one-on-one
Oh.
time with a trainer to work out
More
elbows
like
or
one-on-one.
feet,
Oh,
as the case may be.
A stretch.
Yes,
Especially with your broken toenail.
exactly.
Okay.
Though we don't want to stretch that.
Sorry, I'm sorry. It's 6 o'clock.
Yes. So again, thank you very much for
Sure.
clarifying the history of the site so that we didn't have to do our own forensics.
Understood.
Saved a ton of time.
Good.
And
Okay.
it's still proposed, is that right? It's not
sorry?
open yet?
Oh, yeah, just to clarify, I actually brought these up if you want to see. I brought one photo. That's what it looks like right now.
Yay, okay.
So it's still under construction. That and then the next one also. They're both still under construction.
Great.
Okay, then, I don't see anybody who would be a speaker unless Jello wants to speak. Okay, so for a motion to close?
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
And a motion to grant.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Okay. Item number 5, 2019-8BZ, 3000 Jerome Avenue, the Bronx. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions?
I affirm.
Good.
But I understand for review session, the only question was whether it was still under construction. It is still under construction. This is the photo. They're actually hoping to open early June, late May, assuming the building is finished.
Yeah, early June, that's in a minute, okay. All right, so, yes, so I don't see anyone who might be a speaker, therefore I'd like to make a motion to close.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
And a motion to grant.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Thank you.
Yay, thank you.
This concludes, sorry, thank you so much.
Thank
You're gonna
you,
sign these?
everyone.
This concludes the public hearing for April 23rd, 2019.